All right. Hello. Good morning, everyone. I'm Cynthia O'Donnell. I'm here to talk about defending debt buyer cases. I'm an attorney in Mount Dora, Florida, and I do a lot of debt defense as well as consumer bankruptcy. Unfortunately, my PowerPoint, the computer my PowerPoint is on is not cooperating, so I'll be doing this PowerPointless, which could be a good thing for you guys because it's not that great of a PowerPoint to begin with. All right, so we're going to talk about first, what is a debt buyer? You may know it's in the news pretty occasionally or pretty regularly. A debt buyer is a company basically that buys purchases portfolios of charged off accounts. They can be anything relating to generally unsecured debt is what we're talking about with regards to debt buyers. So credit cards, medical debt, and then there's some fintech type stuff that is newly being litigated. And it actually is trying to join now with the PowerPoint computer. Okay, so the debt buyer gets little to no documentation on the underlying debts that they buy. They usually just get a spreadsheet with some contact information, maybe the account balance, maybe the date of the last payment, and possibly if the debt's ever been disputed by the consumer. Okay, so I'm on two computers now. Is there a way for us to swap over to the one with the PowerPoint?
It did swap over it did swap something for you, Cynthia. And just before you keep going, I just wanted to, just a couple of housekeeping items for everybody that's attending. We did send in the application for our CLE credit. The bar is taking a little bit longer than expected to process the applications. So we did not have the course ID ready for today, but they said we can go ahead with the presentation and then we'll just email out the course number and the information once we get that back from them. And if any of the attendees have any questions, please put them in the chat so that our panelists can get to them during their segment. They'll either do that right after their presentation or as they go along, depending on their style. So I just wanted to kind of throw that in there for everybody. But thank you for doing this today.
Okay. Okay, I'm gonna turn this one off so don't get that. Okay, can you hear me still? No. Can you hear me? I can't tell.
Yes.
Okay, I see nodding heads. All right, maybe this will work. I'm gonna try to continue while I fire up the PowerPoint. Okay, so they don't get much documentation on the debt itself. They get just the spreadsheet. Debt buyer industry has grown exponentially since the last financial crisis. It has been, okay, I might give up on the PowerPoint. Okay, it's asking me too many questions. All right. They collect aggressively since they've been around for quite a while, but since the mid-2000s and then on into the financial crisis timeframe, they started becoming very, very big, buying a lot of charged off credit cards. So over the last 10, 15 years, there's been a lot of credit card lawsuits. They generally will end in default judgment if the consumer is not represented. So it's important that they get represented because the consumers don't know their rights, obviously. They usually sue after they've contacted the consumer several times and the consumer is ignoring them. But that's also very common for somebody who owes a bunch of bills. They tend to put their heads in the sand and not necessarily pay attention to the documentation that they're getting. May not even know if they've been served or not, which we'll get to in a little bit. Let's see. So first, what you do when you have a lawsuit or you get a call is once you want to make sure that they've been served. They don't know. They get letters from lawyers and it may have a copy of a summons for small claims court, and they know that there's a hearing date and they think that they've been served because they have this information. Look on the court docket and see if there's a proof of service filed. I don't like to waive service by noticing an appearance before they manage to serve the client, because they may never figure it out. And that'll get to in a little bit later as well. So then you can get the complaint if it's been filed from the docket and review it and see what you might want to plan on doing once the client's been served. You have to weigh this though, because sometimes they will get served and then they won't let you know that they've been served. So if you haven't noticed an appearance, you won't know that anything's been filed. So definitely, if you're going to do that, like I do often, I make sure they understand they've got to let me know as soon as they've been served, so that I can notice an appearance and start working against the debt buyer attorney. So first thing, once you review the complaint, you want to look at, does it state a cause of action? And there's generally two causes of action they'll claim in a debt buyer lawsuit, and that's account stated or breach of contract. So account stated is popular with the credit card buyers. They've determined that it's easier than proving a breach of contract theory because they don't have to have the contract. The elements are that the defendant and the creditor had business relations between them, that the creditor sent a statement to the defendant, and that the defendant did not object to the statement, which creates an implied in law agreement that what is on the statement is actually owed. And then Florida Rule of Civil Procedure Form 1.933 says that a copy of the account showing the items, the time of accrual of each, and amount of each must be attached. This is, it's technically true, but courts will often find that the statement that itself is enough. Lots and lots of lawyers, including myself, have argued that they need to show what was bought with the credit card, and so that the consumer has an idea of whether or not this statement they got it, or things like that. What is this balance that's claimed on there? There's no items or times of accrual. It's just a balance, and it says past due, and it says some date several years ago. That's not sufficient for the form and therefore the rules of civil procedure. But I don't think that's the best argument. But I would still make it, but just make sure you have something else to bring up. I think it's worth repeating that. That is actually what's required by the rules. Okay, and then I have, oh man, I'm sorry that you'll get this. I'm gonna send out a PDF of the slideshow so that you guys can see the documents, because there are some good examples. In an account stated, it's a common law theory. Basically, the history of it is something akin to, there was a corner store and a family used to shop there on credit before there were credit cards. They would go in, mom might pick up some essentials for the house, kids might go and pick up a piece of candy. Occasionally, I'm hearing that people can't hear. Is that, I will share the PowerPoint. I see questions, I'm gonna answer them real quick so I don't get too behind. I will share the PowerPoint. I'm using an old computer that is unfortunately unable to run two things at once. Let's see. And yeah, everybody's asking to see the PowerPoint, sorry. And then somebody said they can't hear me. Is that still a problem? I hope not. Okay, I can hear you now, great, thank you. So it's a common law theory. It was built on, based on transactions between a merchant and a consumer. And under this scenario, the merchant would have some kind of log of what was purchased and how much the items were worth, and there would actually be a record of what was purchased at the time or close to the time that it was purchased. And when confronted with the manager of the store or something, then a refusal to pay, then the merchant would have the opportunity to go to court under an account stated theory saying, okay, they never objected to any of these charges. This is what's owed. I want a judgment. A lot of consumer attorneys have been arguing that those facts are not at all similar to a credit card transaction where you have many different third parties. There's not one merchant, there's numerous merchants. And the most that the credit card company itself, much less the debt buyer, is ever going to be able to tell you about any particular transaction is where it occurred, not what was purchased. That is also not the best argument, but I also encourage people to continue making it, because it, just goes back to what the Florida rules actually do require. And maybe one day we'll get some success in that. Okay. So I actually also argue that under an account stated theory, because of its history, that the sending of an account statement is not enough. That they actually have to prove something, at least something that shows that the consumer got it, so that they had an opportunity to object. Because there are 3 actual requirements to the cause of action. They can prove that, maybe they can prove there was a business relationship between them if they have some kind of agreement. That they can prove maybe that they sent it by producing a bunch of statements with addresses on them and then backed up by testimony saying that this is how they are sent. But they can't prove the third, that they didn't object if they didn't reasonably have an opportunity to object because they didn't receive it. So this example that I have, the first example is a credit card statement that was filed with a complaint, and it has the address of a law firm. And I pretty much immediately just emailed opposing counsel and said these statements weren't sent to where she lives. And whether or not the opposing counsel decided that they just didn't want to have to prove that the consumer had authorized the lawyer to receive the credit card statements, and therefore she should be imputed with that knowledge or having received it. She didn't want to make that argument. I don't know if that's what it was, or if she just, I don't know what their policy is, but it went away pretty fast after I just said this went to the wrong place. So look at the statements. We're going to get to that more as well shortly. The other cause of action is breach of contract that they'll typically do. It's very popular with fintech loans, and I'll talk a little about fintech loans and also medical debt. Fintech loans are what I mean by them is Prosper and Upgrade. They're basically credit arrangers, and you may have seen ads for them or be aware of them. They, at least they used to, and this is also around the time of the financial crisis when a lot of other kinds of loans were not readily available to consumers. They would get in, and also the stock market was crashing. They would market to investors that you can invest in people's loans. So you can bid on loans and all this stuff. So there's a marketplace where normal consumers like y'all either are requesting a loan or offering to invest in a loan. So that's generally what Prosper and Upgrade are about, as far as that's what they were about, at least in 2010 to 2012, and I'm not sure how they necessarily operate now, but they have a contract. They don't send regular statements, so they can't do the account stated theory. They've never sent a statement. Medical debt, similar. Sometimes there's statements being sent, but there's usually not records of it. And often they aren't sent at all. Okay, so the elements of breach of contract, as I'm sure you know, is that a valid contract exists. The defendant has a duty arising out of the contract, that the defendant breached the duty, and plaintiff suffered damages as a result of the breach. So what you want to look at here is, well, is there a valid contract? These fintech loans actually will sign as attorney in fact for a consumer. And in the presentation I will have, oh, somebody's asking if I can repeat the second cause of action. That's just the breach of contract. So there's a contract, The defendant has a duty that he did not fulfill, so he breached his duty, and that the plaintiff suffered damages as a result of the breach. So the fintech companies, they'll sue as they're also debt buyer cases. They will sell it to some unknown entity. The relationship is not clear. And then they'll file a bunch of printouts from a website and claim that those are an agreement. There's never a wet signature. And usually there's not even something that approaches an e-signature. It just says something like electronically signed, or there's just nothing with the consumer's name near a signature portion at all. It just is as attorney in fact by either Prosper or Upgrade. Those are the two I've seen, not to pick on them. I'm sure there's more. They also will not file the the power of attorney, or at least not a signed version of the power of attorney. So there's just nothing on the face of it establishing that the consumer entered into this agreement. Okay, so now you're going to check the assignments after so the complaint will have the complaint, which will be 1 or 2 pages typically, not very long, and then it'll have assignments usually showing that the plaintiff actually has standing, or attempting to show that the plaintiff has standing to bring the action, and then maybe statements from a credit card or a contract, or sometimes both. So then when you're reviewing the assignments, what you're looking for is what is it that is assigned. So they'll show something, they'll have something called a bill of sale or just assignment, and they might be claiming that, so the assignment says, okay, let's make this bigger. Sorry, you guys can't see those. The bill of sale will refer to something like a forward flow accounts purchase agreement, and then the rest of the assignment will refer repeatedly to this agreement, including that all terms are defined in the agreement. And then it's going to be signed by however many entities there have been. So a lot of these are older. When the contract was entered into, it may have been with whatever bank, and then they got bought out, and then they became whatever LLC, and then along the way they became some other LLC, and then they assign it to some debt buyer. So often though, these things are signed by, and I haven't figured out exactly with regards to all these different kinds of accounts, how you can actually trace it back to which bank and who is the one with real title. You aren't getting their purchase agreement between the banks as it's getting bought out numerous times, and you're not getting, they aren't attaching this forward flow accounts purchase agreement to the complaint. It's probably a pretty long document, not unduly long, it could be attached, but they're very protective of these documents, which I'll refer to as the agreement, and that's between the debt buyer and the original creditor. That's something you really need to look for in discovery, or try to get them to show in discovery, because clearly whatever is assigned is limited by what's in that agreement. Sometimes nothing is assigned, and then I have a picture that you'll see in the materials when I email them out shortly, of a picture of an assignment that's just not signed. It just has 3 blank lines. It doesn't even have the name of the person who was supposed to have signed it. Just nothing. So it doesn't assign anything. And then sometimes they don't even bother to attach an assignment. So if that's missing, just note that. So then you're going to look at the statements that are attached to the complaint. In the event that it's an account stated claim, there may be several statements, there may just be one. You want to look to see if it was sent, like I mentioned earlier, to an address where the consumer ever lived or authorized them to send statements. this is where you'll find out potentially that this is just the wrong consumer. So, you know, there's a lot of folks with similar names and they may just have the wrong one. If it's somebody who, you know, they could be suing somebody from Miami or something, but they think they found them in Sanford and now they're suing them in Seminole County. And it's just not the right person. So find out where they lived at the time that those statements were sent. I'm sure you're all smart people and can figure out the best way to question your clients or potential clients on where they lived, as opposed to saying, did you receive this statement? And they either say yes or no. You want to find out generally what was going on around that time frame to see if it could just be the wrong person. You're not going to get a lot of information on this, and they aren't going to remember their account numbers, but they'll remember generally where they lived during certain years. Okay, I will email the presentation. Sorry, pausing just a second so I can figure this out and not mess up. Okay. All right, sometimes you're gonna get the agreement as well, which is nice because they're not easy to read, but you can find out things about what the authorized late fees are and if they should be charging. I mean, credit card agreements generally will allow for late fees, but surprisingly often they will attach an agreement that authorizes, say, $35 late fees, and they're charging, on the only statement that they provided, they're charging $39. So that's either not the right agreement, or, well, that's what you say on a motion to dismiss, is this is not the right agreement, so try again. Find the right agreement next time you file. Let's see. Many of these credit card cases are, this is an incredibly slow computer, I apologize. Many of the credit card cases are filed in small claims court. And if you're not familiar with small claims court, there is mandatory pretrial mediation where when the consumer finds out about the case, there will be a pretrial conference that they have to go to if they're not represented. However, if they are represented, then you can waive it with the opposing counsel. They will agree to waive it almost all the time. So usually when I notice an appearance, I will immediately send opposing, well, I'll review the complaint thoroughly first to see if there's any obvious issues. And I'll point those out in my initial contact with the opposing counsel, and also attach a stipulation to waive pretrial. They don't want to have to pay their appearance counsel to go there. It doesn't save them much money because they probably have somebody that day anyway, but you know, it could be 50 or 70 or 15 to 70 bucks or something is what I understand happens with these credit card guys. So you're saving them a little money. They're happy to waive it. And then it saves you a trip to the courthouse for pretrial, where all you're gonna do is stare at another lawyer and tell them that you're gonna move to dismiss the case. So it's really important to do this and not let the consumer go to pretrial, because all of the debt buyer is going to try to do at pretrial is to get them to agree to a payment plan. And they'll offer really low payments. So they think, okay, this is a $3,000 claim or something, and I'm worried that I'm going to get a judgment against me. So I'll agree to pay 25 bucks a month or $50 a month so that I don't get this judgment. But their stipulations always have a clause saying that if you miss one payment, that they're entitled to a judgment on the full amount immediately. And that's where a lot of default or a lot of judgments come from. People who actually went to court and did everything they were supposed to do and just felt pressured into settling with them at pretrial. Okay. My email just crashed, so I don't think I don't think that's gonna work right now. Okay, sorry about the presentation, y'all. So saving your client from, or saving any consumers from going into this pretrial is really a very good service to them. You're also going to invoke the rules of civil procedure if you would like to. You can do some discovery in small claims court without invoking the rules, but I just go ahead and invoke the rules so that they can't say that I'm being overbearing with my discovery requests. Okay, then after this, and also before, if you're not real familiar with small claims rules, you can file a motion to dismiss before pretrial and insist that it be heard by a judge at pretrial. So if you want to go and have your motion heard, you already have a hearing date, you don't have to schedule it. Just file your motion to dismiss after your notice of appearance. Things that you want to look for that are very common. One is that they serve these folks outside of 120 days. They do this a lot. So I always put that in there if service is outside of 120 days and they didn't make some kind of showing to the court, and I've never seen one where they did, they just get an alias summons. And sometimes these things are 2 years old by the time that the client's served. So include that in your motion to dismiss. You can get it dismissed just on that alone. You don't have to put everything in your motion to dismiss. You also want to challenge standing. That could wait till you have to answer if you need to. And then obviously failure to attach any necessary documents. If it's a breach of contract claim and they don't have anything that looks like an agreement that your client entered into, or if it's the wrong agreement in the credit card case and it doesn't match what the statements say, they should attach the correct agreement before you're obligated to respond. So you don't know, maybe there's an arbitration clause, there likely is, but you don't know what the arbitration clause is if that's just the wrong agreement. Standing, if they don't sign the assignment, then that's a problem. There's a lot of these debt buyers have kind of common names, and especially with the weird ones. I have a strange student loan case, specialty kind of student loan, private student loan, and the name of the company that has it, there's at least 10. If you look on Sunbiz, there were at least 10 different entities that started with those two names. And even their pleading referred to them as this group and also this group Inc. And so it's just internal. Both of those were registered with Sunbiz. So it was just not clear who was suing. So you file a motion to dismiss for lack of standing based on that. You shouldn't have to answer a complaint when you aren't sure who's making the allegations. So then when you get to the answer stage, again, standing, by then you may have worked out something with opposing counsel. Occasionally they will send you stuff without discovery. That's only if they have a great case, I think, which does happen, but it's very, very rare. Especially once you develop kind of a relationship with some of these attorneys, they'll just send over stuff because they know you're gonna ask. But they won't send over the agreement without a big fight. The agreement meaning the agreement between the debt buyer and the original creditor, saying what exactly was assigned. Those agreements typically will say that there's no representations and warranties made in the accuracy of any documents, that they may even say things in there that would defeat the business records exception to the hearsay rule, but it's hard to get that. So be prepared for a fight if you're getting down to that point. But usually you can get these things, you can take care of these things based on something other than needing the agreement. So I wanted to let you know, statute of limitations for accounts stated, should have said it back then, is 4 years, because it's not based on a written contract. And then breach of contract on a written contract is 5 years. But they have to have the written contract, the right one, to get 5 years. The benefit of getting these things dismissed is that, especially after a long period of before they were served, if they've been served late, they may well have missed their statute of limitations if you can get it dismissed. Okay, another affirmative defense. So statute of limitations and affirmative defense. And payment, obviously, is an affirmative defense. With regards to medical bills and the fintech type loans, they aren't even alleging that there ever were payments. The credit card ones, but typically will, on the statement, they'll show when they'll say something about the last payment. So you know that there was a payment at some point, but that's an open-ended credit arrangement as opposed to these others that are closed-end or an amount that is supposed to be certain, like the medical bill situation. If they've made a payment and it's not alleged, then you need to claim it as an affirmative defense. And then sometimes they've settled it, or the client may think that they've settled it. They might have 4 different credit cards over the last 10 years with the same original creditor, and they think they've paid it. Well, if they think they've paid it, then allege payment and, you know, try to find some records to back it up in case you get to where you need to prove it. But it might, don't just assume that they didn't pay their bills. They may have. And there may have been a settlement. A lot of times a debt collector, so debt buyers end up with it about at least 6 months after it's not, hasn't been paid. So they've missed 6 months of payments. As far as I understand, the Office of Comptroller of the Currency requires banks to get rid of these kinds of assets after 6 months. So that's when they start selling it to debt buyers. Before then, they'll either have in-house collection folks calling and writing to the consumer. And after that, then the debt buyer will hire debt collectors, or they have in-house debt collection affiliates. And they may have paid, they may have settled it. So if that's true, if there's any good faith basis to say that they've settled it. Another one is debt relief companies. They're awful. I hope you don't run across them too much, but you probably will if you start getting into this line of business. There are companies that say, pay us and we'll settle your debt. So they'll sign this agreement and they start making payments to the debt settlement company. And you don't know who's getting paid, but you know that they're claiming that they've paid things. So, you know, put that under payment or settlement in your affirmative defenses. Also release. So there's some old mortgages out there from around the financial crisis where the people will come back after 10 years and a foreclosure where the house was sold, and they'll say, you owe us on this note because there's no house anymore. So it's just an unsecured note. They may have been released during the foreclosure. This gets complicated, but you need to you need to try to find out if the client has any kind of documents regarding what happened to the second mortgage when the first mortgage foreclosed on the house 10 years ago. Okay, so then in discovery, which I encourage people to do early and often in these cases, the main thing you want is the agreement. That's a big thing. They're going to object or give you something highly redacted, but you need it. And they referred to it numerous times and throughout their pleading. So they need to produce it so that you can make sure that whatever they're claiming is assigned. And then any other documents that are referred to, they'll refer to the agreement in the assignment or bill of sale, but you need to request all documents that they have referenced. And it may be easy because it'll be dated. It'll say as of this document dated this or whatever. Then you just add those to the document request. Now you want the name and address of any record custodian that they expect to testify at trial. And then also a lot of other attorneys, if you're on any kind of listserv where they do this kind of thing, I don't know if community legal has something like that, or if they keep track of folks who've taken these cases. But I would definitely recommend, if you're doing this, to share who has actually prepared the affidavits for these cases and who, as a records custodian, and who, or, you know, keep track of the names so that you know who's working for whom ahead of time, and you don't have to wait for your discovery requests to come back, which they'll try to object to. They'll say that we don't know yet for when you ask for their witnesses, but they know. Okay. Okay, another advice, or more advice about discovery is keep it kind of simple. You may be trying to do a motion to compel, and county court judges, particularly small claims court judges, are, if you come in with 35 pages of discovery saying they didn't do it, and the judge is looking at a $600 credit card claim, they might get irritated. So try to keep it pretty succinct. This is basically document driven, and also, as we'll get to next, the records custodian and whether or not they're qualified to give testimony. So in preparing for trial, you want, don't skip over foundation. Everything that you'll see is driven with documents for them. Even the assignment, everything is going to say stuff that's trying to establish the business records exception to the hearsay rule. They're just assuming you're going to claim that everything is hearsay, because it is, but don't skip foundation. They have to introduce evidence sufficient to support a finding that the witness has personal knowledge of the matter they're testifying about. So a debt buyer, they don't know how statements were generated and sent. So in an account stated theory, they need to show some kind of knowledge as to that. And truthfully, even the original creditors don't have personal knowledge of that, because they outsource that stuff. Typically, they outsource it to some company that deals with in paper. They don't have some big print shop in a floor of the building where this one creditor has its offices. It's just not done that way. There's some other company that's actually doing the printing in the mailing and the generating of the statements based on stuff that would qualify for the business records exception. But you don't have those witnesses. You have debt buyer witnesses. So you want to ask where this person works and if they've ever worked for the original creditor, and they haven't. So, all right. Okay, and then if you get past foundation is when you get to the records custodian testimony as hearsay without an exception. They're going to claim the business records exception. And then typically the judge is expecting you to explain how it's not business records. So they're kind of up on this. They don't just assume that it's business records. So if you make a good argument after they say, oh, it's business records, and they'll just rattle off the rule. They won't say why somebody has knowledge or whatever, but the requirements of the business records exception to the hearsay rule are that the statements were made near at the time by someone with knowledge, or the recordings were made near or at the time by someone with knowledge. So they don't need, in a debt buyer case, you don't know who that person is. They don't know who worked at this company. So they're going to have a hard time showing that the person had knowledge who did it when nobody knows who that is. And it's kept in the regular course of business. Making the record was a regular practice. Then the opponent, that's you guys, does not show that the source of information or method or circumstances of preparation indicate a lack of trustworthiness. So this is where the agreement between the original creditor and the debt buyer is really important. That agreement is likely to indicate a lack of trustworthiness of the original records when you have the original creditor disclaiming any warranties or representations that anything that is in their records is accurate. That would probably suffice. It's hard to get that agreement, but since you're not going to get that agreement in most cases, if you get to trial and say, look, they've been withholding this agreement, and this agreement, you know, you should get a negative inference that that it lacks trustworthiness, or they would have produced it. They referred to this repeatedly. They haven't produced it. It was requested as number 1 on your document request. And yeah, so that one, it's required for the business records exception. So I'm going to go through them again since you don't have my slide yet. So a record has to be made at or near the time by someone with knowledge, kept in the regular course of business. Making the record was a regular practice, and the opponent does not show that the source of information or the method or circumstances of preparation indicate lack of trustworthiness. They shouldn't be able to qualify. A debt buyer should basically never be able to qualify for the business records exception to the hearsay rule. If you get that far, they shouldn't really even get past foundation, so that the statements just shouldn't come in to begin with. I wanted to spend a couple minutes. Let me read through the questions real quick. Somebody, let's see, could you go into more how you utilize the arbitration agreements in your defense strategy arbitration clauses? Okay. You can move to compel arbitration. The only time I do that, and I'm considering doing it right now, is when you come in really late and they're just going to get a judgment against them but there is an arbitration agreement. So if there's an arbitration agreement, then maybe it's worth a Hail Mary to initiate arbitration. I don't just because there's an arbitration agreement, file a motion to compel arbitration. I'm not sure if that's what you're going for. I really just kind of ignore them. They've obviously ignored the arbitration clause by filing the lawsuit in the first place. So you have an argument that they've waived it. You don't have to waive it. So it's just, if you really like arbitration, and I can understand, and I'm happy to make the argument that consumers would rather be in arbitration than court because court's scary to them, and not arbitration. It's not as scary as rather than a conference room than a courtroom. But I don't tend to do that. And then I have, can you please explain what the state controller requires banks to charge off? Okay, so it's the Office of the Comptroller of the Currency, and this is based off of something I read maybe 3 years ago, so not necessarily accurate. It's a banking regulator and it's federal. So they require, their rules, or maybe a statute requires them to charge off bank assets that aren't performing after 6 months. So that's why they sell, that's why the debt buying industry gets, and I don't know when that rule went into effect, if that ties into why the credit card debt buyer industry exploded, or if that was just as a result of the weak economy at the time. Quickly, while I have a few more minutes, I wanted to talk about garnishment, because you'll find you kind of get to do these in reverse when there's a garnishment action sometimes, because they a lot of default judgments are entered. As I said earlier, 90% of these or more result in default judgments. Some more of those end up in judgment because the settlement agreement was breached. Okay, and also quickly, the settlement agreements are problematic because they'll call for payment terms that are sometimes ridiculous, like payment by certified check mailed to someplace in Chicago, and they won't do automatic payment. There's no accounts. You can't, it's hard to prove that they didn't pay. They may have paid. They may have changed the PO box where payments were supposed to be, and then they get a judgment because they didn't get the payment. So it's really, really problematic. I never, never, never let people enter into settlement agreements where there's more than one payment. And I try to keep them from ever paying anything to them. So garnishment happens after there's a judgment. It's a third-party lawsuit against either I'm just going to talk about employers or bank accounts. So you can garnish bank account or wages. It's Florida Statute Chapter 77. It is short. I recommend you read it if you're dealing with garnishments. It's purely statutory. There's no common law equivalent, and all requirements of the statute are strictly construed. And the debt collector attorneys love this because if you miss your claim of exemption by 1 day, they'll say that it is a nullity under the statute, that you've waived all exemptions and they're entitled to whatever. But they mess up too sometimes. So always use that argument when you're dealing with a garnishment. They have strict, there's strict service and also timing deadlines for the claim of exemption that your client will need to file if they have exempt wages or assets. And so please read the exemption statutes as well so that you know what all the, I mean, even homestead exemption can be waived under the statute, under Chapter 77. So make sure that you're claiming things if they're getting garnished. So if it's wages, the federal law limits it to 25% of wages can be garnished. If there's a head of family exemption, so the person that is your client has a minor, or not even a minor, just they have a dependent that they're providing more than half the care for, then their wages are just exempt, and you have to get a claim of exemption in. Once you file a claim of exemption, the other side, the opposing counsel, has I believe it's 14 days, but look it up because they'll file it late. If they don't object to the claim of exemption, then the clerk is directed by the statute to dissolve the garnishment, and it's dead from there on. It's dissolved and it'll be dismissed. All of the withholding by the employer or the entire bank account will be released immediately, or should be released immediately to the client. Garnishments are really painful for clients because it's going to take some time for them to get their assets. They have to file the claim of exemption and then they have to wait, and they're not getting their pay or their bank account during this time. And right now it's very, very stressful for them. And also I wanted to talk about garnishment because it's increasing. Right now, and especially during the financial crisis, there were more garnishments on judgments than I've ever seen come through, which is particularly nasty. Some states stayed them, ours did not. So I believe that they're still executing on judgments very, very heavily. You may, when you get a garnishment, I don't want to go over, but I want y'all to know this. When you get a garnishment, make sure you go through the docket history, the whole docket history. You may have something where it's a default judgment where the client was served more than 120 days after the lawsuit was filed. If you have that, notice a limited appearance. You're not making a general appearance. They're going to say you've waived any kind of claim to object to the judgment. So limited appearance, file a motion to quash service and to vacate the judgment, and also file a claim of exemption if one is applicable. I'm going to open up to questions now. I want to say a little bit about bankruptcy. Just one thing is if you file a bankruptcy, or if the client files a bankruptcy while they're being garnished, they'll usually get a few weeks after the bankruptcy and a suggestion of bankruptcy is filed, they'll get a check for whatever was garnished. And sometimes it's a lot more than just the last 90 days, which would be something that the trustee would be looking at. It is property estate, but I don't know that if they have more exemptions, you could still exempt it. So that's one benefit of bankruptcy during a garnishment is they usually get a check and some money that they weren't expecting. Okay, so I have a few questions again. Nope, I don't have any more questions. Are there any other questions? No. I guess if there's no other questions, I'll turn it back over to David.
Well, good morning. We're going to take a, looks like actually Joseph Sternberg may have a question.
Okay, great. Well, I'll stick around. I'm going to try to.
Yep. Okay, because he has a question about arbitration clauses. That's I think that's something that's near and dear to the heart of every consumer rights lawyer. It's a big part of our practices these days. So, Cynthia, thank you for that great presentation.
Sorry about the technology. It's
We're all learning how to do this at this point. So, but
I should have brought in my other computer, but I didn't want to log it from home.
Joseph, if it's easier to present your question, Cynthia, if you've got a minute or two, I can unmute you. It might be easier just to ask it than to type it. So
okay.
I'm gonna unmute you, Joseph, and so that you can go ahead and ask your question.
Okay, can you hear me?
That should work. Yes.
Yeah, let me pull up my, because I have a copy of this credit card statement that was in the complaint, and let me look for the arbitration clause. I'm curious if you attempt to remove the case to arbitration, if that's a strategy, basically, is my question.
Sure. I mean, you can, and sometimes, I mean, if you want to be don't do it because you think they're just not going to show up in arbitration, is what I would say. If you are comfortable in arbitration, then go ahead, because it's the client's right to do that. And there may be good reason that you'd rather do that. And they may not show up in arbitration. So I don't typically do it. I am planning to do it, as I mentioned during the presentation. The one that I just got one that's just going to end up in a judgment. If I don't, that's basically all I've got left, because I came in so late. I wish I'd known about it over a year ago. The case was actually dismissed previously, but then they got it set aside because they weren't prosecuting it. So we'll see. So there's no discovery that's happened. Nothing happened because the client just didn't do anything until she got noticed of So I'm planning to do it there. But I don't do it just as a matter of course.
Okay, and my main strategy on this particular case is it's an alleged debt of about $6,000 for my client, and I'm curious if you're negotiating and the client isn't able to make, like, let's say an initial offer, like a lump sum, like how would you negotiate with the bank's counsel?
Okay.
Because they clearly do want, like you said, they want her on a payment plan. And before she hired me, they, were in discussions with her about getting her on a monthly, over how many years, right? So, yeah.
Okay, so I do this often. I say I'm not going to agree to a a payment plan. You can float them by me, and I'll tell my client about them. But I'm going to advise her heavily against against taking it, because it's not good, and I'm explaining exactly why. So they don't typically. Sometimes they've already agreed or something, and I'm dealing with it there. I just say, give us time. We're going to get you a lump sum. She's saving up, and I tell them to do that if that's really what they want to do. Sometimes you just have so many of these that, and they also will come way down on a lump sum too. If you're going to do that, I encourage litigating it to the fullest extent that you are capable of doing. I don't know how many, if it's too many cases you're getting, then that's one factor. But if you have, always send discovery requests, always, put the pressure on them that they're actually going to have to fight for it. And also just say, look, she just needs time, and realize that you have time. These things can take a while to resolve in court. Even if they magically have all sorts of documentation, then it's gonna take them time. So your client has time to save up for a lump sum if that's what they want to do. Sorry, David.
Hey, I just wanted to weigh in and supplement what you were saying on the payment plans. Is one of the reasons that debt buyers love payment plans is they always try to sneak that language in that if the client misses or is late with a payment, that they basically can go to court and get a default judgment. So if you do wind up in a situation where you kind of got your back against the wall, the client has to negotiate something. never agree to that position. I always push them, and I've never had them refuse, to where if there's any default, they have to give a notice and opportunity to cure.
Mhm.
Because they will run to the courthouse and get a default judgment, and whatever interest they waive, they want that back. So it's a trap for a lot of clients, what they consider payment plans. And unfortunately, in my experience, a lot of times when your clients go to court unrepresented, I think the courts encourage them to, settle. They, first thing they do is they send them to the mediator.
They do, and they have that form, and that's always in there. And so it's like, this is the only option, and what can you pay? And I think keep your clients out of that pretrial. They don't need to be there. You can get it waived. So at least if you're doing that, then, I mean, even if you end up settling it for some lump sum down the road, it's better that you didn't let them go into pretrial, which they have to do if you don't represent them, and get it waived. I'm going to send out, as soon as I'm off, I'm going to fire up a real computer and email my PowerPoint presentation so you guys can have it. There's a sample language for the stipulation. Just put that in your initial communication with the opposing counsel, and it almost always will get returned to you within the day. And then there's no pretrial at all. And they just let you know, that's really important for them.
Okay, thanks, Cynthia.
No problem.
And David.
Okay. I'm going to go on mute, I guess.
Yes. Yeah. Next up, we've got Jim Turner, who's going to give us a presentation on the FDCPA. And I'm going to, Jim's due to start in 1 minute. So I'll let him do his introduction. And I know what we're going to see is going to be some good stuff. So thank you for doing this, Jim. And thank you, Cynthia, for this your great presentation.
Thank you, Cynthia. You did a good job. You did a good job. I am trying to share my screen. Hopefully, this will work.
Yeah, we're seeing your screen, Jim.
Okay. Are you seeing a combating debt collector and credit? Do you see that?
Yep, it looks great.
Okay, great. All right. Thank you. Good morning, everyone. Everyone in this session represents consumers in debt-related matters, garnishment or debt collection. And what I want to do is I want to talk about what I consider and what many consider to be fighting back. It's a Friday morning. It's a rainy morning. If you will indulge me, I'd like to tell a quick joke about baseball. I'm very excited about the baseball season starting again. I'm a Boston Red Sox fan. And about 15 years ago, I was in Boston at Fenway Park to see the Red Sox play the Yankees. And it was in September that the stadium was sold out. You couldn't get a seat. So my wife and I are seated, and in back of us is a woman that I know, a former neighbor of mine, Mrs. Bernstein. And I see Mrs. Bernstein, and next to her there's an empty seat. So I turned around and I said to Mrs. Bernstein, why the empty seat? She said, it's my husband. It's my husband's seat. He passed away. Oh, I felt terrible. I felt terrible. So that, so we started watching the game, and in the 5th inning, my wife turned around and said, Mrs. Bernstein, didn't you have any friends or family that you could have brought here to sit in this seat? She said, of course I do, but they're all at the funeral. So I can hear the laughter. I can hear the laughter. Okay. All right. So let's talk about the Fair Debt Collection Practices Act. It's a federal statute, but I want to make sure that I point out that this provides for concurrent jurisdiction. And what I mean by that is, or what is meant by that is that you don't have to file a case in federal court. You can file it in county court. I frequently file my FDCPA cases, more often than not in state court and county court. I get a summary a small claims procedure. The case is on a fast track. Damages in these FDCPA cases are less than $2,500. So my filing fee is going to be about $300. My filing fee in federal court is $400. So one of the reasons is I save $100. But just because there's concurrent jurisdiction, and concurrent means in state or federal, because this is based upon on a federal statute, the case, if it's filed in state court, can be removed. So what the FDCPA does, and it's a beautiful statute because in just about every case, it is construed to help the consumer. When in doubt, yield to what the, I'll get into these specific items, but when in doubt, favor the consumer. First of all, since it's a remedial statute, it should be construed in favor of the consumer. So it requires debt collectors to affirmatively do certain things, and it prohibits them from doing other things. What you need to prove in order to establish an FDCPA case are basically three things. Number one, that the creditor is a debt collector under the FDCPA. It is important to understand this, and I want to repeat it. It is the creditor, in order to have an FDCPA case, the creditor must be a debt collector. I'm going to tell you what a debt collector is later on. Second, that the creditor collected or attempt to collect a debt from the plaintiff. Usually that's not a problem. Usually there's a collection letter, there's a phone call, there's something that is clearly an attempt to collect a debt. But it can't be something that the person filed something in court, or that there is the appearance that it's an attempt to collect a debt. It must be an attempt to collect a debt. But the good news is about this is that anything that the consumer could possibly construe, and what I mean by the consumer, I'm talking about the least sophisticated consumer, which I'm going to define in a minute, that the least sophisticated consumer thought it was an attempt to collect a debt. And third, that the debt collector engaged in some act prohibited by the FDCPA or failed to perform an act that was required by the FDCPA when it attempted to collect the debt. The FDCPA covers only consumer debts. It doesn't cover business debts. And a consumer debt is any obligation of a consumer to pay money arising out of a transaction primarily for personal, family, or household purposes. Most of our consumers that come to us for help, they have consumer debts. A student loan is a consumer debt. A mortgage on a residence is a consumer debt. Most debts for consumers that are not business debts are going to be consumer debts. So false, misleading, or deceptive. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of a debt. Now, these words, false, misleading, or deceptive, are very powerful words, because when used in the context of a least sophisticated consumer, this could mean an abundance of things. And because of the least sophisticated consumer, and because the FDCPA says you shall not make any false, misleading, or deceptive statement in connection in a communication, the standard is very high. And certainly the standard on the debt collector is high. And I think another way of saying it is that the bar is low for the consumer. What is the least sophisticated consumer standard? In judging any communication from the debt collector to the consumer, the communication must be judged and analyzed under the least sophisticated consumer standard. It takes into account that that consumers are that this isn't a law that is designed to protect experts, but it's designed to protect the general public. So when you're looking at whether a statement is false, misleading, deceptive, or unconscionable, you must look at it through the eyes of the least sophisticated consumer to decide whether or not they were misled. Now, the great thing, another great thing of the many great things about this law is that it's not a subjective standard. And what I see often is the debt collector will attempt to say, come on, your client wasn't misled. Your client knew that this wasn't an attempt to collect the debt from them. And that's not an argument that can be sustained. It's not a subjective standard, it's an objective standard. Whether the least sophisticated consumer, in looking at this communication, would have been misled, that's the standard. So you don't have to prove that your client was actually misled. You just have to prove that the least sophisticated consumer would have been misled. I have to step away for 1 second. I need a glass of water. Thank you for your indulgence. I'm back. So, who is a debt collector? This is again important. Not everyone is a debt collector. A debt collector is any person which uses the instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of debts, who regularly collects debts owed or due or asserted to be owed to another. So that means that Bank of America is not a debt collector. Chase Bank is not a debt collector. And National Collegiate Student Loan Trust, they cannot be considered debt collectors under the FDCPA. So debt collectors are, many of us know these companies. Metacredit Inc., they are a debt collector of medical debts. Midland Funding is a debt buyer and a debt collector. portfolio recovery, and the list goes on. I hope when I say National Collegiate Student Loan Trust that a few ears perked up, because this is a debt buyer that has purchased a lot of student loans, but they are the owner of the loan, and they cannot be considered a debt collector. And the great, I don't know, the great news is, but it's also important to know that attorneys are considered to be debt collectors under this statute. There's been a great attempt on the part of the Republicans, and David told me I wasn't allowed to say anything bad about judges. I won't say anything bad about judges, but he didn't say anything about saying anything bad about politicians. But the Republicans have tried to exempt this and get the attorneys out, and fortunately that has been unsuccessful. So attorneys, and I'll get to this in a minute about the attorneys and the liability of attorneys, because what I'm saying is that if you have a suit by Bank of America and the attorney engages in some act that is prohibited by the FDCPA, you may have a claim against the attorney or the law firm. Back to the least sophisticated consumer, the law describes the least sophisticated consumer as ignorant, naive, unthinking, and gullible. No special training, no obligation to doubt or question the sincerity of information that he or she receives. The least sophisticated consumer has a basic understanding of the world and a willingness to read a collection letter with some care. So I think the law is in favor of the consumer. So I want to talk about this example. I think this is a good example of the least sophisticated consumer standard, and it's a good example of the Fair Debt Collection Practices Act and the prohibition on misleading or deceptive communications. I do a lot of student loan representation. I have at least 100 National Collegiate Student Loan Trust cases that I've handled and still am handling. What National Collegiate Student Loan Trust does is that it buys student loans, it securitizes them, it sells paper. I mean, National Collegiate Student Loan Trust is a debt instrument that you can purchase. So another company, another debt buyer similar to National Collegiate Student Loan Trust is a company called SLM Private Credit Student Loan Trust. They sued my client on a student loan in state court. And the law firm was from Kentucky, not that really matters, but this is what was in the complaint. In paragraph 2 of the complaint, it said that the plaintiff, SLM, is authorized to conduct business in the state of Florida. It also states that upon the defendant's request, SLM entered into a contract with defendant, a copy of which is attached. Pursuant to the contract, defendant obtained a line of credit from SLM. And although plaintiff made demand, defendant has refused to make payment in full. Now, I want you to read this with me from a critical standpoint, which if you're going to find these cases, you have to read every communication this way from a critical standpoint. Let's go to the first allegation that I've mentioned. It's paragraph 2 of the lawsuit. And I submit that this is a complaint that was done by an associate lawyer in a big law firm in Kentucky that does a lot of debt collection work. And they pulled the complaint off the shelf. And they really didn't carefully read it, and they really didn't carefully adapt their complaint to this particular transaction. So it says plaintiff SLM is authorized to conduct business in the state of Florida. No, it's not. No, it's not. If you go to the Florida Department of State, you won't find that they're authorized to do business in the state of Florida. Moreover, they're a trust. Florida doesn't authorize trusts to do business in the state of Florida. And I allege that this is a false, misleading allegation that was intended to bolster the status of SLM. It also alleged that at defendant's request, my client's request, Mrs. Martinez, this was a case that was filed in federal court, so it's public record, that SLM entered into a contract with my client, a copy of what, no, they didn't. SLM didn't enter into a contract with my client. My client borrowed this money from Bank of America. She took out a student loan from Bank of America, and SLM bought the loan. Again, we argued that this was deceptive and misleading. Number 6, pursuant to the terms of the contract, defendant obtained a loan from SLM. No, they didn't. They obtained a loan from Bank of America. This was a sloppy pleading. However, as sloppy is not a defense. This was a false, misleading, and deceptive communication. And lastly, that plaintiff made demand on the defendant for payment. And again, SLM, the plaintiff, never made demand. And that was a false, misleading, or deceptive allegation. Now, going back to the debt collector, I told you who was a debt collector, and SLM is not a debt collector, but the law firm was, and I sued the law firm. The case was resolved. There was a confidentiality agreement, as our standard in these cases, but this was something that I use this as an example to show the power that the FDCPA has, the stringentness, if that's a word, of the law to prohibit false and misleading communications, and I also use it to demonstrate that the difference between a debt owner, which was SLM, and a law firm, which the law firm is considered to be a debt collector under the FDCPA. But I also use this as an example to communicate to you that, and hopefully you communicate to your clients that it doesn't matter if the consumer owes the money. My client owed the money, but she was still entitled to recover under the FDCPA. let's talk about some common violations under the FDCPA. Number one, and I think this is the most common one, is collecting on a debt that the consumer does not owe. Some examples. The consumer has filed for bankruptcy and the debt was discharged in bankruptcy. There is a line of cases that has developed recently where the debt collectors, they put in all of their communications a disclaimer that if you have filed for bankruptcy, then this is not to be considered an attempt to collect a debt. There's a lot of cases on this. The cases go both ways. You have to look at that disclaimer in the context of other communications. So I'll leave it at that. But certainly, a claim that was discharged in bankruptcy cannot be collected, and it's a violation of the FDCPA. The consumer has paid the debt. You might say, well, come on, how they're going to bill someone who has paid the debt? It happens all the time. It happens, in my experience. It has happened and will continue to happen with hospitals, healthcare providers. They are overwhelmed with. Unfortunately, they're overwhelmed with patients right now, but they're overwhelmed with bills and billing, and so I've had a number of cases where the consumer has paid the debt, and they have referred the case out to a debt collector. Another case where the consumer doesn't owe the debt, where the creditor has the wrong person. Sometimes there's name confusion. They buy these debts, and they buy old debts. They don't have all of the information. They do some kind of a skip trace, and they come up with a name. A very common name is Jared Lee. You could find something. And anyway, so that wasn't him. There's someone from Tuscaloosa also named Jared Lee. So they found the Jared Lee from Longwood, my distinguished colleague. There's another case that I want to get to in a moment where the law prohibits the collection of the debt. There is a Florida statute in the workers' comp section of the Florida statutes. It's cited here on the screen. It says a healthcare provider may not collect or receive a fee from an injured employee within this state, except as provided in this statute. Such providers have recourse against the employer or the carrier for payment of the services in accordance with this chapter. So this happens on a regular basis. I want to get to this case, Malone versus Accounts Receivable Resources. Such a great case. I've given you the site. And another one is where the debtor doesn't owe the money, is where they've sued an individual instead of the corporation. We as lawyers know that there's a distinction between an individual and a corporation. In my case that I'm working on right now, I'll talk about that, about suing the individual instead of the corporation. Another common violation under the FDCPA is contacting the consumer after they have representation. Uh, There was a law firm in town years ago, and they used to handle a lot of mortgage foreclosures. And what they did was what they did was when they received the client, they would immediately send a fax. They would find a fax number. They would send a fax to the lender, and they would notify the lender of the representation. And because this process began in 2008, when everything in the financial industry went to hell and their fax machine was burning up paper, and so they had some record that there was representation, and inadvertently or whatever, the client would be contacted by the debtor, and they had an absolute violation of this. Now, again, I may have used Bank of America, and we'll get to that in a minute. Under state law, there's a similar prohibition on contacting the debtor after you know about representation. So this is one that is often violated. Another one that is frequently violated is contacting family and friends. They can contact family and friends if they can't find the debtor. But once they have found the debtor, once they know where the debtor is, they have to, they can't do that. They can't contact family and friends. And once they contact a member of the family, and they attempt to get information on the location of the debtor, they can't contact them again. They can't keep calling the same person under the guise of trying to get location information when they've already done that. And another frequent violation is that the communication was from the creditor was false, misleading, or deceptive. And we go back to the case of SLM and the student loan. Another violation is collecting fees or interest that are not allowed by the underlying agreement. Frequently, debt collectors, debt buyers, they try to collect, they add on a fee. Cases dealing with adding on attorney's fees where there was nothing in the agreement that provided for attorney's fees. This is a violation. The next one, everyone knows, and you know, it's you can't call after 9 a.m. or before 8 a.m. I don't get many of these or any of these. I think that the debt collectors are pretty trained on this, and while I'm on that subject about being trained on this, I get a lot of calls from people who say that the debt collector called me at 6 a.m. or they called me at 10 a.m. and they threatened me and they said there was a warrant out for my arrest, and on and on. And when I would first get these calls, I'd get very excited. Then I realized that these are scams. These aren't debt collectors. These aren't anyone that that I can sue or you can sue. They're scam artists, and they, you know, if they get 5% of people to pay, and they scare people, they're successful. But I find that a lot of these extreme situations that people tell me about, these are not legitimate. These are not legitimate debt collectors. These are not cases that you want to get excited about or take. Another one is that you cannot call the consumer at work. Now, what you have to do is you have to tell the debt collector, look, I'm at work and I cannot receive calls at work. That's all you have to do. Once you do that, this law applies and you're protected. They cannot call you at work. And lastly, but certainly not the last for this page, is that you must give the consumer a mini Miranda. When a debt collector calls, they must identify who they are. They can't say, this is somebody. They have to tell you who they are, and they must tell you, this is an attempt to collect a debt. I'm a debt collector, and any information that obtained will be used for that purpose. Now, you'd think that again, the debt collectors and the telephone staff would be aware of this. Sometimes they are, and sometimes they're not. I still get cases where they don't give the mini Miranda case. This is a case that I was referring to earlier, and I just love this case. And this is by a lawyer from South Florida by the name of Scott Owen. He is he's the leading attorney in Florida under the FDCPA. He's a smart lawyer. He's a hardworking lawyer, and he had a successful case here. So this is a case where the medical center referred a $981 medical debt to a debt collector by the name of Accounts Receivable Resources. The debt pertained to an on-the-job injury of a worker by the name of Archie Malone. Mr. Malone was billed, and he sued under the FDCPA, claiming, among other things, that this was a violation of the FDCPA. The particular debt that is involved was a debt that was prohibited under Florida Statute 440.13, Section 13A. It says a health care provider may not collect a debt from an injured employee within this state, except as otherwise provided in this statute. The health care providers can only collect from the carrier or from the employer. So this was a clear violation, and the defendant in this case, Accounts Receivable Resources, admitted that it was a violation and admitted that they were wrong, but they said that this was an error and that they were excused from liability under the FDCPA under the bona fide error defense, which I'm going to get to in a minute. But the court granted summary judgment in this case in favor of Malone, and his counsel, Scott Owen, submitted a motion for attorney's fees of $75,000. on a $981 debt. And I love it when after I sue the debt collector, they say, please make a demand. I say, okay, I'll make a demand, but how much of a demand can I make? Because my fees are, I put maybe 4, 5, 6, 10 hours tops in the case. They want to settle in the beginning, but when they fight it, like accounts receivable resources fought it. This is an intricate law. It requires a lot of work, and $75,000 is a reasonable fee for the work that was done. A beautiful result. The case is on appeal. They appealed it, and it's before the 11th Circuit right now. They appealed that the trial court didn't consider their evidence on the bona fide error defense, which I think when you read the opinion, you'll see why that they didn't have any procedures. So this is the citation to this case. I encourage you, if you want to get a better understanding of the FDCPA, read this case, 408 F Sup 3rd 1335. It was decided last year in the Southern District of Florida. And again, I mentioned that the case is on appeal. There is a, forgive me, I'm jumping around a little bit, but I want to talk a moment about the statute of limitations. Frequently people call me and they say, someone is trying to collect the debt from me, but they can't collect the debt because of the statute of limitations. The statute of limitations in Florida on written agreements is 5 years, and this is a 10-year-old debt. But the answer is they can collect the debt. They just can't sue on the debt. So the Consumer Financial Protection Bureau has issued a rule that requires a debt collector, when it knows or should know that a debt is time barred, to conspicuously disclose information about the debt in the validation notice, that the law limits how long a consumer can be sued for a debt, and that because of the age of the debt collector will not sue the consumer to collect it. And if under applicable law, the debt collector's right to bring a legal action against the consumer can be revived, the fact of revival must be disclosed. What that means is that, and I know many of you already know this, but if a claim is barred by the statute of limitations, making a partial payment on the debt starts the statute over again. So a communication, the Consumer Financial Protection Bureau and the 11th Circuit in case law before this case came out says that unless you tell the consumer that this debt is time barred, and unless you can tell the consumer that that if you make a payment, it revives the statute of limitations, that communication is false, deceptive, and misleading. If anything, by omission. That's a material fact that should be disclosed to the consumer in connection with the communication. So I want to talk about a variation. This is a case that I'm handling right now. It's in federal court. and hopefully this will this will give examples, and this will illustrate some of the things that I've been talking about. So, excuse me, Luis Valenzuela owned a small drywall company by the name of Daedalus Inc. And Daedalus used a contract employee named Perez to do drywall work on a building project. Unfortunately, Perez was seriously injured on the job. And when he was taken to Central Florida Regional Hospital. And right after the treatment was rendered, Central Florida Regional Hospital sent a bill to Daedalus Corporation in care of my client, Luis Valenzuela, as president. And the bill said the amount you owe is zero. Now, I'm confused, and I'm sure that you're confused, but continue to listen, and maybe maybe we'll both understand this a little bit better. But the bill said the amount you owe is zero, and when I pursued them, why did it say zero? They said, well, we wrote it off, and we sent it to Metacredit for collection. Well, you can imagine when what Mr. Valenzuela thought. Mr. Valenzuela is not a lawyer. He's the least sophisticated consumer. He gets a bill that says zero. He says, that's great. I'm happy. So after that, unbeknownst to Mr. Valenzuela, unbeknownst to everybody, Central Florida Regional Hospital referred this matter to collection to a medical debt collector by the name of Metacredit. So Metacredit, after I'd taken the deposition, I found out more how they handle stuff. Everything is computerized. So when Central Florida Regional Hospital sends this information about the debt, when they send it to Metacredit, it's an upload. There's no people involved. It's just an upload. Once the upload occurs, then the computer spits out a bill. And the bill that it spit out, it says, Luis Valenzuela, 123 Main Street, Apopka, Florida. Says nothing about Daedalus Corporation. And Mr. Valenzuela believed that the debt collector was trying to recover this from him personally. There's nothing, again, there was nothing on the bill that says anything about the Daedalus Corporation. So Metacredit argued that, at least I think they're arguing this as it pertains to Daedalus Corporation. Why is Metacredit, or why is Central Florida Regional Hospital billing Daedalus Corporation for injuries sustained by Perez? Their argument is because this was an on-the-job injury, we are entitled to bill the employer. And they may be entitled to bill the employer, but they're certainly not entitled to bill Valenzuela. But what I pursued them on is, was there an agreement by Valenzuela? They claimed that there was an agreement by Valenzuela to pay the bill for Perez's medical services. And I said, well, is the agreement in writing? And they keep pushing this argument that this is by operation of law, because Valenzuela admitted that this was an on-the-job injury, that somehow there's automatic liability. under the statute that I referred to before in the Malone case. But again, not as to Valenzuela. So one of my arguments, my main argument is that he was billed for a debt that he didn't know, was false, deceptive, and misleading under the Fair Debt Collection Practices Act. But in order for an agreement to be enforceable in Florida, to promise to pay for the debt of another, it must be in writing. Section 72501 of the Florida statutes. So when I was preparing for the deposition and beginning a draft of my motion for summary judgment, my thoughts about the statute of limitations arguments started to percolate in my mind, and I said, this is just like the statute of limitations. The statute of limitations beyond 5 years is unenforceable. An agreement to pay the debt of another, unless it's in writing, is also unenforceable. The partial payment of a debt that is barred by the statute of limitations revives the statute. And just like that, a partial payment under a debt that is not in writing, partial performance can be considered false, misleading, and deceptive. If anyone agrees with me or disagrees or wants to discuss this, this is a theory. This is my own theory. This is one chance where I have an opportunity to be a little bit creative. Me, like most lawyers, are plagiarizers and copy from other stuff. So this is something that I'm kind of excited about. I'll let you know. I'll let you know what happens. So I want to talk about the Florida Consumer Collection Practices Act. And what I want you to understand here, I want you to leave with this understanding. I went on and on about a debt collector and who's a debt collector, and they collect for, it's got to be collecting for the debt of another. This doesn't apply to debt collectors. This says no person. So this says no person means Bank of America, and it also and Chase Bank and Capital One, but it also applies to XYZ roofers, and it applies to AT&T, and so this is a very very powerful statute. So I gave you 4 sections of this statute that I think are the most frequently used. So number 7 is you can't call a debtor or a member of the family with such frequency that it considered to be abuse or harassment. Now, there are a few cases on this in Florida. I have not taken any case on excessive calling because excessive calling is, in my opinion, it's very hard to prove. It's very hard to prove. So I think that this is something that, while it's in the statute and I understand why it's there, it's designed to protect people from harassment. I think that this is something that, if you have nothing else, I wouldn't take this case. I don't get the profane and obscene, vulgar, abusive language in communicating with a debt collector, but it certainly happens, and I read the papers and I hear stories. But the one that I think is the most powerful is 9. It's 559.72 subsection 9, claim, attempt, or threaten to enforce a debt when the person knows that the debt is not legitimate, or assert the existence of some other right when the person knows that the right does not exist. That's very powerful. That's very powerful. And again, if your roofer is trying to collect on something, this may apply. If your roofer is trying to collect on a debt or make some claim that's not valid, this applies. And then one, I'm speeding up a little bit because I see I'm running out of time here, but one of the other things we talked about it with the FDCPA was you cannot communicate with a debtor when you know that they are being represented by a lawyer. I want to go back. I mentioned bona fide error defense before. Both the FDCPA and the FCCPA have bona fide error provisions. But under FDCPA, unlike the FCCPA, the FCCPA requires there to be some intent on the part of the person violating the law. But under FDCPA, it's a strict liability statute. It doesn't matter whether they intended to engage in the act or whether the debt collector should have known. All that the plaintiff has to prove is the debt collector did engage in the prohibited act. However, there's one exception, and that's the bona fide error defense. And that's cited at Owen. And I mentioned about the Malone case, read the Malone case, but the defense accepts a debt collector from liability if they can prove all three of these sections, that the violation was not intentional. Okay, that's pretty easy. The violation was a bona fide error. Okay, maybe that's easy too, but the violation occurred despite the maintenance of procedures reasonably adapted to perform any such error. This is where all the litigation occurs in these cases. Whether or not these practices, whether they have any policies. I told you before about Metacredit. They had an upload procedure. They have no policies. Then you got to ask them, well, are the policies written? If the policies are not written, they cannot rely on them. What Metacredit relies on and what accounts receivable resources relied on in the Malone case, both relied on this as a bona fide error. Was they have an agreement with everybody who refers debts to them, only send us valid debts. And they say that takes us out of the statute. That is a maintenance of a procedure that eliminates these errors. And the court in the Malone case said that's not a procedure. That doesn't qualify. Where to sue? The FDCPA provides for concurrent jurisdiction. That means that a case claiming statutory damages can be filed in state court. You have a $300 filing fee. You save $100. So I file my cases in county court. They may be removed, but I've still saved $100. Should you file an FDCPA case as a counterclaim? My suggestion is you get more leverage if you file it as a separate action. The last thing I want to cover is a 30-day validation notice. Within 5 days of an initial communication, that means a phone call. You must send a letter, and this is something that's often violated. And in the letter, you must state the amount of the debt, the name of the creditor to whom it's owed, the right to dispute within 30 days, and it must be within 30 days of receipt, not in 30 days of issuance. The right to have verification and the name of the original creditor, and once you ask them to validate the debt collector must cease all communications and efforts to collect the debt. The remedies under the FCCPA are $1,000 plus court costs and reasonable attorney's fees. The same under the FDCPA, but under the FCCPA, you're also entitled to equitable relief and punitive damages. Under the FDCPA, and I'll give you this outline. I know I'm running out of time. Anyone who wants a copy of this outline, please let me know, and I will send it to you. Thank you. I want to take time out for questions.
Hey, Jim.
Yeah.
Jared asked a question about, hang on, I've got to find his question again, but basically I think he's asking about the issues with Article 3 standing and Spokio and its progeny with, what's the status right now with FDCPA claims and the need to have actual damages to have federal court standing under Article 3. Do you know? Because I know that's a rapidly emerging area in the law, and it seems like it's changing every day. Do you know what the?
I don't think it's changing every day. I think that the cases that I have read, Spokio for purposes, and I guess you've already explained this, but what the Article 3 of the United States Constitution says is that you have to have some case or controversy and there must be an injury. Justice Alito wrote this opinion, of the Spokio opinion. I think that the cases, they say that statutory violations still a congressionally created harm is still standing under Spokio. I see Spokio cases in the 11th Circuit all the time. Every defense attorney raises Spokio, but I have not seen in the 11th Circuit, again, I haven't studied for this question, but I haven't seen one where they have sustained where they have dismissed on the ground of standing. It is emerging, but I think that like a lot of cases, the defense attorneys have tried to abuse this, and I don't think they've been successful. I think that the cases that I've seen, Spokio has not been a problem under the FDCPA.
That's good news to hear.
Yeah, yeah.
Jim, have you looked over the case that came out of the 11th Circuit this week, the Trichel versus Midland Credit Management case?
I have not. I have not. I guess I need to.
I think did create an issue for a Spokio issue, specifically in FDCPA cases where you haven't alleged actual reliance on the misleading communication. And even worse, the appellate court there raised it on its own. It was not something raised by the parties.
Yeah, I have heard from people who know a lot about this more than I do, and this may be the case. I need to read it, but they say that that in the 11th Circuit they're going to abolish the least sophisticated consumer standard because it conflicts with Spokio. The least sophisticated consumer says whether you relied or not. But what you're telling me is this recent case says you have to show reliance. So I'm going to have to read it. Jared. Thanks for.
I would just encourage people to plead actual damages and you know, when pleading a case based on a misleading statement, go on and put that into the complaint.
Yes, I agree.
Well, Jim, I want to thank you. That was a great presentation. And if we can, maybe we can hang out for a few minutes after Jared's presentation to take questions. And then we've got at the end of the day, we'll be taking questions too. So if anyone has any more additional questions, it was a great presentation, and it's a really, it's a very powerful remedy for consumers. But I want to kick off with Jared, who's going to be talking about the Fair Credit Reporting Act for us, which I'm very eager to hear because it's always seemed like spaghetti to me. So.
Well, David, I appreciate the opportunity to participate today. In a moment here, I'll get my screen shared so people can see a PowerPoint. Please let me know privately about the errors in my PowerPoint because I'm sure there are many. I've also asked Martha to allow attendees to unmute their mics if they have a question. You can also submit, I'll try to keep an eye on the question and answer box as well if you prefer to send. I won't watch the chat because it's kind of hard to sort questions out from there. So if you have a question, put it in the question and answer or unmute your microphone. I appreciate interruption. I think that the Zoom meetings that we are all getting used to can be at times boring, especially if it's just one person talking. Luckily, we've had some great speakers this morning, but I don't hold myself to their caliber and appreciate the interruptions if you have a question. So that being said, let's talk about the FCRA. So this actually hits on the cartoon here hits on the point I was just talking about. Sometimes it is a difficult choice whether to engage in these never-ending Zoom meetings. So what is the FCRA? Most of you have heard of the FCRA, or its initials, the statute, the Fair Credit Reporting Act. The Fair Credit Reporting Act has been around for about 50 years. A lot has changed in those times. It was enacted when tape players and lava lamps were all the rage. The Beatles had just broken up, and the FCRA was the first data collection regulation passed in the computer age. Most of us don't think about the computer age beginning in the 1970s, but by that time, they were already collecting and categorizing consumer data electronically. The findings of Congress that led to the Act's key regulatory action laid the foundation for several other privacy acts over the next 50 years. And one of the most important aspects of its innovation was the decision that secret databases should not be used to make decisions about a person's credit and the person's life, that a person should have an opportunity to see and challenge the accuracy of the information that was held in such databases. The FCRA affects almost everyone. And so it impacts consumers, of course, consumer reporting agencies, banks, credit unions. More interestingly, it also impacts insurance providers who often use some form of consumer report in the underwriting process. It impacts employers who use background checks or credit checks in the hiring process. It impacts background check companies, and it regulates those companies as consumer reporting agencies, just like Equifax, TransUnion, or Experian. A company that's performing background checks will be considered a consumer reporting agency. It affects public records providers, reference check providers, and so like as part of a background check, often a company will hire a third party to call and check references. The information that they report is considered a consumer report and is subject to the restrictions of the Fair Credit Reporting Act. So let's talk about what a consumer report is. And I've put the statutory language up here. When David was referencing the Fair Credit Reporting Act being somewhat confusing, these definitions can definitely get into that confusing category. So the statute says that a consumer report means any written, oral, or other communication of any information by a consumer reporting agency that has a bearing on the consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, which is used or expected to be used or collected in whole or in part for the purposes serving as a factor in establishing the consumer's eligibility for credit, insurance, or employment purposes. Boy, what a mouthful. As you can see, the language is very broad here as to what is considered a consumer report. But you'll see that a key aspect of what is considered a consumer report is that it is information communicated by a consumer reporting agency. So to understand what a consumer report is, we have to look at what a consumer reporting agency is. So a consumer reporting agency means any person for monetary fees, dues, or on a cooperative basis regularly engages in whole or in part in the practice of assembling or evaluating consumer credit information or otherwise other information on consumers for the purpose of furnishing consumer reports to third parties, which use any means or facility of interstate commerce for the purposes of preparing or furnishing consumer reports. Those of you who are paying close attention to those definitions may see a little bit of a problem here. It is a little bit of a circular logic in that a consumer report is a report that is created by a consumer reporting agency, and a consumer reporting agency is a company that creates consumer reports. So you'll see that that's a little bit circular, but luckily there is a lot of there's some clarification as to what is considered a consumer reporting agency through the case law, and the definition is actually fairly broad in practice. If you have someone that is routinely collecting information and putting together and distributing it to someone else, they are likely to be considered a consumer reporting agency. So let's talk about the life cycle of consumer information. Actually, before we get to this point, let me see if I can pull the chat box up. I'd love to see to get a better feel for our audience, and so maybe someone, if you have been involved in a Fair Credit Reporting Act case, could you just make a comment or raise your hand in the chat and help me understand what our audience is like today? Let me actually go back to that. Okay, I am actually, the chat is not doing a good job coming up on my screen. Hold on just a second. Okay, I see that we have a few people and someone who's had a mixed merge file, which is always a fun consumer FCRA case. Joseph, let's loop back and definitely talk about that because I love mixed merge file cases. We'll talk about that in a few minutes, actually. So let's talk about the life cycle of consumer information. Consumer information flows through the system in kind of a circular pattern. Within the system, you have consumer reporting agencies. These are the companies like Equifax, TransUnion, Experian, and others that collect information about consumers in order to provide or create reports or serve as a source of information in that process for others. They take that information and sell it to users, and users are regulated under the Fair Credit Reporting Act in several ways, just like consumer reporting agencies are. Users of information are employers, banks, debt collectors, and others that buy consumer reports in order to make decisions or take actions regarding consumers. Interestingly, users often become furnishers because once you apply for credit and your credit report is used to help approve you for credit, that user then becomes a furnisher of information frequently, where they are then reporting information on you. Furnishers are another party that is governed by the Fair Credit Reporting Act, and it's anyone who is reporting information to a consumer reporting agency. Even if they are someone that is going out and gathering that, such as a public records company, when they're furnishing that to a consumer reporting agency, they are governed as a furnisher. So, who has obligations under the Fair Credit Reporting Act? Well, first and foremost is consumer reporting agencies. Consumer reporting agencies have a number of obligations to consumers. First, they have an obligation to ensure maximum possible accuracy. And I love that language from a perspective of presenting jury instructions to a jury, telling them that the consumer reporting agency had to have reasonable procedures to ensure maximum possible accuracy. That is something that is going to be relied on heavily at trial and is great language from a perspective of how you think about your cases. Second, consumer reporting agencies have an obligation to do reinvestigations when information in their report is disputed. We'll come back to reinvestigations in a little bit. And interestingly, the reason it's a reinvestigation instead of an investigation is the consumer reporting agency, in theory, should be investigating the information on their consumer report from the beginning. And so when it's disputed by a consumer, it should be a reinvestigation of that information. In practice, we'll see that there's not a tremendous amount of investigation at the beginning, and there's no private right of action to enforce investigation, at least from a furnisher standpoint. And so we will see that reinvestigations are really where liability is established. Second or third, they have a duty of confidentiality. They have to keep the information that they collect on consumers confidential, except to someone who has a permissible use. And there is a statutory list of permissible uses for when a consumer reporting agency can release a report or other information to a user. And then finally, they have an obligation to make certain statutory disclosures. I will confess, I don't bring a lot of cases based on CRA's disclosure requirements. Most of them have put the right disclosures in place, but sometimes in the context of a background check, these disclosures can become an issue. The next is the users of information under the Fair Credit Reporting Act. Users must have a permissible purpose and certify a permissible purpose to a CRA in order to obtain access to a consumer report. And so if they improperly certify that permissible purpose or pull a report for a purpose that is not a permissible purpose, that may give rise to an action. Users also have notice obligations. For most, that is an adverse action notice. We'll talk about that a little bit later. And then also users must provide disclosures. For example, many of you have seen in your clients' files a credit denial that discloses that a consumer report was used as part of the process. That is generally an adverse action notice. If the language is getting too complicated, just take yourself off mute, tell me to slow myself down. But we do have a fair amount of information to cover, and I don't want to run out of time too much. So next we have furnishers. Furnishers have a duty to ensure accuracy. However, that duty to ensure accuracy is not enforceable under a private right of action for consumers. They do have a duty to conduct reinvestigations when they get notice of a request to conduct a reinvestigation from a consumer reporting agency. So who can enforce the FCRA? Well, first, the Consumer Financial Protection Bureau, the CFPB. Most of you are probably familiar with them. They recently survived a constitutionality challenge in front of the Supreme Court. Next, the Federal Trade Commission. can enforce the FCRA. State attorney generals can enforce the FCRA. And for the most part, consumers can enforce most aspects of the FCRA under a private right of action. There are some limitations, and we'll try to touch on those. And of course, if a consumer needs help in this, or you ever need a co-counsel in an FCRA matter, our firm is always happy to help you. As far as civil liability, there are two liability provisions under the Fair Credit Reporting Act. There's one for negligent noncompliance that provides for actual damages and attorney's fees. And the next is for willful noncompliance, which provides not only for actual damages and attorney's fees, but also for statutory damages that go up to $1,000 and punitive damages. Most cases that we bring involve willful noncompliance, but we also plead the negligent noncompliance as well. So let's talk about statutory damages. Statutory damages can range from $100 to $1,000. The existence of statutory damages generally should not be the only damage you plead in your complaint. And we talked a little bit earlier in the last presentation about the Spokio case. Spokio was actually an FCRA case that came out of California, came up through the Ninth Circuit to the Supreme Court. The Supreme Court said a bare statutory violation alone is not sufficient to trigger Article 3 standing, sent the case back to the Ninth Circuit, where the Ninth Circuit found that there was a future risk of harm coming from that FCRA violation, and established that there was standing. But it is important to plead damages and harm, or a risk of future harm, when you bring an FCRA case for that reason. Actual damages can include out-of-pocket damages, wages, lost credit opportunities, emotional distress, reputation damages. It's actually a very broad net of things that can be collected as damages under the Fair Credit Reporting Act. Also important and essential in FCRA cases, from my perspective, is that the statute provides for punitive damages. And punitive damages can be a very useful tool in pursuing situations where a furnisher or a consumer reporting agency has created the same problem in other situations, or is aware of the possibility of a problem similar to what your consumer experienced. So you have a consumer who has an inaccuracy. What are your next steps? So the first and most important thing to do, once you've determined that you are dealing with a consumer report that has an inaccuracy, is to dispute the information. It would make logical sense to dispute this information with the furnisher that is putting the information on, or giving the information to the consumer reporting agency. But logical is not how this statute is written. The dispute must be sent to the consumer reporting agency that created the report, and they send that dispute to the furnisher as part of their reinvestigation. Without disputing the information to the consumer reporting agency, you cannot establish FCRA liability in a private cause of action against a furnisher. That being said, it is always good to send a copy of your dispute to the furnisher so that if they later claim that they didn't get enough information from the consumer reporting agency to understand your dispute, they have been sent a direct copy. The dispute ideally should be in writing. I am not a fan of disputing inaccuracies online or by phone. A couple reasons for that is when you dispute by phone, that call recording is likely not to be found when it comes time to litigate your case. And second, when you dispute online, you are limited and forced into selecting different categories automatically that will automatically filter your dispute into certain processes, where your dispute may actually cover several different issues that need to be investigated in different ways. Include as much documentation as you can in your dispute. Be specific in your dispute. Send it by certified mail and save the green card. There is an ongoing debate in the FCRA circles about who should write and send the dispute. It is my understanding and reading of the statute that the consumer needs to send the dispute. And so I sometimes do assist consumers in drafting those disputes, but have the dispute come from them. I can certainly see the argument that a dispute on attorney letterhead is arguably from the consumer, but why face that, that challenge and that issue if you don't need to? So, generally, consumer reporting agencies need to investigate the dispute and respond to it within 30 to 45 days. 30 days under normal circumstances, 45 days if the dispute is disputing something that has been received on your consumer's free annual report. This is probably a good point to note that right now the free annual report is actually a free weekly report. You can get your consumer report from either any of the major 3 bureaus once a week for free through annualcreditreport.com or by mailing a file request. That will include your the full consumer file, but will not include credit scores. For purposes of the FCRA does not actually include the calculation of the credit score. That's not governed by the Act. But the information used in the calculation of that score, of course, is. The consumer reporting agency must send notice of the dispute to the furnisher. This is one way that consumer reporting agencies can violate the Fair Credit Reporting Act, is if they leave information on that is inaccurate without transmitting that dispute to the furnisher. The furnisher must then conduct its own investigation and respond to the CRA. And so much litigation has occurred in the context of what furnishers must look at. And really it comes down to a case-by-case factual question. But generally, furnishers are required to look at their entire file to the extent that such is triggered by the information that's disputed. It is a frequent violation of the Fair Credit Reporting Act that the furnisher will simply verify the information that is currently being reported, or simply look at the surface verification and say, yes, this is what we meant to send, without looking beyond that to see whether the information being reported is accurate. This is where prior disputes that were made by the consumer to the furnisher, phone calls and letters saying, hey, you're reporting wrong information and why, can be helpful and become relevant to your FCRA case. The consumer reporting agency must then mail the consumer reports of the investigation in writing. This can also be done online with the consumer's consent. Generally, the results will be to either modify, delete, or verify the information. Modify includes sometimes the information being updated, will be how it's listed and phrased. All of this is done through an electronic platform that was set up, at least in the context of the major bureaus. It is done through a platform called eOscar. It's a platform that was owned and created by the Big Three and uses a system called Automated Credit Dispute Verifications, or ACDVs, and Automated Universal Data Forms, AUDs. So if you're involved in FCRA litigation, one of the first things you need to ask for in discovery is copies of those ACDVs and AUDs, because those will be the key documents to understanding the communication between the consumer reporting agency and the furnisher. Those disputes are generally they talk to each other through numeric codes. And there are codes that categorize a dispute as not mine, categorize a dispute as inaccurate information, that categorize a dispute as wrong consumer or identity theft. all of those codes are standardized through a format known as Metro 2. And again, eOscar and Metro 2 are created ultimately by an arm of the big three, and they use standard coding, even though the way those codes are described may be different for the different consumer reporting agencies. So when your consumer receives the results of their consumer dispute, if the information has been corrected, modified, or deleted, and as a result of that is now accurate, you don't have a case generally under the Fair Credit Reporting Act. There are some exceptions to that. Joseph mentioned earlier that he had a situation where there was a merged file and two individuals were combined together in a background check or a consumer report. That is a situation where there may still be a private right of action against the consumer reporting agency. But generally, from a perspective at least of the furnisher, if the information is corrected, modified, or deleted and is accurate after the first dispute response, they are off the hook, even if, sadly, the information was reported maliciously. It's worth noting that most of the case law has found that the FCRA preempts common law causes of action, such as libel and slander and intentional infliction of emotional distress, when it is based on this reporting process through a consumer reporting agency. There are some very narrow exceptions and arguments to be made, but let's not go down that rabbit hole now. So the results that are mailed to your client can be helpful in allowing them to go back to people who may have denied them credit based on the inaccuracy, or to have them request a new consumer report. Have the consumer save copies of the dispute results. And even if the dispute turns out in their favor, it is important to save copies of those results, because if the information comes back or gets changed again to inaccuracy, there may be other claims such as a reinsertion claim. And then always have your consumer check the reports again in 60 days. Because again, some kinds of errors, some kinds of inaccuracies can very quickly reinsert themselves back in a consumer's file and make problems. If the information is verified as accurate or modified or somehow changed to continue to report the inaccuracy, keep disputing. Absent a really urgent situation, we like to see at least 3 consumer reports consumer disputes before we file suit. Even if the dispute information is corrected on a later dispute, you may still have the ability to bring an FCRA case against the furnisher. And often them correcting the information later on can be great information as to a great tool to use in discovery as to why it was corrected later but not corrected earlier, and using that to show that at one point in time they did not follow their policies and procedures. Try to include new information in each dispute, or at least phrase it differently. Adding information and including more information can help you avoid the dispute being categorized as a frivolous dispute. And the restriction on frivolous disputes allows a consumer reporting agency to ignore disputes that they consider frivolous. And this might be a good reason to tell your client not to file a new dispute of the same account every day for a year, because that can look frivolous. Even if a furnisher or CRA refuses to correct the information, the situation is just beginning. That is generally when a Fair Credit Reporting Act case is best considered. So let's talk about some of the common FCRA claims, and we're going to talk statutory language here. Actually, let's pause for a moment because we're about halfway through my time, a little bit more than halfway through my time. We've covered a lot of material. I'm going to take a quick look at the question and answer. And if you have a question, please let's take this moment to unmute the mic and ask the question and see if we can, make sure we're headed in the right direction. All right, I'm not hearing any questions, not seeing any in the question and answer. So I hope you are all having good dreams as you sleep through the presentation. So some of the common FCRA claims versus a consumer reporting agency. The FCRA is found at 15 USC 1681, and the subsections start at A and continue for quite a while. It is a dense statutory scheme and particularly dense before you understand how the players interact and how the statute interacts. It's always good if you're looking at these issues and aren't used to litigating under the Fair Credit Reporting Act to bring in someone who has done it. Those of us who litigate regularly under the FCRA are always happy to talk, always happy to co-counsel. But even if you don't want to co-counsel, don't hesitate to call me up, talk to me about your FCRA claim, brainstorm how it fits into the statutory scheme. So the first and most frequently used provision under the FCRA is probably under Section I. And this is the obligation of the consumer reporting agency to reinvestigate after receiving a dispute from the consumer. These are the disputes that we've been talking about for the past couple of slides. And when those are received, again, the CRA has the obligation to reinvestigate. If they don't reinvestigate or do an insufficient reinvestigation, they may have liability that is triggered under Section I. The next section is one of my favorite, particularly in situations where the consumer reporting agency is the source of the inaccuracy. This can be situations where they have merged two people's credit files together, which is known as a mixed merge situation. This can include situations where they split a single consumer file so that the same consumer has multiple files. And so when someone requests their credit report, say a bank requests their credit report, they're only getting half of the credit history rather than the full credit history. Anyway, under 1681EB, the Consumer Reporting Agency has an obligation to maintain policies and reasonable policies and procedures to ensure maximum possible accuracy. And so where they have failed to keep another person's information off or include information that needs to be included about that consumer, this is an extremely powerful tool. The next section is 1681C, and it says that a consumer reporting agency cannot report obsolete information. Obsolete information generally is calculated as 7 years from the date of first major delinquency. And so generally look at about 7 years from the date of charge-off for revolving accounts like credit cards, for some situations, such as bankruptcies, it may be 10 years. It's worth noting that in background check cases and situations where a consumer report is being pulled for insurance underwriting for life insurance greater than, I think, 150,000, this time period restriction doesn't apply, but that's not the common situation. And many of the consumer reporting agencies still follow that 7 to 10 year window for obsolescence. Finally, they can't report or release a report for an impermissible purpose. We see this sometimes in the context of an auto dealer that pulls a credit report without an application for credit. For example, a consumer comes in, the dealership asks for a copy of the driver's license in order to facilitate a test drive. They run a credit check while the consumer is out driving, so that they know what kind of first, whether the consumer is a viable customer. Second, what kind of ways they can screw them in the financing arrangement. Next, let's look at the furnisher claims. Furnisher claims primarily come up in the context of S-2B. And it's worth noting that there are regulations under S1 and S-2 subparagraph A that require the furnisher to do certain things. However, there is no private right of action for it. So when you're bringing a furnisher claim, make sure that you plead that properly as a reinvestigation claim, not under S2A. Next is a furnisher or a user, in this case, having an impermissible purpose. And an impermissible purpose, again, is a statutory list of reasons that a person can pull a consumer report. We already touched on parroting and what parroting was, and that's parroting is what is called in the case law is when a furnisher simply reports back the information that was disputed without doing a reinvestigation. In a reinvestigation process, the CRA shall review and consider all relevant information submitted by the consumer. So this is why it's important to include lots of details and lots of documents in your disputes. If you have the ability to back your dispute up with documentation, the consumer reporting agency must consider that information, and generally that information is transmitted onto the furnisher. Their failure to do so may in some circumstances be a violation of the FCRA. Again, if the information is inaccurate, incomplete, or cannot be verified, the CRA or furnisher must delete or modify the information to remove the information that is inaccurate, incomplete, or cannot be verified. And this cannot be verified is an important aspect of why parroting is a violation of the FCRA, because it does not actually go through any verification process. Again, we touched on this earlier, but it is important to realize that the dispute to trigger furnisher liability under the FCRA, the dispute has to be transmitted to it from a consumer reporting agency. There are also, let's talk about some claims that might come up in the context of housing. There are inaccurate landlord-tenant debts that are reported. There are false eviction records, false criminal histories. There are also situations where in the housing context, there's impermissible pulls and of course, issues with obsolescence. Most of your clients in the housing context will not know exactly why they were turned down. They may think that it was because of something on their background check, but ultimately they, if they can discover that a consumer report was involved, they should request a copy of that consumer report, look for inaccuracies. From what we've seen, about 40 to 70% of background checks have an error of some kind. Joseph, I'm seeing your question here. How often does the impermissible purpose where dealership is checked before giving a test drive happen? It happens quite frequently, but proving when it happened is a little bit more difficult. Very frequently, the dealership will put paperwork into what the consumer is signing in advance of doing their test drive. And so if the consumer has signed a written authorization, that is, of course, a fine reason to pull a consumer report. Or after the test drive, there is a financing process that the consumer is going through, and it's difficult to know whether the report was pulled before the test drive or after. And ultimately, a permissible purpose includes applying for credit, and that's a situation where the dealership can pull a report. It's also worth noting that paying for a car on a check is a credit transaction for purposes of the FCRA under FTC guidance. So even if your client isn't applying for traditional financing, if they go in and pay with a check where they walk out with the car that day, that is considered an extension of credit until the check clears. And so the dealership can properly pull a credit report at that time. In the employment context are some of my favorite FCRA cases. Joseph mentioned earlier in the chat that he had a situation where a background check was involved. And so many times employment background checks are pulled. In fact, most employment lawyers will tell you that employers need to pull those on a routine basis for most of their employees to prevent negligent hiring claims. And so we see that about 97% of employers conduct background checks on at least some of their employees. Consumer reports in this context can include background checks, reference check services, and credit reports. Generally, a financial credit report should only be pulled by an employer if the potential employee or current employee is involved in financial decisions or financial accounting in the company. But that deals more with an EEOC issue. Let me go back there. There are 3 rounds of notices that consumers should receive in the employment process if something is happening to them that's adverse. First, they should receive a disclosure form when they are authorizing the pulling of a consumer report, including a background check. And so that notice, that disclosure has to be a standalone document. But the only thing it can include, apart from the statutory disclosure language, is the allowing the consumer to sign to authorize pulling the report. There were a couple years ago were quite a few rounds of class actions over these disclosure, this disclosure language getting stuck in the middle of a bunch of other information, not on a standalone page. I've seen situations where this disclosure included a release and waiver of liability under the FCRA, which thankfully is not enforceable if it is included on this as part of this disclosure that should be a standalone disclosure. The second, if there's something wrong with the background check, the consumer or employee or potential employee should receive what's known as a pre-adverse action notice. This notice doesn't necessarily have to be in writing, but generally is, and should include a copy of the consumer report. It should give the consumer or employee the ability to see everything that was told to the employer about that background check. Now, the case law is not exceptionally clear as to how long before taking an adverse action this pre-adverse action notice needs to be given to the consumer. The FTC's guidance has been 5 days, although that's non-binding. Generally, it's supposed to be given to give the employee the opportunity to contest the information with the employer or counteract the information with the employer. Unfortunately, it doesn't give long enough time for them to go through a full dispute process with the consumer reporting agency. Not that they shouldn't do that, they definitely should. And then third, there should be a post-adverse action notice. The disclosure form, like we talked about earlier, has to be clear and conspicuous. The document should include only that disclosure. In practicality, absent situations where there are actual damages, there may be concerns about spokio that we talked about as far as a standing question. And then the 11th Circuit, in the context of the FDCPA, had a fairly damaging opinion for consumers this week, that we're watching closely. We're hoping that that will be looked at further en banc or, through a motion for rehearing. Pre-adverse action, like we talked about, needs to include a copy of the consumer report. It needs to also include the CFPB's summary of rights, and that is something that the CFPB has created under its statutory authority, and you can find that on their website. They updated that last, I think, in September of 2018, making some changes, make sure that the employer is providing the right summary of rights if you're looking at evaluating one of these situations. An adverse action in the context of employment can include firing, demoting, the choice not to promote, the choice not to hire, the choice not to provide raise. And again, the employer should wait before taking further action at generally about 5 days or more before taking a final action that is an adverse action. Post-adverse action is something that is required actually of all users of a consumer report. And so anyone that is using a consumer report should provide a post-adverse action notice to the individual that includes the name and contact information for the consumer reporting agency, a statement that the CRA didn't make the adverse employment decision, and notice that the individual is entitled to receive a free copy of the background check or consumer report within the next 60 days. Always encourage consumers to get a copy of this report if they have the opportunity to. Okay, let's look at the, I'm going to look at the chat box, and then, for purposes of discussion and questions, I'd love to see some people come on and at least unmute their microphones. I'd love to see people's faces if they're willing to come on to video, and I welcome input from any of the other panelists that are on. We've got a few minutes, actually technically 11:50 is the end of my time, but I think we have a minute or two that we might be able to talk about questions here.
Jared, there are a few questions in the question and answer box, and there was a
wonderful.
couple of questions in the webinar, and Caitlin also has her hand up, so I don't know if she has a question, so I would like to invite her, if possible, to unmute her mic and ask her question if she has it. Don't want to step on your toes, but just kind of pointing to lots of interaction here.
Sure. Well, I'm going to start with one of the question and answer boxes, and the question was, what percentage of FCRA cases result in punitive damages awards, and what is the standard for punitive damages under the FCRA? So as far as a percentage, I don't know the exact number. I know that almost all of the significant FCRA verdicts have included punitive damages awards. Generally, the courts are restricting those to a single-digit ratio, something less than 10-to-1 to the actual damages. But the actual damages can include emotional distress and things of that nature. Situations where we've seen juries come back and award punitive damages include the Julie Miller case a couple years ago out in Oregon, where a jury came back at, I think, $18 million in total award. The court, I think, ultimately reduced that to about between 2 and 3 million against Equifax, and then it settled confidentially on appeal somewhere. I would assume somewhere between those numbers. As far as the standard for punitive damages under the FCRA, willfulness is what is required to award punitive damages, but willfulness has been reviewed by the Supreme Court in this context in the, I think it's the State Farm case, but I will check on that quickly, but can include reckless disregard. So it doesn't include malice. It simply includes situations where information is being recklessly ignored. And that can, in some situations, be recklessly ignoring, circuit level case law authority for consumer reporting agencies. As far as the cite to the 11th Circuit decision that raises a Spokio issue, I will send that out on chat or as a response to that answer here in a few minutes. Let's go to other questions. Let's see. Ms. Dunwell, I see a hand up.
My apologies.
Okay.
Jared, I have a question.
Yeah.
This is Joseph. And I put in the chat as well. Is there a difference between hard and soft pulls as far as the FRCPA?
So under the Fair Credit Reporting Act, well, let's talk about what soft and hard pulls are for people not familiar with that. So a hard pull is generally a request for a consumer report involved in the application for credit. And because one of the factors used in scoring consumer reports includes how much the consumer is looking for credit, other requests for credit can have an impact on your score. And those requests for files that do have an impact on your score are considered a hard pull. And so a hard pull is generally in the context of applying for credit. A few things to note to facilitate allowing consumers to shop effectively for credit. Most of the scoring, actually all of the scoring models, group mortgage applications in a 30-day period together to only count as one credit pull, and then auto applications in a 15-day period only count as one credit pull. I frequently get people that call me and say, oh, the dealership sent my information out and they applied for credit 17 times on the same day, and it's going to tank my credit score. And that unfortunately is not the case, even though I am not a fan of dealerships sending that information out and applying at a bunch of different places. That's not going to have an impact on the consumer score. A soft pull can be anything from a consumer requesting a copy of their file or requesting information through something like Credit Karma. It can also include situations where a consumer report is being provided to someone as part of ongoing account maintenance. Many credit card companies will pull a credit report once a month to monitor whether they're going to make changes in the credit line available or make other actions in regards to servicing. Those do not count against a consumer score, but will be shown on the bottom of their consumer disclosure that a report was pulled. Joseph, did that cover that? What we're looking for?
Yeah, that was useful. And I also have a question about this particular situation where I had a client whose background check came back where there was a charge from many years ago on there that was not him. He has a very common last name, and so we were able to make a demand on the agency that pulled it to clear it. So I don't believe there'd be a claim based on what you're saying, right? That basically because they corrected it within 30 days, then my client therefore doesn't have a claim, right?
No, actually, I do think that they likely have a claim. In this situation, the consumer reporting agency, in other words, the background check company, merged two people's identities together. And so I think that there is a very strong argument that they did not follow and ensure, have reasonable policies and procedures to ensure maximum possible accuracy. And so situations where the consumer reporting agency screws up are much easier to pursue without a dispute or even with a correction on the first dispute. Now, let me ask, in this situation, did the consumer have an impact to their job?
This was actually not for employment. It was for an application into a condo association, right, for residency.
Okay, but did it impact them?
Yes.
I would definitely, if it had an effect on their ability to get in, either delaying that process or preventing them from getting in, I definitely think it's worth pursuing. We had one of these that I litigated a number of years ago. We litigated it for some period of time. The CRA, it involved both a CRA and an employer. They came to mediation. They basically gave us the bird, told us to pound sand. We ultimately settled the case a few days for trial in the 7-figure range. Now, granted, that case had some extraordinary wage loss damages, but in this context of if they had a delay in getting into their housing or had extra expenses as part of that, I think it's definitely worth pursuing.
Oh, okay, great. That's good news. Because this has just happened in the last 2 months, and thankfully he was delayed, but now he has been granted access to the association. But in that situation, who is considered, and I want to look, who's considered the furnisher, right? Because it's not involved in a furnisher, right? It's simply the agency.
Well, it may or may not be, and you're not going to know that until you get into discovery on the case. Many times the company that performed the background check is not the one that necessarily collected the information. Companies like Lexus use a lot of third parties to go and gather court data and things of that nature. And so until you get into the inner workings of how they put that together, there may or may not be a furnisher involved. You probably don't have a furnisher claim since it got corrected on the first dispute, but you still have a claim against the CRA.
Okay. Great. Thank you. I was hoping someone else has some other questions as well. I mean, this has been very informative, all of the speakers so far.
Yeah, I would agree. I wholeheartedly think this has been a phenomenal CLE, one of the best that I've seen.
Thank you, guys. I've enjoyed and considered it a privilege to be part of it. David, since we're at lunchtime, I'm going to hand it back over to you. And I know that you mentioned potentially some further questions for our earlier presenters. I'll stay on the line here a few minutes, but then I plan to rejoin about 4 o'clock today.
Sure, there's one more question. I think that just popped up, and I think maybe you're the best to answer it. About original, it says, can both the original creditor and the debt buyer both report on the same account? More specifically, if you settle with a debt buyer and they agree to remove the trade line, can the original creditor continue to report the account?
So Angela, the question, the answer is both yes and no. The original creditor can continue to report the underlying history on the account, but they cannot continue to report a balance once the account is transferred to someone else. And then if the debt buyer agrees to remove the trade line, they don't necessarily have control over the original creditor's reporting. Although, I have seen situations where we have effectively helped people get the original debt off of the credit report, where there's a clear written agreement that the settlement included not reporting it. Sometimes the CRAs will help remove that, but you would want that agreement to very clearly identify the information for the original account. And a lot of times you're going to run into problems with the debt buyer or debt collector saying they don't have authority. They want to make that disclaimer that they don't have the authority to bind the original creditor. And so you'll see situations where they want that specifically in there. If it's not in there, you may be able to get the CRA to remove it as part of a reinvestigation.
Jared, I have a similar question, I guess. I defended is the National Collegiate Student Loan Trust case a while back. And when we looked at the credit reports, there was a prior debt collector and also the current debt collector that were both reporting it. Is that okay?
I think that that is an inaccuracy if to the extent that both the former debt collector and the current debt collector are reporting the same account balance being owed. I think that that is an issue. I wouldn't bring a suit without doing a dispute. I'd dispute both accounts and say, or I'd kind of pick and choose, but I'd probably dispute the earlier collector and say that it's no longer accurate because it's been transferred to another party and not owed or at this time to that debt collector.
So if you do dispute it, because we did, and it came back verified, it was basically just duplicates. It was the same amount claimed, so okay. And
at that point where you have notified the CRA that the same account is being reported twice, you may have a claim against the Consumer Reporting Agency.
Alrighty, I'll give her a call. Okay.
Yeah.
I did have a quick question if it's not too late.
Yeah.
This is Zach McCormick. I'm not sure if you can see me or not, but I had posted this, and maybe Jared, it's not appropriate for your particular presentation, but I thought maybe you'd come across it. I know that, you know, in this day and age of hypothecation where everything essentially is securitized, think like mortgage-backed securities, for instance. Has anyone seen any viable defense bases on this sort of ground? I've seen some arguments being made more in the mortgage-backed security sort of arena, but you know, as it pertains to foreclosure. But I wondered if we were seeing any of this stuff in this consumer defense realm as well.
Cynthia, I'll defer to you on this because it's probably most relevant to debt defense, and you do a lot more.
Yeah, I can't say that I haven't dealt with that. I'm sorry, I kind of zoned out when you were starting, but I think I sort of responded when you asked it originally in the chat. So following on,
Did you?
I think so. I didn't pin you specifically because I've just posted it back to all panelists. So what I understand, and I haven't seen it, and now, okay, a lot of these credit arrangements are actually securitized as well. But what that has to do is the investors are buying the securities are contracts with the owner of the note.
Right.
It's a right to payment. It's not an ownership of the note.
Right. So that was what I had seen in I believe it's out of the Ninth Circuit in California. I could be mistaken, but the gist of it was, you know, for a long time, especially in the foreclosure arena, people were saying things like, well, show us proof that you have the right to foreclose. And a lot of courts were saying, we're not going to pursue that. It's relevant to the consumer side, non-foreclosure side, at least so far as I can see, because some decisions appear to have now said, well, wait a minute, if a note essentially or a debt is securitized, then it's sold to a trust effectively, which would allow the trust to be the owner of the note. And then that implicates the question of who has standing to sue based upon it.
Right.
And more that it's hypothecated and used as collateral, then theoretically questions as to who actually has standing to, and I'm using the word foreclose, you know, generally, is raised.
There was, and I'll try to look into this. There was something with National Collegiate Student Loan Trust recently that came out having to do with if the documents, you know, if the trustee, you know, who has the power to sue under them. And those matter. And the reason why I bring that up is those are big. Some of those are big cases, hundreds of thousands of dollars in some cases that they're claiming on. Not necessarily the same case, but I've seen numerous NCLST cases be filed simultaneously against the consumer. In total, you're talking about, you know, at least $100,000 or so dollars. So those get litigated. And it was a Delaware decision, and they were talking about if the people who assigned the rights basically under the ownership. So there is stuff on that.
I'll look into it.
They could bind the trust, and it was all in the Delaware trust law, which is apparently slightly weird. You know, not like any other normal state, I guess. So there is stuff like that out there. But on the smaller ones, there are other trusts that sue, and it's usually as the trustee is the one who's claiming the right to sue.
Thank you.
Zach, it's David Abrams. I know about 10 years ago, there was a lot going on with April Charney on that area where she was litigating a lot of these cases on the basis of the issue of standing. And I will tell you that I used her techniques. I did not have great success in the courts with it, at least at that point. And I think part of what was going on, it seemed to me like the courts initially, when the foreclosure crisis hit, were entertaining those arguments much more willingly than when things really got hot and heavy. Apparently, at one point, there was some movement by the legislature to actually make Florida a non-judicial foreclosure state because the lenders and creditors were complaining that the foreclosures were getting too bogged down. And at that point, I noticed that the judges seemed to lose interest in those claims. They seemed to want you to be able to show some basis by which you could assert that they didn't have standing.
An affirmative duty. Okay.
Yeah, it actually, I'll tell you the truth. It actually happened in one of my cases where my client got sued by two different entities for the same mortgage, seeking to foreclose on the same note. So that gave me some, I had some good success with that case, but I think that it's I don't know how the courts are gonna, because I think we're gonna see another wave of foreclosures, and it'll be interesting to see how receptive they are to that argument. I think it's a very valid legal argument. I've heard law professors talk about it, but I just found on the ground that the judges seemed to feel like they were under pressure to move the foreclosures.
Thank you.
I'll see if I can find that Delaware decision over lunch.
Thank you.
But also there's usually some other thing that might be related to that kind of issue without making that exact argument as to standing. Like what I've had success with is the name of whatever it is. Sometimes it's very vague. And if you can show that they aren't registered, that they might not be a real thing. Specifically, I mean, I wouldn't go, there's a real risk of like double jeopardy, basically.
Well, it went to your earlier points because when I had to call in because I had an appointment I had to get to, so I wasn't able to see your PowerPoint slides. But you were talking about issues related to, well, basically predicates upon which these lenders would sue. And my concern was when I looked at how much debt is now being turned into securities, bonds, whatever other forms you want to refer to them as. The question that I have is who has the right to sue at that point? Once it's been securitized, once it's been charged off. I have several clients actually who are subject to this, and I've raised many of the arguments that you have raised. And I was curious to see what everyone has discovered on this point because, and I'll have to do my own research. I should have been better prepared, but I saw that the courts kind of to the previous gentleman's point, don't want there to be an answer that results in the debt essentially being unrecoverable. That's clearly something the courts are opposed to, but it seems like actually the pendulum may have started to swing towards that because of the fact that there have been so many of these hypothecations, these debts being used again and again and again, sometimes thousands of times as collateral. One debt being leveraged thousands of times, creating essentially the impossibility that anyone could ever actually claim to have the right to foreclose, even in situations where there was no charge off. But I'll look into it, see if I can maybe send it to someone.
I would kind of focus on if you find other cases like one David was mentioning, or just other attorneys, like find those cases and say, look, here's an example of what happens when we're not careful about this. They can get sued by somebody else for the same thing. And there is, you mentioned it, so I'll follow up on it. I'm careful about what I say about judges, but you got to keep in mind when you're doing debt defense, 90% of these are default judgments. Judges are very used to signing things that are based on very scant documentation and coming in and trying to say, oh no, your argument really is none of these are they're on a motion or dismiss. None of that stuff you sign all day long is supported by anything. That's a hard thing for them to get over. And then with what David was also saying regarding the judiciary kind of turning when it looks like the legislature might be taking away some of their jurisdiction. There's all kind of delicate things you get to tiptoe around doing debt defense. The presumption, I mean, of course, the plaintiff has the burden, but in debt, we all have this kind of, I mean, that's my profession, so I kind of get this. There's just this assumption that this person doesn't pay their bills and this person owes this money.
Yeah.
That's underlying it all, and you got to get like past that on other grounds.
I don't want to keep people too long for lunches, so I want to encourage folks that want to head off to lunch, and I'm going to grab some lunch here in just a minute. We're going to restart at 1 o'clock sharp, so come back, and we're going to have I mean, we've already had some great speakers. Jared's talk was fantastic. Cynthia, yours was great this morning. This afternoon, we've got Bob Murphy, who's going to talk about auto repossession. If you've never heard a Bob Murphy lecture, you're in for a ride. He's a very dynamic, interesting speaker. So he'll be starting at 1 o'clock. And then Robert Churchill, who knows more about landlord-tenant law than anybody I know, is going to be there at 2 o'clock. And then I'll come in and talk to you about some bankruptcy stuff at 3 o'clock. And then open panel discussions at 4 o'clock. Zach and Cynthia, one thing that I do want to say about the debt collection thing while we are talking about it is something that I did in a case not too long ago was there's an FTC report out that shows that Florida is, they get more complaints to the Federal Trade Commission about debt collection abuse out of the state of Florida than any other part of the country. And I showed that to a county court judge. I included in a motion I drafted. And it was very interesting because I saw a very distinct shift in the way that judge looked at my client's case and our fighting that case. And we ultimately prevailed in that case. And I really think that opening that judge's eyes to the fact that her courtroom is used by dishonest debt buyers and that there's a potential for fraud happening in her courtroom really made a difference in how the judge regarded the case.
Wow.
That's
I hadn't even thought of that.
Good job.
Yeah. So, all right, I'm going to go have some lunch. You guys go eat, and we'll be back for a great afternoon. And thank you to all the speakers.
Bob Murphy. Oh, you guys are recording me. I'm an attorney down in Fort Lauderdale, and I'm dressed very casual today. I apologize for that, but I wore a suit 4 times this week, and today's a Friday. My practice is almost exclusively consumer litigation. I do individual and class actions, and I'd say about 1/3 of my practice is outside the state. I litigate pretty much anything that involves consumer matters. I have co-counseled with several dozen legal services organizations, and including at times community legal services in Mid-Florida. My presentation is on, the title is Post-COVID-19 Auto Repossession Litigation. I apologize to anyone who attended the auto fraud training at NACA, National Association of Consumer Advocates, earlier in June, because this is going to be a repeat, except I'm going to add a couple of things that weren't part of that presentation because it wasn't directed towards either post-COVID-19 issues or some contemporary events that just literally happened in the last 2 months. So before I begin, I'm going to do my spiel about disclaimers. I am renowned for being really a snarky person. Some people call me an ass. And I make a lot of remarks that are meant to be funny, sometimes sarcastic. If I do, I'm not trying to defame anybody or any company. I do this largely because I don't want to get sued if I'm having a CLE presentation outside the state of Florida. So what are we going to talk about? Introduction. We're going to talk about the problem. And I'm going to add some things into it that are related to COVID-19. part two is developing a repossession practice. That's more just, what to expect with respect to clients. And I'm going to do from the hip comments about COVID-19 related clients. People are having or will have financial difficulties in the future, and have their vehicles repossessed. And I'm going to do an overview of the toolbox. Primarily, it's Article 9 of the Uniform Commercial Code, and we're going to talk about some other stuff. And then I'm going to talk about defending deficiency actions for fun and profit. For those who are legal services, I guess it's actually neither. It's neither for fun or profit. It's because you've got someone in your office present themselves and needs legal help, and you're doing legal triage. I refer to defending the legal deficiency actions as reverse engineering the auto fraud. I do a lot of auto fraud as part of my practice. I have www.autofraudlawyer.com, much to the dismay of some law firms like Morgan. And I'll talk about class action repossession practice. I'm actually not going to talk much about that at all. And then we're going to have a bonus, my repo practice tips. Some just observations that I've had as a result of doing this for, I guess, about 20 plus years. So part one, the introduction, meet the four horsemen of the COVID-19 economic apocalypse. I run in the morning and I'm listening to podcasts. A lot of the podcasts I listen to are shareholder meetings and quarterly profit meetings of finance companies, because my practice lends itself to doing class litigation. I kind of want to know what the other side's discussing, and every once in a while they'll mention some class action without mentioning a specific case. And I may have a smile on my face if it's one of my cases. The first horseman's houses, and I'm not dealing with that, but they think that right now the forbearances as a result of COVID-19, it's about 15%. Plastic credit cards, according to the Federal Reserve, our debt load is $1 trillion for credit cards, which I guess in a big scheme of things, considering that the initial stimulus package was initially slated to be $2 trillion, it's not a lot of money, except when you realize that the cost of fighting World War II was $2 trillion. As of when I pulled this a month ago, we're pushing about $8,600 in credit card debt per household. Third horseman, student loans. 51% of student loan borrowers of every age haven't really done much to reduce their loan balances in 5 years. And I know we haven't included student loans in the program that David and the others put together, mostly because it's beyond what we can cover during that one day. And then the fourth horseman is auto loans. Seriously delinquent auto loans, $68 billion, and it jumped 5% in the last quarter. So what I've learned from listening to podcasts in the morning during my run is that the consumer finance industry related to auto loans doesn't know what's going to happen. Like many Americans, they're in the same boat as we are. And when you have in the same disclosures by the business that, in like the first 1 minute of the discussion, the officer will relate that they think that there's going to be inflation, and then 5 minutes later they talk about deflation. You can't have inflation and deflation at the same time. And when they talk about having severe inflation and severe deflation in the same discussion, it's obvious that they don't know what's going to happen. The discussions I've listened to, and from what I can glean from accessing information on the internet, is that they don't know whether or not they should repossess cars or not repossess cars. And this isn't related to COVID-ish directly, and I'll talk about that later, I think, when we get to part 3. I'm just talking about the macroeconomics of the auto finance industry. Their primary concern right now with respect to repossessions isn't so much that they want to be nice to people, that they care about their consumers. There is, I guess somewhere in their fiber there is that interest. Their primary concern now about repossessing collateral is whether or not they can unload the vehicles at the auctions. The 2 primary auctions are Manheim and Odessa. We've got about 24 auctions in Florida. The big ones are Orlando, Jacksonville, and Miami. And the discussions I've listened to and the reports I've seen is that they're concerned that there's going to be a backlog of repossessions. There's a backlog of vehicles that they would have repossessed during the last quarter, and we're beyond a quarter now. We're in the 4th month of this, and so they've got 4 months of vehicles that haven't been repossessed. And I'm speaking specifically of prime lenders. Prime means under 18%. Subprime is typically over 18% annual percentage rate or interest rate. Prime lender is banks like Bank of America, lenders like Capital One, lenders like Ford Motor Credit. They have been taking a hands-off view on taking collateral. If you go to their websites, they modified their websites in the first 2 weeks of March to reflect an interest in working with people and giving forbearances. And I'll talk about some of the problems coming from these forbearances in a moment. But the current concerns right now is that it's back to business to a large degree in terms of recovering cars. And they are concerned about whether or not the used car market is oversaturated, both with respect to the sheer number of cars that may end up at the auctions. And there's another problem in that Hertz filed bankruptcy about 6 weeks back. They filed a Chapter 11. And Hertz unloaded a large amount of its fleet, especially the prestige cars. And they did it both to raise cash and because the need for rental cars dropped significantly with people not traveling. So the Hertz dumped so many cars on the auction lots and these cars are in largely in better shape, that they can't, they're concerned about having the ability to liquidate the cars. And plus there's a problem in that consumers are afraid. They're afraid because they've lost their jobs or may lose their jobs. And the uncertainty in the future has caused car sales to plummet. These are the macroeconomic issues that are the backdrop. And so some of the concerns that we have, the lawyers that focus on this part of consumer law, is whether or not the decision to repossess when there isn't a ready ability to liquidate collateral, is that commercially unreasonable? If they're repossessing vehicles that are going to be put into even worse fire sale than dealer-only auction, is that commercially reasonable? Well, I don't have the statistics to support anything on this, but these are things that when you're having a client come in to discuss, how do you deal with a auto deficiency matter, or if their car just got repossessed and hasn't been liquidated. These are things that should be in the back of your mind. Developing a repossession practice. What's the benefits of auto repossession litigation for the client? Obviously, their objectives are to avoid a potential deficiency. I trust that most people know what that means. A deficiency is the difference between the amount of the outstanding loan indebtedness together with recovery expense, late fees, reconditioning expense, minus the proceeds from the sale of the collateral. I used to be able to pretend or feign that I was an idiot when I'm talking to a lawyer who may have had the misfortune of suing one of my clients, and I'll go, well, they took the car back. Why are you suing them? Just to mess with the other lawyer's head if they don't know who I am. And one lawyer did that to me, and this is going back a few years, I loaded up my counterclaim that was a class action in the fax machine, and I needed to have him confirm the number of repossessions he was involved in so I could figure out the numerosity to bring the claim against the, and I think that was SunTrust. So this is going back to about 2005. And then he got the facts and then he called me yelling at me. So second thing that most clients want is clearance of their credit report, or credit amelioration, as I like to call it, and recovery of damages, lost down payments, statutory damages, etc. When you are handling one of these cases and you are fortunate enough to get a resolution that has the first, has some type of potential deficiency avoidance, you need to be mindful that together with that, you need to request, as part of the settlement, clearance of their credit report. This becomes more of a problem when you're having a debt buyer buying a auto deficiency because the original creditor, let's say it was Bank of America again, is not the entity that is bringing the lawsuit against your poor client. It's something, usually it's like Cascade Capital or Portfolio Recovery. And Portfolio Recovery, Cascade Capital will agree to delete what they're reporting, but they have no authority to delete the information that's being reported by the initial original creditor. So just need to have that in the back of your mind. There's some limitations on what you can do. For the attorney, and I'm speaking largely from the view of a private attorney, I know we've got a mixed group listening to me, and I hope there's nobody that I have cases against. Source of prospective clients, skill enhancement opportunities using the FTC holder rule. When you have a finance agreement, a retail installment sales contract specifically, if you look at it, they're all ostensibly the same everywhere in the country. I've probably looked at 10,000 in my lifetime. On the back side of the retail installment sales contract, if it's a 2-page document, or if it's some other, like Westlake uses I think it's a 9-page retail installment sales contract. And if I don't remember, remind me to tell you why I think Westlake and some of the other subprime lenders use these multiple page front side only contracts. But somewhere in these retail installment sales contracts, there will be a disclosure, a legend, if you will, that says the holder of the contract is subject to all claims and defenses that the consumer, your client, had against the original credit seller, and that's going to be the dealership from whom they bought their vehicle. So whatever the dealership did, you can either defend a deficiency action or alternatively advance claims against the finance company or the debt buyer that the consumer had against the original credit seller. And this is significant because it means that your client can actually come out of one of these auto deficiency cases with recovery of what she paid to both the dealership and to the finance company if you have a claim against the dealership that would have stuck. It's only to the extent of the amount that is owed under the contract or what has been paid. In other words, you can't exceed that. I apologize, my phone's ringing and someone picked it up. The third is simplicity of legal area. I am not the brightest bulb. I've got some skills, but I'm not brilliant. And if I could do a pretty decent job in these cases, I dare say that everyone listening to me can too. And then fee generating potential, especially in class litigation. I can say that I've done pretty darn well with this, but it's something that you develop over a period of time, and the skill set is acquired by just doing one case after another. And plus, I have the benefit of doing auto fraud litigation. So that means I have the ability to know how to use the FTC holder rule to bring claims against a finance company for odometer fraud. And it usually shocks the lawyer bringing the case against my client that I counterclaim under the Federal Odometer Act until they realize that, the claim is valid and it's something that the contract permitted. Overview: auto repossession clients, parties, the client. Repossession clients are on the spectrum, like everything in life, from the so-called grade unwashed subprime consumer to the sophisticated prime consumer. I've had people who have hired me to defend them in auto deficiency cases when their Porsche got repossessed. One case in my mind is Ferrari. But most of my clients, fortunately, I say this fortunately because I do appreciate people who don't think they're smarter than me, and that don't have a feeling of entitlement or a gold spoon in their mouth or silver spoon in their mouth. The prime and subprime consumers have dramatically different objectives usually. The prime consumer typically is usually concerned with trying to get their credit restored, while a person of lesser means may seek damage recovery. The repossession parties, there's two different types of defendants. The small player defendant. As the dark side goes, small players, buy here, pay here dealerships, captive finance companies, which are typically linked to a dealership, and regional finance companies. Their compliance with state and federal consumer protection laws are usually lacking, especially with respect to Article 9 compliance. Captive finance companies are common in some parts of Florida, especially in Miami, because the dealerships like to create a separate standalone company to hold their loans for two purposes. One is so that if they sell a vehicle after repossession, that they have the ability to bring a claim against that consumer in court to recover a deficiency, even though they may have flipped the car right back to the dealership that they own to sell to some other consumer. In other words, it's called revolving repossessions or churning. Both are potentially violations of state and federal law, depending on how they do it. And the other reason why they have a captive finance company, which is basically a sister affiliate corporation that holds the paper, is to provide at least an appearance that there is another independent third party collecting the loans, so that the consumer's car breaks, the consumer isn't going to go to the finance company and say, hey, finance company, my car broke, you need to fix it. The finance company will tell the consumer to go talk to the dealership, even though it's the same people running both. And the other reason is because when the vehicle is repossessed by the finance company and the consumer goes to the dealership, the consumer is told by the dealership, well, it's the finance company's position, so that our decision to take your car. And so they use this, appearance of that they're not related to foster a more efficient way to deal with consumers. And the problem with small player defendants is that they typically use non-specialist attorneys, meaning that jack of all trades, masters of none. And a lot of times I have to deal with lawyers that do criminal litigation. They represent, people in jail. I think there may be a connection between the buyer payer dealerships and criminals, and these lawyers are pains in the butt. I have more problems with lawyers that don't know what they're doing because they don't have the they don't have the intellectual honesty to admit they don't know what they're doing, and they just make things much worse. They don't know the law, and oftentimes they learn at your expense, not realizing that a lot of the consumer laws actually do operate black and white, and there's a lot of case law to support it. In contrast, we have the big player defendants. Large banks and finance companies are characterized by pretty set repossession practices and procedures. It's very difficult to find a defective form. Let's see, I apologize. I actually edited that the other night and I forgot to put in what I was going to tell you. I was going to tell you that I had recently found is I finished a case in New Jersey against TD Bank last summer, and TD Bank is a very large bank, and they totally messed up the post-repossession notices. And every once in a while, you'll see a large lender just mess up their paperwork, largely because they have institutional amnesia. And with TD Bank, that was the second class action I had filed against that company. One was in Florida, the other one was in Jersey. And sometimes you find that same company 5 years after you sue them, again, not complying with the notice requirements of the Uniform Commercial Code, specifically Florida Statute 679.614. And I'll go over the statutes in a second. But the good thing, and perhaps the bad thing, is that the big player defendants are represented largely by large or national law firms. And to a degree, they tend to understand their clients' risk. They understand that the way the laws would apply to their clients. But every once in a while, that large or national firm may have brought their client into error by giving them faulty legal advice, and they oftentimes become very difficult to deal with. But there is a commonality between small and big player defendants or plaintiffs, and that's the consumer is the debtor, and it's difficult to accept any outcome that doesn't involve the consumer paying money to the business. Those of you that have handled consumer litigation matters or have represented a consumer in, let's say, a collection matter, I think you're going to have or will have heard from attorneys Churchill and attorney Turner. And it's really difficult for a lot of companies to walk away from what they perceive as an obligation that was broken by your client. And it's even more difficult for them to accept maybe having to pay your client money. But you know, they have to be big boys and girls and accept what comes to them. So part 3, the UCC toolbox. The Uniform Commercial Code has been adopted by every state in the country, and because it's a uniform statute, it pretty much is the same in every state, with some major exceptions in states like Illinois doesn't have a mechanism to get aggregate relief, but by and large, they're all the same. That means you can draw upon the body of case law from around the country with respect to the Uniform Commercial Code. If you can find the section that was that is applicable to your legal problem, you draw upon the UCC case law from other states. A really good resource is the National Consumer Law Center's Repossession Treatise, which if I would go into my library, I'd pull it out, show you. The old book, it's beautiful. I may have one I can send someone who's working for legal services. I won't send it to a private attorney unless you're my buddy. I've got a collection of them. And the book is like the treatise of how to help someone in a repossession. The starting point always with repossessions is whether or not there is a default. If there is no default, there is no right to repossess. The problem is that the term default is not defined in the Uniform Commercial Code. It is, however, specifically stated in 679.901, or wait, 674.901, that you have to have a default to take a person's vehicle. But it's not defined, and it's typically determined by the contract terms. And default is a cause for acceleration. The typical default events are much further beyond just simply the person didn't make her payment. Obviously, non-payment of installments is the most obvious default, but loss or damage to collateral is also a default under the retail installment contracts and under case law. Loss or damage to collateral could mean things like your client got into a car accident and didn't have insurance to fix her car. Bankruptcy of a debtor is a cause for default after the 2005 amendments to the Bankruptcy Code if your client chooses not to reaffirm her debt in a Chapter 7 bankruptcy, or if it's not included in her Chapter 13 and she's out of her bankruptcy. From a purely technical standpoint, a creditor can repossess collateral. Insurance lapse is probably the second most common instance of a default for people who are financing their vehicles. And insurance lapse means that they're driving around even for a day without insurance coverage. You have to ask the client. Clients always tell you that they're current, but they're not. Impoundment of the vehicle is also an instance of default. If the client was pulled over and she was, let's say, got a DUI, I'm not picking on women right now, it's just rolling out of my mouth. if he or she got their car repossessed as a result of a DUI or a criminal offense, that's right, that was impounded as a result of a DUI or criminal offense, and it was sent to the pound, if you will. The pound sends a notice to the secured creditor, and the secured creditor could technically repossess the vehicle immediately. Use of vehicle in crime, that's obvious. And here's my first practice tip. Beware the self-professed current client. Every client wants to present themselves as being compliant with their contractual obligations after the car is repossessed for no other reason than to have them, to allow them to put a good face on when they're approaching to help them. They don't want to say that they broke their contract. They want to come up with any reason to explain away what may have been a legitimate reason for the repossession of the vehicle. Clients who claim to be current are typically not. There may be hidden defaults like insurance lapse or unpaid late fees. Always get the account history from the finance company before you go very far in the representation of a person who says that they are current in their car payments. Second tip, in order to get the account history, you can send a letter, and the letter can be just simply, I would like to know what I paid. It's can be a request for an explanation of deficiency or request for an accounting. Under 679.625, if they fail to respond to that request, it's a $500 statutory damage claim. So you have it if they ignore you, and a lot of subprime finance companies and a lot of buy here pay here dealerships will ignore a letter even from an attorney asking for an accounting. It's a tool, and everything counts. You can't get attorney's fees, but you might have the ability to recover attorney's fees under a different section of Florida law, which is Florida Statute Chapter 520. Chapter 520, which is the Retail Installment Sales Act, says that a consumer can ask the lender for an accounting. And if they fail to respond to that accounting, and if that failure to respond was willful, and that's the furry part, is willful. Willful is not negligence. It means that they purposely decide not to respond to your request for an accounting. But if they fail to respond to that accounting, the consequence to them is pretty severe. It is the finance charge under the retail installment sales contract. And with some of these subprime lenders, as I'm going to mention repeatedly starting from now, the finance charge for subprime lenders can be significant because they're charging interest at over 18%, as much as 28, 29% in Florida for used cars. It can be biblical justice. That is, if you can prove up that it was willful, at least for the purposes of Chapter 520, which is a Retail Installment Sales Act. Self-help repossessions. Self-help or involuntary possessions are treated, did I say that wrong? Yeah, so are treated the same as far as deficiencies are concerned. It should have said self-help or involuntary voluntary possessions, and I did that wrong. Voluntary possessions, when your client lets the car go to the lender, gives up the car, brings it over to the car lot. A voluntary possession is the same as if it was involuntary. A lot of consumers have an idea that if they're nice to the lender, they get a special benefit, and they may not be sued, or it may not show up on a credit report as the same derogatory thing, which is the repossessions typically reported as an I-9 on most credit reports, which after bankruptcy and a foreclosure of a home, a repossession of a car is the most significant thing you can have that's adverse to the consumer on the report. But self-help repossessions, when the lender says, hey, I'm going to go take that person's car, that often presents opportunities for distressed consumers. I use the words opportunities for distressed consumers kind of euphemistically because it's more of a, sometimes personal injury lawyers wouldn't be around if there weren't people who were injured. Lawyers that do repossession litigation wouldn't be around unless there were people who were victims of self-help repossessions if there was a breach of the peace. So, do I pray for things? Sometimes I do. The repo code. All right, I'm a person who grew up in the 70s and 80s, and Repo Man, starring Emilio Estevez, was one of my favorite movies. Punk rocker taking vehicles together with the old man whose name I forget. But in the middle of that, there's a section that I oftentimes have on a video, and I forgot, I didn't do it here. But the repo code was, I don't break into a car, never hotwired a kid, I never broke in a trunk, I never harmed any personal contents, et cetera, et cetera, et cetera. The repo code. Not many people got a code to live by anymore. Unfortunately, the repo code is forgotten a lot of times when a recovery agent attempts to recover collateral. A breach of the peace is a fatal creditor mistake. It's the most important restriction because the creditor cannot breach the peace while exercising self-help remedies. If a breach occurs, statutory damages and defenses flow. When you have a client present themselves and their car got repossessed, or they're getting sued for a deficiency, your analysis should start off with, was there a breach of your contract? Why did they take your vehicle? I think the way to frame it when you're talking to someone is, what did they tell you the reason was for them taking your car, as opposed to what the client's perception of the reason why was. You'd rather know what the other side thinks as opposed to your client's subjective view. But if there's a breach of the peace, and then you go start talking about, well, how did the car get taken? I'd say about 95% of the time, the consumer is just going to tell you the truth, and the truth will be, I was asleep at night. I woke up, went out to the parking lot of my apartment, car's gone. Well, there's no breach of the peace typically associated with that, unless the car maybe had been in a garage or something. But if there was a breach of the peace, then under 679.625 of the Uniform Commercial Code, the damages are the finance charge plus 10% of the principal indebtedness, which can be significant, which can oftentimes exceed the claim deficiency by a large margin. And I'll repeat that. It's the finance charge plus 10% of the principal indebtedness. So what is a breach of the peace? It's not defined in the Uniform Commercial Code either, but typically it's bodily harm or the threat thereof. Trespass, breaking a curtilage, opening a fence or garage, a repossession over objection, deception sometimes. Trespass. Is it trespass to take a person's car parked in his or her driveway? No, it is not. There is considered to be, and this is Florida law, as well as the law of other states, a zone where taking a vehicle that's parked in a driveway is considered to be fair game. It's taking a vehicle from a zone where it's likely that the owner of the car is going to respond with violence. A secured creditor is liable for all acts of the recovery agent. And here's a hypothetical, and I apologize for, this is my favorite hypothetical. Joe Dirt finances a $50,000 SUV under retail installment sales contract with a $23,000 finance charge. Joe Dirt ends up in jail because he's Joe Dirt. While in jail, the SUV driven by the pregnant cousin of Joe Dirt, Jill Dirt, is in an accident where it's not an accident, but the recovery agent rams the tow truck in the SUV and throws Jill Dirt onto the street. Who is the better repossession client? And Jill Dirt's not hurt. Who would you want to represent? This is a hypothetical, but it's actually a true story. It's a case I handled. The names are all obviously different, and but my client was in jail. I was having lunch with a local trial attorney, and the trial attorney knew I had done repossession cases. He threw this scenario at me and asked me, what do I think about Jill Dirt's case? What do I think it's worth? And I gave him an opinion. I said, was she hurt? No. Did anything happen to the baby? No, she had the baby. Baby's fine. I go, well, who's representing Joe? He goes, Bob, you weren't listening. He wasn't driving the car. I said, I want to talk to Joe. So I went to Broward County Jail, met him, signed him up. Well, I got him to invite me to go meet him. I'm not an ambulance chaser, that sort. And when Joe Dirt got out of the jail, he got a pretty substantial check because under this factual scenario, the statutory damages were the finance charge, which is $23,000, and 10% of the $50,000 amount financed. So it was a $28,000 amount of check that he got from just being in jail and the recovery agent doing what the recovery agent did. So that's an example of how statutory damages would typically work. I'll have maybe about 2 minutes. I'm looking at my clock. I do want to talk about some concerns that are coming up with respect to statutory damage claims. The notices, every aspect of the sale of the collateral has to be commercially reasonable. That means time, place, manner, and this is one of the issues about the post-COVID-19 or COVID-19 repossessions is it commercially reasonable to take a car that you can't sell? Notice of sale under both 9613, it's 679.613 for Florida, and 614 have the minimum disclosures, and many creditors haven't revised their notices in the 19 years since it was revised by the Florida legislature. If the required disclosure missing, the sale is commercially unreasonable as a matter of law. That is actually contained in Florida statute section 679.614 in the comments section, where it says that the required disclosures are missing, the sale is commercially unreasonable as a matter of law, which means what? The burden shifts to creditor. Statutory damages is a set-off or counterclaim, and you can potentially get summary judgment. Most of the time I get summary judgment on these cases. Under the Uniform Commercial Code, the notice must have the identification of the creditor, debtor, collateral, method of any intended disposition, disclosure of right to accounting, and charge of any for same, public sale, time and place of auction, if private sale, the time after which it will occur. And here is the first one, the uni notice. A notice that fails to identify whether the sale is public or private is fatal. This is a very old, oh shoot, where'd it go? Sorry. This is an old notice from affiliate finance company. And you'll see if you read it, it mentions inside that you are hereby notified that the affiliate finance will sell your vehicle private sale or private public auction on or after 4/4/2003. I am choosing very old notices for reasons connected to the fact that I don't want to pull a new notice up because I may have cases going on. But this was a defective notice and ended up being a modest class for Miss Austin as a class rep. Second notice requirement, with consumer goods, they have to describe any liability for deficiency, and it has to be a description. So it can't just say, you may owe us money. It has to be a little bit more than that. Description means that they have to provide more content than just you may owe us money. A telephone number from which the amount must be paid to get the car back, telephone number, mailing address from which additional information is available. This, believe it or not, is a notice of sale from United Auto Credit, which is a fairly large finance company based out of California. And it was about as botched as it can be. This ended up being in federal court. And anytime you see something handwritten, you know you got a problem. But in this particular instance, Judge Altanaga found the notice to be defective as a matter of law because nowhere on the notice did it have a telephone number. And it also didn't disclose a right to an accounting. You'll see that there's a part here. I don't know if you can see my little, it tells what is owed, but it doesn't tell the person that they can get a disclosure of how they came up with that. And disclosure of how they came up with it is an accounting, which means a disclosure of the payments made, credits, and charges against the account for, let's say, late fees, accrued interest. The changed our mind notice is a notice that says that they're going to do a sale of a public notice, the public sale, and they do a private sale. And it's a UCC violation. Either or. This is a Westlake notice, and those of you that have had Westlake cases know what I'm talking about. It's a big company. And so Mr. Ray got this, gosh, this is an 18-year-old notice. So this describes a public sale. And this is a perfectly good notice. It complies with the safe harbor form under 679.614. If you look at the statute, it actually has the form they have to follow in it if it's a public sale, and the form they have to follow if it's a private sale. This notice describes a public sale. There's a problem because Manheim never does public sales. Manheim does private sales, which are dealer-only auctions. You got to have a dealer license to go to the auction and bid. And for those of you that don't know this, almost every single sale in Florida by major finance companies is going to be a private sale, dealer-only auction. We have only private sales in Florida unless it's something very unusual. Very, very few states mandate public sales. Ohio has a public sale requirement. Maryland's got a, Maryland, I shouldn't quote Maryland right now, but I've done these cases and I can tell you that Florida, we don't have public sales of vehicles or boats or anything. And this, I was probably the only person that knew they didn't have a public sale. I got an affidavit from Manheim because they were angry because not only didn't they have a public sale that day, they weren't doing anything at all for Westlake at that time. Anticipating your questions, a dealer-only auction, they're private sales. Despite the fact that vehicles are sold at basically a fire sale, you know, you're not getting real good value. And these are considered to be commercially reasonable in Florida. There is no premature termination of redemption rights. The consumer has a right to redeem her car or his car anytime prior to the sale of the collateral. There are a lot of notices, and this is a common problem with notices that are sent to consumers. The notices fail to tell the consumer that she has a specific time period to get her car back. They'll say, you have 10 days from date of this notice to get your car back. If it says a definite time to get her car back, it's a violation of Article 9. But don't be confused. It usually says that they'll sell the vehicle after a period of 10 days. That is a notice that's compliant with the law because they're telling you the time after which they're going to do the private sale. And 10 days is not mandated in Florida. States like Ohio, Ohio is the only state that's adopted the 10-day rule for consumer transactions. We have a section of the Uniform Commercial Code that says that 10 days is considered to be the minimum for commercial transactions. So obviously a consumer transaction should be, something more than 10 days. So this is a Unibank notice. This notice said in the middle of it that you have a right to get the collateral back. I think it said 10 days from the date of the notice. And this is Delta Finance. They limited it to March 17. Waiver of notice, there's no pre-default waiver of notice. Any waiver must be in writing, signed by the debtor after default. I had to go to the 4th DCA in a case called Jackson versus Southern Auto Finance to demonstrate to the defendant that the statute says what the statute says. Voluntary possession is not a waiver. However, if your client signs a document after she gives back her car voluntarily that says, I waive my rights, and it says, I waive my rights to get notice, that's effective to be a waiver. The timing of the notice must be 10 days, must be reasonable notification. The safe harbor form sets 10 days before the sale. Here's a practice tip. If your client has the notices, get the notice and put it in some type of plastic sleeve. You don't want to get coffee on it because it's important. It's a piece of evidence, and you should get the envelope as well. The envelope is important because sometimes they're postmarked so that it was not put in the mail for 6-7 days. The failure to provide the mandated notice results in statutory damages, again, of the finance charge, percent of the principal indebtedness. Statutory damages are not discretionary. This is part of 679.625, which is the civil remedy section of Article 9. And it says, any violation of Article 9, every noncompliance in consumer transactions results in liability, regardless of any injury that may have resulted. that means you'll get statutory damages even if your client was absolutely totally ignorant of the notice of sale, didn't look at it, threw it away, burned it. That's because the consequence of taking a person's car is pretty severe. Consequence of selling the car is pretty severe. And because the state legislature said, look, unlike a house, we're not going to require you to foreclose on that car by going through court processes. Instead, we'll let you liquidate it because it's a car. It's going to depreciate because it's a car. So if you go ahead and dot your I's and cross your T's and send the right notices out, you can go right with God. And notification in consumer goods, any notice of sale, notice of disposition that lacks any of the information in the statute is insufficient as a matter of law. There's no trial, and obviously it sets it up for summary judgment. Post-repossession notices, really the only important post-repossession notice is a deficiency notice that requires an explanation of deficiency, how they calculate it, before they start collecting. They don't have to send this notice of deficiency unless it's asked for by the consumer or the secured creditor starts collecting on the debt. In other words, if they're not going to collect on the debt, they don't have to send it unless they're asked for it. And they got to state and order this stuff. And I would recommend you just look at 679.616, compare the notice, compare it to the statute, and you got you can determine you can determine if it's compliant. What's a violation worth? It's $500 if it's part of practice and pattern. If they send a defective post-repossession notice, post-sale notice, that is a notice of deficiency, but it's only if it's part of practice and pattern. But since it's a form and all the forms are the same, they say the person owes $2,000 of deficiency and there's no disclosure that what they sold the car for, then it's a form, it's defective, you can sue, all right? Right to request explanation, I went over this before. And after repo, you can send a stop letter. Worst can happen is they will violate the law, or they'll comply with the law. All right, so I have got 8 minutes, so let me go through this quick. We have an anti-deficiency statute in Florida that applies to high interest rate loans. It's under Chapter 516, and a lot of people don't realize it, but there is no deficiency if the amount owed at the time of the default was under $2,000. You don't see too many auto deficiency cases that are being filed for people whose loans were if they owed less than $2,000. If it's more than $2,000 and it's a high interest rate loan over 18%, it's a special usury statute. A special usury statutes for prospective vehicles, there's 2 of them. Chapter 520, which is the Retail Installment Sales Act. That's what most lenders think about. That's what most car dealerships and auto finance companies know about. But there's also Chapter 516. Chapter 516 is Consumer Finance Statute. It's also the small loan statute. If it's under $25,000 and 18% interest, and the car is repossessed, the deficiency is based not on the sale proceeds, what they get from the auction, but fair market value of the collateral, and it's determined by the statute. It can include the evidence of it is periodically published trade estimates of retail value is presumed to be fair market value. This is important stuff. Retail value means that the consumer has the benefit of the value of her car as it is in the market being sold to consumers. This is a statute that was created largely to prevent revolving repossessions, which I went over a minute ago, where companies are selling cars repeatedly and repossessing them and then selling it back to their dealership that they own and then suing the consumer for the made up deficiency. And to a large degree, people sometimes forget about it. If you're going to have a Chapter 516 anti-deficiency issue, before you start tinkering with it, please call me. There are some nuances in the statute that may not be readily apparent. I've had to brief this in more than one instance. There's issues concerning Chevron deference, which for those of you who don't know what that is, you need to ask me what it is. It's a state's Chevron deference issue that's based on some administrative rulings that you need to be very familiar with. It's based on parity, and those of you who do know what Chevron deference means in the contents of regulations and interpretations of statute by legislative agencies, you know, there's lots of stuff when you argue that sometimes are lost on the masses. So the UCCMO is defective notice of sale, failure to safeguard collateral, use of collateral. That means you're driving the secured creditor is driving the collateral through the turnpikes and stuff. Failure to advertise, failure to recondition, delay in sale. And if you see, that's 6 things that you can inquire when you're representing a poor consumer being sued for a deficiency. I'm not going to go. I got only 5 minutes to finish this, so let me spin. So what's the effect of not having compliant notices of sale? All right, so here it is. A non-compliant notice of sale or non-compliance with Article 9, some states it's the absolute bar. The secured creditor cannot get a deficiency. Okay, those states are not Florida. Okay, we are a rebuttal presumption state, which means that the secured creditor now has a presumption to prove that what they got at the dealer-only auction was reasonable within the range of what they would have gotten anyways if they had to comply with Article 9. So I am at the end of my presentation. I did not go through a lot of the stuff that would otherwise go through in terms of I'm stopping the share. So David, you can just see me right now, right? You're not seeing like my work on the screen, right?
Yes, yes, I can see you.
Okay.
I can see you.
So
you do have a question in the chat.
yeah, so I'm not yet finished. So when you get a auto deficiency case, am I allowed to have 5 more minutes, David? All right, don't worry about it. I'll take it. So when you get a person come in your office and she's had her car repossessed and she's being sued for an auto deficiency, you go through an analysis of, you know, were you current, you know, what was the breach, was there a breach of the peace? Look at the notices of sale, look at the notice of deficiency. If that's all compliant, then you shift your focus to what did the dealership do? And did the dealership commit a fraud on your client? I cannot do an auto fraud presentation today. But if it's a used car, there's usually something that you can glean from the purchase and finance papers, or at least a retail installment sales contract, that will let you think about maybe, was there something the dealership did that cheated your client? And I always tell people, lawyers, if you're doing one of these cases, you need to get the title history for the car so you can look at the title history and see if there's something in the title history that would make a difference to your client. Was it a daily rental car? Was that disclosed to your client? Did it have a branded title? And you can only learn this by looking at the title history. I have got a case pending right now in federal court where my client bought a vehicle and she didn't know it. She didn't know it until she hired me. It had a rolled odometer and was a daily rental car. And you know, that's the type of stuff that the finance company, you know, is liable to the extent that there's money owed and money paid. It takes a little bit more work to defend an auto deficiency case when you're focusing on the bad conduct of the auto dealership. You got to work very hard on that. And there's a treatise, again, National Consumer Law Center has an auto fraud treatise from the National Consumer Law Center's collection of books. So let me just talk briefly about a couple developments that are important. One, people are asking, is there a prohibition, or was there a prohibition against repossessions during the height of the COVID-19 shutdown orders? We're litigating that, and I don't have an answer from a judge yet. There is a development that you need to be aware of that is something that is not yet broadcast to the point where people know, and here it is. We have a Santander entered into a settlement agreement with, one moment. Santander entered into a settlement agreement with 38 attorney generals that basically is giving a lot of consumers who have their cars repossessed both cash and recovery of, and also a waiver of deficiency and clearance of the credit reports. The settlement rolled out mid-May, and the settlement is based on the fact that Santander was financing vehicles for people without consideration of whether or not it was affordable. There are something, I think, 75,000, 100,000 consumers. They haven't really given us the data on it yet. There are many people who have their cars repossessed by Santander who are in this group, and they're playing it really close to the vest on who's in the group. I'm currently litigating a case where I'm trying to get that information so I can figure out who the consumers are. And they actually are keeping it so that even it's based on a scoring method that they're not disclosing. So when you have a client who had her car repossessed by Santander, you need to start asking the questions about whether or not the vehicle was subject to that settlement. Jay, was there a question for me? Oh, from Zach McCormick. I have long wondered if there is any remedy to tragedy that comes from lenders reselling repossessed vehicles at grossly below the fair market value. The answer to the question is no, not now, not yet. I've tried to challenge the practice of selling vehicles at these dealer-only auctions as being commercially unreasonable. And I don't have the courage to file an antitrust case because I think it's anti-competitive. I think it's fostering a depressed values for repossessed collateral solely for the benefit of used car dealerships. But you know what? I'm just one man. David, are there any other questions I need to answer?
Bob, what I'd like to do is, in order to get stay on time and let Rob Churchill do his presentation, what I'd like to say is that if you'll come back with us at 4 o'clock, and we're just going to open it up the whole panel and let people just find questions out of that.
Can you text me at 4 because I won't remember.
I will text you at 4, my friend. Thank you for
Bob.
the great presentation, Bob. A lot of good, valuable information. And if people need to, I know you're always a resource for anyone looking at any of these kind of cases.
Okay, everybody, bye.
All right. Let's see. I think next up we have Mr. Churchill.
Hello. I'm Robert Churchill. I'm going to work here for the next 90 seconds on sharing my screen and my PowerPoint. So now is a good time to run out to the bathroom or get a drink of water.
Yes.
Sorry. All right, we'll let this percolate a minute here because I just made the promise. So 60 seconds from now, I'm hitting go. I'll be right back.
All right.
The on? I said you want the light off?
I said on would be great.
Okay, I am teeing this off, ready or not. I am Robert Churchill. I'm an attorney. My law firm is Churchill Law Group. I have an office in Tallahassee where I live and work, and I have an office in St. Petersburg. And between those two offices, we handle consumer issues over most of the area of the state, except for south of Okeechobee. The lake, that is, not the county. But what I'm talking about here is landlord-tenant issues. Where I live and work happens to be a college town, and we deal a lot with landlord-tenant law, especially as it relates to student housing. And over some years, that has given me a lot of exposure and now expertise on landlord-tenant issues and the Landlord-Tenant Act. So I'm going to cover this. There's a lot we could talk about here, so I'm going to make sure that we're hitting the very high notes. And we can go back and answer any questions there are, but I want to make sure we cover the high points. The big four issues that come up in landlord-tenant cases a lot are these four. Number one, the landlord will not maintain the place. We need to talk about what to do about that and how to best address it. Number two, the landlord is removing a tenant, putting a tenant out, typically through an eviction or a lease termination. Three, a landlord saying that the tenant owes money, and how the landlord goes about collecting money. And as a side point here, there are a lot of very ripe issues in a landlord-tenant context for consumer protection actions. That is, this landlord-tenant relationships, especially with corporate landlords, is a breeding ground for consumer actions, and that's because at least in a college town, but also in many other contexts, you have college students often sitting behind the desk playing the role of property manager who are willing to say things out loud and are willing to put things in writing on behalf of their corporate employers that are not legal. And then at the same time, you have a lot of issues with landlord-tenant leases that we'll get into that are drawn by corporate entities that create claims. So that'll come up when we talk about landlord saying how the tenant owes money in terms of security deposits and rent acceleration, which is a big one, lease termination fees, and property damage. And then number four, landlord doesn't know or doesn't care about Florida law tenant protections and how to keep the landlord compliant on those issues. Where'd my cursor go? Okay. Just to drop a note here about what we are not covering. We're not covering issues specifically related to COVID, and that's because there's been a lot of movement as it protects tenants in relation to the virus. We could spend an additional hour from the hour or the 15 minutes that I have here talking about those issues and the ramifications of them. The other reason that I'm not talking about them specifically is because they are sunsetting, they're expiring. Both the CARES Act, which is a federal law, and the governor's Florida moratorium on evictions are set to expire at the end of July. They may in fact be extended, especially because of the aggravation of the virus or how it's spreading, but there's a different CLE that you can look at, and I actually can give you the slides for the CLE. There's an excellent CLE that was done by Jeffrey Hearn, who runs the litigation section for I think Greater Legal Services of Miami, just about the CARES Act and the moratorium, and that's worth looking at. If you're interested in these issues, you can email me and I will shoot you the stuff. Okay, important kind of ground rules for covering everything we're touching on these big four is that the supremacy of the Landlord-Tenant Act provisions over any contrary agreement between the landlord and the tenant, including what's in the lease. That matters a lot because corporate landlords, as I've mentioned, tend to be multi-state entities. I'll put it that way. You have a landlord who is headquartered or located in Chicago and has spread into Florida. And what they want to do is use the adhesion provisions and all of the landlord-friendly provisions in their lease in Florida. And so they'll just rewrite the terms in Florida. And then they might have a state-specific page that deals with the Florida law, but they want to use everything else from their corporately drawn lease that they use across the country here in Florida. And that tends to, again, create claims, and it brings into the Florida landlord-tenant relationship with your client 4 or 5 different things that are illegal, facially illegal based on the Landlord-Tenant Act. Those include, the biggest offenders on this are liability waivers favoring the landlord in the lease, and penalties or rent acceleration. That is, if you fail to perform under the lease, if you leave early, if you can't perform under the lease, then you owe us all of the money that is due under the lease from the day you leave to the end date of the lease, called rent acceleration. Is a big no-no under the Landlord-Tenant Act. The other thing is that the reason that this matters is that many landlords, especially the mom and pops landlords, that is smaller actors, think that the lease controls everything and that they have only to live up to what's in the lease, otherwise, and the tenant does not have rights beyond the lease. And that's obviously incorrect. The Landlord-Tenant Act creates obligations on both the landlord and the tenant and is actionable. That is, it creates rights that on its terms says can be enforced in court as necessary, either through a damages action or an action for declaratory judgment, and pays attorney fees. Okay, and big for issue number one is maintenance issues. Maintenance under the Landlord-Tenant Act is divided by what kind of property your client lives in. That is, apartment versus, actually apartments are never mentioned in the Landlord-Tenant Act, but what is mentioned are single-family homes or duplexes. So the other properties that typically come up in landlord-tenant relationships that are not mobile homes, which are excluded if the tenant owns them, are apartments. So generally speaking, the way that this is interpreted is that the apartment buildings and apartment landlords normally are always required to maintain the premises and to keep the place up to applicable code. There is some nuance in that local code offices typically will say that they don't regulate large apartment buildings if there are over, say, 20 units, because that's regulated by the same people at the statewide level, like the Department of Business and Professional Regulation, that regulate apartment buildings, or excuse me, regulate restaurants, and hotels also regulate apartment buildings. But under the Act, a landlord is required to maintain the premises, and those requirements, maintenance requirements, can be enforced. Let me see if I can minimize this because you guys are bleeding onto my screen. Yeah, okay. Sorry, my face was blocking the PowerPoint and I couldn't read it. So because of the general requirements on a landlord, both for apartments and for single family homes or duplexes, is that they have to meet minimum code requirements as codified in that county. And just about every county in the state now has a governing code. You have to get into very rural, kind of in the sticks areas to find a place that has no governing code. Or they have, the statute actually lists out, and we'll get to that in a moment, lists out what the landlord has to cover in the event that there is no governing code provision. Single family homes or duplexes actually have a right under the, and so you need to investigate the lease further, because with a single family home or duplex, the tenant and landlord together have a right to waive the landlord's maintenance obligation. So typically what this is normally designed for is for fixer-uppers. You have a handyman tenant who wants to rent the place and ostensibly is going to rent it for less money because he, the tenant, or she, the tenant, is going to take on the obligation of keeping it maintained. There's nothing wrong with that under the Landlord-Tenant Act. The problem is that it's overused. Landlords, once they figure out that they can do that and exclude their own maintenance responsibilities, will load them into leases. And some landlords have ended up just using a straight waiver of maintenance obligation in single-family homes or duplexes. So Florida, Florida statute requires that the landlord meet minimum code, or if there's no applicable code, to meet the list here. And this list means, and I won't read this all to you, but generally speaking, it means keeping the place livable, keeping the place load bearing, the walls load bearing, keeping leaks out, making sure the floor surfaces and the weight bearing elements of the structure don't fall through, and exterminating rats and wood destroying organisms and mice and roaches, etc. Providing locks and keys, and basically establishing a safe place to reside. And also the other one is that often comes up is facilities for heat, running water, and hot water as a minimum. Code compliance is something to remember because this will come up later as the way by which these things are enforced. So what to do in the absence of proper maintenance is use the mechanisms that are in the Landlord-Tenant Act for enforcement. And the effective way to do this is not to sue the landlord for lack of maintenance. Normally it is to leverage the situation by doing a legal withhold of rent, or if your client wants to terminate the lease and is fed up and needs to get out of there, you can do a 7-day notice to terminate the lease. As a practical matter, terminating a lease through a 7-day notice is fraught with some risk, which I can explain, but normally that means that the method by which, the best way to address a maintenance issue is to do a 7-day notice to withhold rent. This 7-day notice, the timeline for doing a 7-day notice typically should be right around the 20th of the month. That is, if you do a 7-day notice too early in the month, then the landlord will say that they've fixed everything up, everything is good, and your client needs to pay rent next month. If you do it too late in the month, if you do it on the 25th, then your 7-day notice is going to cross over the rent obligation to pay. In other words, your 7-day notice will not have expired by the time your client's rent comes due. And then if their client is not paying rent because you're doing a 7-day notice, then they're going to get a 3-day notice from the landlord to pay rent. You don't want to tangle up those notices or to have them cross. So what you want to be able to do is to have your 7-day notice to withhold rent expire before rent comes due the following month. That's why typically when I'm doing a 7-day notice to withhold rent, I'm doing it on the 20th, the 21st, the 22nd. The reason that 7-day notices for termination are not a preferred method, even if your goal is to terminate the lease, for me, is because what will end up happening is that you will do a 7-day notice and you'll do it perfectly, and you'll say the landlord didn't fix the problem, therefore I'm terminating the lease. And then the landlord will say, no, you're not. And then you'll say, yes, I am. No, you're not. Yes, I am. And you'll go back and forth doing that for a month. And then the landlord will treat your client like somebody who just walked away from the lease. And there's not an effective way to establish that a lease is terminated, because the landlord doesn't have to agree with you unless you litigate it. You're going to have to take it to court and file a declaratory judgment action to establish that the right to terminate was established and you followed the law, et cetera, and therefore the lease is terminated. Whereas if you do a rent withhold, what you're going to do is get the landlord coming to you, asking you if you guys can please work this out and offering a termination where it can be settled out. And that typically is, with all the drama included and considered, is the way that most clients choose to handle it. Month to month is an exception that you need to be aware of. Month-to-month tenants have a much harder time enforcing either a right to withhold rent or to terminate a lease. And that's because month-to-month tenancies are typically viewed by courts as portable in their nature. So you have, it doesn't, if you have a problem with the place, Mr. Churchill, your client can do a 15-day notice to terminate their month-to-month lease. Get up and get out. That's what a month-to-month lease is. And that runs both ways for the landlord and the tenant. So it's important to consider that, look before you leap in reference to how to enforce a maintenance issue. If your client is month to month, they're going to have a much harder climb up the hill. Code compliance, I told you I was promising that we would talk about this quickly. Code compliance is wonderful if you're looking to legally withhold rent or to terminate a lease. And that's because of the great trifecta that code officers offer or are. A code officer, when you make a minimum housing complaint to the code officer, what you get is a code expert showing up with a clipboard who does an inspection and finds all kinds of things wrong, more than what you were complaining about, who then generates a written report at no charge to you or to your client for free. And it does not get better than that. Expertise generating written reports for free that you can then use to buttress and leverage your position is the great trifecta, and that's why code compliance is wonderful. And as I write here, it's much, much, much more powerful than your client just saying that there's a problem. So typically the way that you want to utilize code officers, and never tell the code officer that you're using them, by the way. That's how to make an enemy out of somebody that you want to be your ally. But the way that you utilize code officers in this practice would be to start the process of the 7-day notice of a withhold, and then right after that, you call the code officer to come in there, and the code officer will then be verifying the information you provided, plus adding more someday around day 6 of your 7-day notice. And that's when you want it done. All right, big four, number 2 is landlord-initiated lease terminations and evictions. And eviction is important to define. An eviction is basically a landlord legally severing off a tenant's right to reside in a home, which is not the same as a termination. Your lease is just the termination of a lease at the end of its duration, basically saying you have to get up or get out, or a month-to-month termination where the landlord says 15 days from now you need to be gone. An eviction is cutting somebody's right to live in a place off while they have to continue or potentially are obligated to continue paying rent. That is, the financial obligation remains even though they're not allowed to live there. Evictions are regulated more heavily because of that, and that they are only allowed to be done through the court system. So it's not legal to put somebody out by court process, well, by process, of any process that exists, without using a court. And I just covered this. The only exceptions to that are when the tenant has surrendered or abandoned the unit. And abandonment is then defined in the statute, which is that's Florida Statute 8359. Okay, so evictions are typically premised on 2 different sets of reasons, one being non-payment of rent, and the other being tenant misbehavior, basically tenants violating the rules or regulations that either are so severe that a landlord can just tell them to get up and get out in 7 days. That typically would be vandalism or regulated illegal activity like selling drugs out of the unit, something like that. Or if they are not severe, like too much noise in your place or whatever, then the landlord has to give an opportunity to cure. A 7-day notice that says that you have to fix this up, otherwise you will be evicted. And by the way, if I have to warn you again about this, even if it's not an automatic get out kind of notice, if I have to warn you again, the second time I have to warn you about this will be an automatic right to remove you from the premises. There's a lot of fights over how and whether a landlord is allowed to invoke that basically 2-strike rule. But those are the general guidelines for how it is supposed to work, is that severity can breed a right in the landlord to terminate somebody automatically, or repeated minor conduct can also do it. What you want to look for if you're fighting an eviction, and most people who start working in the realm of landlord-tenant law for consumers start by defending eviction lawsuits, and that's because that's when tenant clients are typically looking for representation. And if you fight an eviction lawsuit and win it, it generates attorney fees. It's worth doing. The other nice thing about eviction lawsuits is that they are premised on and required to have performed a notice of termination of a lease. So the lawsuit, the way that this is supposed to work, is that an eviction lawsuit can only be filed after a lease termination has been performed by the landlord through a 3-day notice, or 7-day notice, as the case may be, depending on what the basis is, but through a notice that gives the client an opportunity to fix the problem. So I'm sticking to a 3-day notice here because we're going to talk about the most common type of eviction, which is rent-based. What you want to look at in 3-day notices to find flaws in them are basically notices that deviate from the statutory form that is found in Florida Statute 83.49. Bad date calculations, bad math regarding rent owed, calculations left to the tenant regarding the rent that is to be owed. Basically, if the tenant has to do math or run any calculation at all, that's a bad notice. And a bad notice is important because a bad notice means that if the notice was flawed, then the lease was never properly terminated, then an eviction cannot survive. A lack of specificity, deviations or departures from statutory forms, and post office boxes used as a rent delivery address. That's a big one. So let me, we're not doing this yet. Here, I'm gonna see if I can minimize this screen to show you a form. Bad notice form. Let me see if I can make the view right here. Somebody tell me you can see this thing, because I don't know whether I screwed this up.
I can see it.
All right.
Could you zoom in though?
So this is an actual plucked from real life form that was used against a client of mine. I've redacted it because it's fairly recent, which resulted in me defending an eviction, a rent-based eviction, winning a judgment on the pleadings, which is the motion that I filed, based on the invalidity of the notice. Because this is real life, I'm actually showing you the actual one, and then in a second I'm going to show you how I modified this to make it even worse. But the problem that I found in this notice is right here. The post office box as a delivery address on a notice that is dated February 6th and requires the delivery on February 11th of the rent. So this is 3-day notices are required to give you 3 days, not including Saturdays, Sundays, and legal holidays. And if you look back at your calendar, you can take my word for this, that if you look at your calendar from February of 2020, you will see that this is actually, obviously it's 5 days on the calendar, but 2 of those days are Saturdays and Sundays. So the landlord correctly calculated the timeline that the tenant would have to pay this rent by excluding Saturdays and Sundays. And then the landlord screwed up by saying to deliver the money to a post office box. There are many cases that interpret, that find that 3-day notices that require rent to be delivered to a post office box must include a 5-day extension for delivery by mail. And I was able to go into court and say, Judge, this notice is invalid because this 3-day notice, which is actually a 5-day notice because of the weekend, it should have been a 10-day notice because it needed to add time for the post office box delivery. And that worked. I won that case, and we're now litigating over my attorney fees. Other examples of bad notices are here. Let me expand the view here again. So I just took the same notice and modified it. Problems that you might see in a bad notice are where the landlord will make, this used to be where the calculation done by the landlord was, and there was actually nothing wrong with that was in the prior notice that I showed you. But landlords a lot will say, you have to pay us this amount plus applicable late fees. When you see that, that is a big red flag. That means tenant, do some math. And when the tenant has to do math, when the tenant has to do any calculation at all, meaning on the date by which the thing is supposed to be paid or on the amount of money to be paid, that's an invalid notice and it cannot support an eviction. Other problems are typically where there are not all tenants are listed, so the notice will be done only basically to whoever the property manager deals with most often. A get out now lease, your lease is terminated, get out now, or the missed date in here where the notice actually says the same date on which it's delivered to get out or is left blank. Or the tenant, the notice will not name the actual landlord listed in the lease or the owner of the property, but will list a property manager who is not a party to the lease. That happens frequently, especially when property management changes during the life of the lease. Any one of those things can make the 3-day notice invalid, and there is case law supporting that, by which you can then defend the case and say that the notice was invalid and therefore, I rewound this thing all the way back. Hold on, I gotta find where I was. So you can use those eviction clauses to fight an eviction and get prevailing party attorney fees when you do. Landlord conduct that can waive the right to evict includes the acceptance, and the law has changed on this in the last 2 years to become much more complicated through the legislative wisdom. But this statute is the one that the legislature in the last several years has messed around with to make more complicated. It used to be that landlords accepting a tender of rent after a 3-day notice meant that they could no longer evict. So when a tenant comes in and says, listen, I want to pay you something, can I pay you something but not all? The landlord was put in this dilemma of, do I take this money because it's money on the table, or do I refuse it so that I can maintain the right to evict? Now, and because there were so many effective landlord-tenant lawyers fighting evictions by saying you accepted rent, therefore you flushed your eviction right down the tubes, landlords lobbied the legislature to get this changed. Now, a landlord can accept partial rent, and if they give the tenant a receipt showing basically a ledger balance of what money they accepted, then they can still evict the tenant by either giving them using a receipt saying you still owe this amount of money, posting a 3-day notice, or placing the money that they accepted rent into the court registry, which they never do. So normally the question when your client says that they paid rent after they got a 3-day notice, or they paid partial after they got a notice, is did you get a receipt in real time? And one of the things that will come up in that context is a ledger, where they paid online and there was a ledger showing balance on the internet that the landlord will then say protects them, and there's still litigation going on about those issues. Issue number 3, landlord claims for tenant owed money. I was checking my wrist here to make sure I'm on time. Usually issues over landlord claims for tenant owed money after a tenant vacates are going to be for residual rent that is owed, or for damaged property. One thing that actually is not covered here in the outline, but I'm going to touch on briefly, is rent acceleration. Rent acceleration is what I just referred to earlier, and one of the things that Bob Murphy, when he was talking about repos, was saying is that default is a cause. I took note of this when he said default is a cause for acceleration. And he also said that some large auto dealers have gotten in trouble by taking legal advice and letting the advice from their lawyers bleed into the practice of writing the forms, etc., gotten their clients in trouble. That's a pretty good analogy for what has happened in the landlord-tenant space, is that large corporate landlords have started to utilize acceleration in their leases, probably because they were getting legal advice from somebody in some other state, saying, why aren't you guys doing this? Why aren't you going after people to accelerate their leases when they fail to perform on the lease? Under Florida law, that's not legal, and that's because the Landlord-Tenant Act lays out the remedies that are available to a landlord in the event of a tenant breach by list, and that list does not include acceleration. So when you see an acceleration clause in a lease, it's valuable because it can be used as actionable against the landlord and as counter leverage to whatever is going on. Other sources of tenant owed debt are residual rent obligations that are not accelerated. That is, you failed to pay even though you're already gone. You still owe us money that we were not able to cover our butts on by re-renting the space, or damage to the property. Those claims typically arise by a rendering of a security deposit notice that exceeds the amount of the deposit. So what you want to do when you're looking at a security deposit is evaluate first whether a security deposit notice was required, which is a security deposit notice is always required when someone leaves on time and they had a lease in writing. So when you have a lease that's a year-long lease and you leave at the end of it, then a landlord making a claim on the security deposit has to send a notice. Where security deposits notices are not automatically required, and your client may think they were entitled to a notice and may well be incorrect, is when the tenant leaves early, when the tenant leaves late, or when the tenant is month to month. In any of those scenarios, in order for a landlord to have to send a security deposit notice, the tenant is required to tell the landlord in writing by certified mail at least 7 days prior to when they vacate where their forwarding address will be. And that's in Florida Statute 83.49. So most tenants will say something to the effect of, well, they know where my forwarding address was. I told them when I left, or I put it in writing when I left. And that doesn't matter. Actual knowledge does not matter. What matters is that you're checking the box that says procedurally that the landlord has to send a security deposit notice, because the notice and the failure of the notice is not at all unlike the 3-day notice that we looked at a second ago. If the landlord does not do it correctly, then they waive their right to make a claim on the security deposit, and they also waive any ability to say that the tenant owes money for any other thing until they tender back the security deposit. So it's a very valuable tool as long as you can make sure that the tenant gets the benefit of it. If you're talking to a client who's looking at needing to leave the space, I gotta get out of here, I can't stay here anymore, I need to know that my security deposit is gonna be protected, then what you want to tell that client is, no matter what, 7 days before you leave, I do this 10 days before my client leaves, send a certified letter to the landlord saying where your forwarding address will be. There are good security deposit cases and bad ones, and you want to avoid security deposit cases and damage cases, that is, cases over the landlord saying money is owed. You want to avoid cases involving litigation over a security deposit that involves scratch and dent. That is, if you do not have a basis to argue that the notice was bad, you will end up arguing that the carpet was too dirty or not dirty enough, or excuse me, that the carpet was not dirty, yes it was, no it wasn't. And that is a nightmare for you in representing a client in reference to a debt obligation or a security deposit in a landlord, and that's with a landlord. And that's because those cases you're going to litigate the case, you're going to have to prove up with evidence what your client is saying. Judges hate cases like that, and they're going to glaze over when you start talking about how dirty this carpet was or was not, and then they're going to do everything they can to try and cut the baby in half and say, the place, I'm sure it wasn't a wreck, I'm sure it wasn't perfect, and then your client's going to look at you 6 months into the case going, how did you get me here when I thought I was going to be able to get my whole deposit back? You want to avoid scratch and dent cases like the plague, which means you want to be talking about the notices or the validity or invalidity of the notice, and the consequence that the landlord is no longer allowed to claim money owed until they spit out the notice, or excuse me, until they spit out the security deposit. So that the notice clause is one big pitfall. Obviously, rent acceleration we already talked about, and lease termination fees. Lease termination fees is another very big subject right now for people who deal a lot with landlord tenant issues. The lease termination fee provision in the Landlord Tenant Act says literally that a landlord can charge a termination fee to a tenant when they leave on time, if the tenant has not notified the landlord 60 days prior to when they're leaving that they are not going to renew their lease. And so they are allowed to charge the tenant, I think, 1 month's rent or maybe 2 months' rent as a charge, just because the tenant didn't say, well, I'm not going to renew. The exceptions to that are that a landlord can only charge the tenant that money if the tenant has not provided that notice, if the landlord provides a notice to the tenant of the notice requirement for the landlord. That is, the landlord has to provide at least 15 days notice to the tenant. You have to notify us in 15 days of whether you're not going to stay. And that notice requirement on the landlord also has to be included in the lease. So the requirement in the lease is literally a notice requirement of a notice requirement of a notice requirement. No one understands that, and no one on the landlord side understands it, and no one does it ever. And so when you find someone who has a lease termination fee that has been assessed to them, it's very valuable to look both at the notices that they got and also at the lease, because the statute is such a hot mess on that issue that it's screwed up somewhere. It is, and the landlord's putting feet on it in the way that they carried it out is almost certainly going to be problematic. Okay, prohibited landlord conduct. The number 4 of the big 4 here the biggest offenders in this space are landlords doing a self-help eviction by trying to lock somebody out, not using the court process, basically putting somebody out through a power shutoff or a lockout, or landlord intruding on tenant private space and time. Where did my cursor go? Here it is. So self-help evictions are literally that. When a landlord basically decides to skip the whole court process and let's get this done and lock someone out, or turns the power off, or does something, takes the doors off, the hinges, something like that, does something else that they intend to try and put somebody out of the place without going through the court process. Damages available to a tenant in a self-help eviction situation are the greater of the actual and consequential damages suffered, or 3 months rent plus attorney fees to you at a reasonable hourly rate. The other issue that comes up frequently is landlords intruding into tenant private space. Landlord access to tenant space is limited by Florida Statute 83.53. Not at all unusual for landlords, especially like smaller mom and pop landlords, to take the position or have the attitude that because they own the space, they have a right to come and go as they please in the space. And that is definitely not true. Landlords are allowed to enter the space, to enter the rental space, that is, anytime they want, in order to protect the property. So fire and flood kind of situation, they're allowed to come in and do everything that needs to be done to protect it. Otherwise, for general maintenance, for inspection, for any other reason, a landlord has to provide reasonable notice that they are coming, which is notice of at least 12 hours, and only show up and remain in the unit during reasonable times, which will be between the hours of 7:30 a.m. and 8 p.m. Other than that, a landlord is not allowed to come in. This normally, when I've dealt with this and landlords kind of over accessing the property, it's because a landlord has a key and is coming and going when the tenant is not there. So you have to do, basically send a nastygram warning to the landlord that says, the premises are video monitored. We are watching you come and go. And the next time anybody enters this unit without my client's direct permission and without compliance with the Landlord Tenant Act, my client will just change the locks, and then we'll charge you for the changing of the locks. We'll hold it out of the rent the next month, pursuant to the Landlord Tenant Act. And if I have to pursue claims to enforce this further, I will. That usually gets the landlord sitting up straight and solves that problem. But as I said, every right including this, every right that exists under the Landlord Tenant Act to the tenant is enforceable under the act itself by civil action, either for damages caused, and this would be landlord intrusion onto tenant private space is not something that normally causes out-of-pocket expense, but there is, and you don't want to be getting into the sort of a metaphysical trespass damages scenario where you're talking about some kind of nominal damages. What you want to do is, in the event that you needed to litigate this, is to do some sort of an injunctive relief or declaratory judgment action saying that this has violated the act and therefore you need a court order prohibiting it and asking for attorney fees. And that, unless I'm wrong. Oh, all right. This is my invitation to you. I know there's an open question time later in the show here, but if anybody has other questions about specific issues or things that I missed that you need addressed to me, you're welcome to ask me. You're welcome to email me or call me. And as I said, the COVID-related stuff that I referred to before is actually very valuable. Jeffrey Hearn, the guy who runs that, runs the legal services organization in Miami on housing issues, and I think he runs their entire litigation department down there, has actually succeeded in getting a district-wide order, at least in the Miami area, South Florida somewhere, saying that when you file an eviction, you have to plead affirmatively that you are complying with the CARES Act. He is an expert on these issues, and I did a CLE with him where I covered the General Landlord Tenant Act and he covered COVID-specific issues. I'm happy to give that information to anybody who wants it, and I have his permission already to do that. So anyway, email me if you want more information on that or have any other questions. I'm done.
Robert, thank you so much for a great presentation. That was really wonderful. Since we have a couple minutes, very quick question. What's the status right now about cases being dismissed for non-payment of money into the court funds?
Non-payment of money in the registry?
Yeah, if they're not, the tenant who wants to defend an eviction, I know there was some argument for a while that it was unconstitutional to make the tenants pay to play. Is that still the rule, that they have to put any rent in the court fund that the landlord says is owed in order to raise the defense?
Yeah, so what David's referring to is before I touch on the constitutionality of it, the answer to your question, no, it's not. It's been held constitutional, and there's any effort to declare it unconstitutional has not prevailed to date. Okay. In the statute, the eviction statute, it actually specifically says that a tenant is not allowed to defend, is not allowed to raise any defense other than payment in reference to an eviction, unless the tenant pays the rent money that is at stake in the case or at issue in the case into the court registry, or files a motion to determine rent. So the reason for that, as I explain this to my clients, is to prohibit people from defending an eviction action while they're effectively squatting in the property. So you're saying that you have a right to stay here, the landlord is saying you have to go, because you haven't paid rent. And the way that you have to show that you wish to stay and to defend the case is to put the money that is at stake in the case into the court registry and pay into the court registry as you go the entire time. So rent has to be paid current the entire time. The exception to that is that you can file a motion to determine rent, asking the judge to tell you how much money should be paid into the court registry. And that is done so that a landlord cannot say, for example, by pleading, say, you owe $10,000 when actually you owe $1,000. So you get a motion to determine rent within the 5-day response period. Then you get a hearing, and then the judge says, all right, yes, your rent is not $10,000, it's $1,000, and you have to pay that money into the registry now in order to defend the lawsuit. So as a practical matter, what that does is it makes eviction cases harder to litigate and harder to defend if you're asking your client to pay you to do it, because you have to tell the client, this case is for $1,000 in back rent, plus you have rent that's coming due 3 weeks from now or 2 weeks from now. That rent that's coming due from 2 weeks from now is, say, another $700, $750, whatever, depending on where you are in the state. That's $1,700 that you're going to have to dump into the court in order to hire me to defend the lawsuit, okay? And then you got to pay me separately. So what I have done with some success, and there are orders around the state that actually allow people to do this, is I have told my client, and as I did with that case that I showed the bad notice on, that client did not pay me anything out of pocket. I told the client in that case, what you're going to do is agree that I have a contingency right to, when I'm defending this lawsuit, to make a claim for my attorney fees from the rent money that you're paying the landlord into the registry. In order for me to do that, you have to pay the rent money to the registry. I cannot win this lawsuit. I can't come close to winning this lawsuit unless the rent is in the registry. So you pay the rent to the court, I will defend the lawsuit, and I will get paid from the court registry out of the money that would otherwise be due the landlord for your rent. And that has worked for me. It's worked, and there are court orders around the state, actually some in, I think this is a Central Florida production here. I think some of them are in, I know they're in Central Florida. I believe they're in Orange County, but that is the way, the way as a practical matter to work your way around that problem. But yes, it's still on the books and it's still enforced. You're not going to be able to litigate an eviction without the rent money into the registry.
Okay. All right. Thank you for clarifying that. I don't know, Joseph, I got a message. Joseph Sternberg has a question to ask. I don't know if Joseph, if you want to try speaking and see if we can hear you. He wants to know if we can talk a little bit about acceleration clauses.
Yeah, hold on. I'm unsharing my screen. Can I unshare this?
Yes.
All right, my shared screen.
Okay, now I'm
There you go,
now I'm
Joseph.
able to. The unmute option came up. Yeah, it was interesting that you brought up in the beginning about an acceleration clause. I found one of those in a contract, or excuse me, a lease of a client of mine about this was like a month ago, and it had a guarantor requirement, and then it said if you are unable to have a guarantor, we will accelerate all your rent due, essentially before you even giving possession to my client, to the potential tenant. And I just thought this was the most ridiculous piece I'd ever seen, and I wanted your opinion on it. I could actually send it to you. It'd be interesting to get your opinion. But generally, it had this acceleration clause, and they weren't even going to deliver possession because he didn't have a guarantor. So that's basically what I was looking at.
Yeah, that sounds like a pretty creative way that they've tried to work their way around. I mean, what I was referring to that makes acceleration illegal is that there's a specific provision in the act that says basically landlord remedies in the event of a tenant default. And it lists out what those remedies can be. One being that the landlord can take the property over for their own account, not holding the tenant responsible for anything, which they never do, or they can take it over for the tenant's account, meaning they can try and re-rent it to the full extent that they can, and then hold the tenant responsible for whatever the difference is between what they cover and what remains owed. Or they can do a termination fee, liquidated damages, which is another exception that they can charge. But they cannot ever accelerate rent. It just isn't on the list. The situation with yours that you're describing is, it almost sounds like they're trying to say, well, this is not an event of default at all. We're laying out right here in the lease. If you just signed up, you agreed to pay us all this money for this place to live, but if you don't have a guarantor, you don't get to live here, and you owe us all this money. And almost certainly that would be held, if you were to pursue it and litigate it, you would, there's a separate provision that says that a court can find any unconscionable provision in the act, or any unconscionable provision in a lease, unenforceable. And I have used that to some effect by saying, you know what, Judge, we're not asking you to go out on a limb here. This is not, I'm not coming in here with, you know, a law school unconscionability argument from contracts. This is in the statute. The statute is, the legislature had put this here, and they said that the court can specifically hold provisions of residential leases unconscionable. That's what I'm asking you to do, and that's what this is. And they did that because, unique from, say, commercial leases, which are governed by a separate section. When you are renting residential space to someone, there is number one, you're renting something that they have to have, and you're also put in a uniquely a unique situation involving an imbalance of power or bargaining power. And that means that there's an incentive for rip-off artists to rip people off and to put unconscionable provisions in their leases. That's why this provision is there, Your Honor, to prevent exactly that. Do your job. And that's, unless you can characterize it as a default provision, it would probably be something that is worth fighting over unconscionability under the statute.
Right. That's 8345. That's exactly what I wrote in my letter to the landlord. But and I typed in the actual language, but I don't want to waste more time reading it. But it was essentially, I found it unconscionable, and that's exactly. Yep. It was probably the most unconscionable thing I've seen in any lease, and I've reviewed a couple dozen of them, you know, just in the last few years. So I thought that was interesting to share.
Good, thank you. Can't hear you, David.
Yeah, we'll take more questions at 4 o'clock when we bring in all the panelists, and you guys can just fire whatever questions you have at us. In the meantime, we've got about 3 minutes, so why don't we all take a quick break, and then I'll be here to give you the blue sky version of bankruptcy. It's 3 o'clock, and I will start off slow for anybody who's lagging and getting back. I do want to give a big shout out to Robert Churchill for that great presentation on landlord-tenant law. And just to make sure everybody knows, if you ever have a question on landlord-tenant law, he really is the guru. And I've had the pleasure of working with Robert a number of times on cases, and he always brings great scholarship to his cases, as I'm sure you guys all saw here today. So let me do my own struggle with the screen share here so that I can join the fun with everybody else. Let's see. All right. Are you guys seeing that? Is it coming through? Jim, can you?
Yes, sir.
All right.
Yes, sir, I can see it.
All right, let me arrange this a little bit differently so I can. All right, so just so everyone knows today, if you're an experienced bankruptcy practitioner, most of what I'm going to talk about today is a very basic stuff. This is really the blue sky version, or the blue sky look at bankruptcy. We're not going to get down in the details too much. These are really the things that I think that if you're not a bankruptcy lawyer, that you need to know about bankruptcy. I'm not going to try to train you to do bankruptcy today, By way of introduction, my name is David Abrams. I'm a lawyer who focuses on consumer law. I practice out of Orlando, Florida. I enjoy partnering with other lawyers and both individual and class action cases. I do a lot of fair debt collection, auto fraud. The last couple of years have been a lot of landlord-tenant cases. As Robert showed us, that's a very a ripe area for litigation. So that's who I am. I'm a member of NACA, and I've been practicing this area for, I guess, about 17 years now. So quite a while. And so here are some things that I think if you're not an experienced bankruptcy lawyer that you really need to know. And these are the issues I'm going to cover in my talk today. And the first one is, what do you need to think about when you're maybe looking at a client that you may think needs a referral to a bankruptcy lawyer? And what do we consider? What do we need to think about before we file bankruptcy? And one of the things to be aware of is, what is the purpose of a bankruptcy? And I included text, and this is actually an old Supreme Court decision from 1934, but it's one of those timeless decisions that keeps getting quoted. You see it quoted in a lot of more modern decisions. And this idea that bankruptcy is there to help the honest but unfortunate debtor, and go through the process, and then give them, in this case, it says a new opportunity in life and a clear field of future effort. The more modern term for this is really the economic fresh start. You hear bankruptcy lawyers talking all the time about the importance of the fresh start, and it's about economic renewal. Bankruptcy is not a tool to cheat creditors. In fact, as you'll hear further in my talk, I think that bankruptcies, in fact, I know one of bankruptcy's primary terms is to make sure that the creditors get treated fairly. It puts all the creditors on a fairly equal playing field. But one of the most important things to think about when you've got a client who's struggling with debt issues, and most of the clients that I think of as being appropriate for bankruptcy, and I filed over 300 bankruptcies in my case, in my career. So I'm not a big time filer, but I've been around the block on this. And I pay a lot of attention to the timing of a client's bankruptcy. Because if you screw up the timing, you can really put your client at a disadvantage. And here's one of the most important issues, and one that I think we're all going to be seeing a lot of in the next couple of years. And that is the debt still accumulating? And one of the primary areas that I look at is healthcare. If you have a client who has an illness and who is continuing to incur debt, I would delay that bankruptcy filing as long as I could, because here's the deal: once you file and you obtain discharge, your client is unable to get another discharge for, as a general rule of thumb, about 7 years. And so that's really an important thing to think about. Is you've got that trump card that you can throw down, that bankruptcy card, but you don't get to use it right away. Again, I mean, so once you've done it, that client is stuck with whatever debt comes after your date of filing. So I like to really pay a lot of attention to that. We've got a lot of people right now who are losing jobs, who are losing, and with that, they're losing their healthcare coverage. And I know that there's supposedly some government mechanisms that are going to pay for COVID treatment, but look, people still they have heart attacks, they have diabetes, they have asthma, they have all these healthcare problems that are still out there. In another life, I was actually, and I still hold a registered nurse's license, so I'm very familiar with how healthcare problems can leave people with huge debts. And unfortunately, healthcare problems also are often associated with disruption in employment. Either people can't maintain their employment, or there's a stress of loss of employment. So pay a lot of attention to what's going on with your client in terms of healthcare issues and whether or not they're incurring healthcare debt, because that, if you file and then they're still incurring debt, it's going to be with them for a long time. So the other issue is non-exempt assets. If you've got a client that just got a big severance package, it's carrying a lot of credit card debt and says, oh, you know, I'm out of work, I can file, and I'm just going to live off of my severance money. Not necessarily. That non-exempt asset, that severance money, may wind up going to the trustee, and you could leave your client with nothing. So that might be an excuse to delay the filing while the client maintains and consumes that asset. And it's important that that asset needs to be used for necessary stuff, not frivolous stuff, because there is some ability of the trustee to look back at transfers and things like that, especially relative transfers. Giving it away to friends and family is never, actually rarely a good idea. The other issue is expected tax refunds. Normally, in my practice, when I've seen the big flood of bankruptcy cases come in, is after tax season. And that's a great time for people to file, because their tax refund, which is an asset that a bankruptcy trustee, especially in a Chapter 7, may be able to take, they often use that to pay for their filing fees. So there's kind of a surge in bankruptcy filings that happens, May, June, in that area. So springtime. And understand, like I say, if your client's expecting a big refund, they file, they haven't gotten it yet, they haven't spent it yet, well, the trustee can probably going to get your client's tax refund. And there's times when that's unavoidable, but do keep it in mind. The other issue to look at is prior cases they've had. It's not unusual for people to have had other cases. So make sure that your client, if they've had a prior bankruptcy, make sure that the time has passed. Or if there's been another filing, there's issues with immediately refiling after a dismissed bankruptcy, and whether or not the automatic stay, which I'll be talking about later, will come into effect. Also look at, did your client recently move? Florida's got some really great bankruptcy exemptions. You can, the homestead exemption here being a fantastic exemption. But make sure your client has, qualified for residency, and that they've at least been here 180 days. The look back period can actually be longer in some cases, and so that's something that might really propel delaying a filing, so that you make sure that they really qualify as being a Florida resident and being subject to those exemptions. And I will tell you, filing in Florida, I almost never use, in fact, I can't remember ever using the federal exemptions. It's always been the state exemptions, because they're just so much better. All right, considerations in favor of an immediate filing. If you've got a foreclosure, especially if you've got a foreclosure where there's a sale date coming, that is the big one. That is the one that we're most commonly going to see. If you're defending a foreclosure and the judge has issued a judgment of foreclosure, but the property hasn't sold yet, your client can still stop that process with a bankruptcy filing. We would do a Chapter 13, which I'll talk about a little later on. And there's a lot that can be done within a Chapter 13 to help a client save a home. And I've helped clients save a bunch of homes using the bankruptcy. But one of the most difficult situations is somebody comes into me the night before the foreclosure sale and suddenly wants to do the bankruptcy. Ideally, they want to get them in there as early as possible. If there's an expected increase in income, can also be a motivation for an immediate filing. As I'll talk in a little bit, an increase in income can disqualify a client from being able to file a simple bankruptcy, a Chapter 7. Sometimes I've seen cases where the client has an offer for a new job, and that job is going to put them over the means test. Well, the income is measured at the date of filing. So the debts that get discharged and the client's assets are measured on the date of filing. So that's something important to remember. So if you're seeing something that's going to change it, sometimes you want to get in before the increase in income. This is this one of stopping the spend down of exempt assets. This is huge. This is really huge. If you've got a client who is spending their retirement savings, is taking out the equity of their house to pay down credit card debts, especially, and it's going to really seriously deplete those assets, I think they're much better off filing a bankruptcy. Understand that retirement savings and your home equity in the state of Florida are exempt assets. They don't lose those in a bankruptcy. And the saddest situations for me to see are the situations where somebody has paid and they sucked all the equity out of the house, they liquidated their retirement fund, and they still have to file a bankruptcy. And they would have had those assets that they come in and filed a year earlier, but they didn't want to do it because, you know, bankruptcy can be shameful. You know, there's all this emotion that's attached to bankruptcy. And sometimes as lawyers, we have to be the unemotional one and just show them this is a business decision. And there's a great book out there called They Went Broke Too, that talks about all the famous people in history who have suffered financial setbacks and went through bankruptcy. And it's very impressive. And I've used it to sometimes help clients feel a little better about the process, because this is emotional. And that's the next reason to file, is that clients that are in debt, most of them are getting collection letters, they're being sued. Very rarely does someone come to me just with one debt problem. Usually one debt problem I can get worked out. But when they're getting hit on all sides, and they've got debt collection lawsuits, and they've got people calling them, and you know they've lost their car, they're worried about losing their car, that is very stressful. In fact, people die because of this. That stress is highly correlated to suicide and depression, and you know, it really is. It's one of the reasons we have laws like the FDCPA is that that's the abuse of people who owe debt and the stress of that. It destroys families, it destroys lives, and I think the most precious thing that people lose when they're confronted with unmanageable debt is they lose years. They lose years that they could save for their family, that they could invest in themselves, and retirement thing, all those things. They lose all that time, and you can never get that back again. We can always get money back, but we never get that time back. The duties of the debtor. This is the basic things of what a debtor needs to do. It's not comprehensive, what I'm going to give you, but it's the stuff that when you talk to your clients about possible referral to a bankruptcy, or maybe even you want to try your first bankruptcy, and you know, maybe co-counsel with one of us that's done it before. Bankruptcy lawyers, I find to be very generous with and welcoming to newcomers in the field, and I think we're going to see a lot of it. There's not going to be any shortage of work coming up. But one of the first things, and this is one of the novice mistakes, and I see especially pro se debtors making this mistake all the time, is that prior to filing, they have to complete a certified or accredited credit counseling course before filing. One of the saddest things I ever saw in bankruptcy court one day was a pro se debtor who filed his own bankruptcy. He took a credit counseling course and then got dismissed because it wasn't a certified provider. So and I remember him standing there looking at the judge and, you know, he's faced with refiling and just not understanding. The law really looks stupid at that point, I think. But the courts, the bankruptcy judges have no discretion in that aspect. So that it's not curable. If it's not done before filing, you're out the door. All right. The bankruptcy client has to disclose all liabilities and assets. There's schedules that have to be completed. It's debts are categorized, secured, unsecured, things like that. And when I say they have to disclose all their assets, I mean everything from their house down to the dog. Dogs are actually property. I do always remind my clients that I've never had a client lose a dog in a bankruptcy, but we did have an argument once about a horse. They have to provide copies of their signed tax returns for the past 3 years. Trustees are actually, my experience has been they're pretty picky about them being signed. And if they're employed, copies of their pay stubs. So basically a disclosure of like I say, all their assets, all their liabilities. And then they will be asked at the trustee meeting. Every trustee is always asked, did they read and receive the bankruptcy disclosure information that's required by these statutes? That's the first thing my clients get when they come in for a consultation is these bankruptcy disclosures. And it basically just tells them about the different forms of bankruptcy and, the effects of bankruptcy, stuff like that. It's not a big deal. I think most people skim it over. I think that came out of the 2005 Bankruptcy Reform Act. And then your client, for most debtors, the only time they go even close to the courthouse is when when we were having in-person hearings, right? They're all being done telephonically now, but they have to attend a meeting of creditors, which in most cases is just the client and the trustee. It's actually fairly rare that creditors actually attend these meetings. And then they have to disclose they have to complete a financial management course prior to their eligibility for a discharge. There's some other requirements, but those are really the main ones. The type of bankruptcy, choosing the type of bankruptcy is actually a very important part of the process for counseling the client. And knowing if you're going to refer to a lawyer, you want to know what forms of bankruptcy that they practice. Chapter 7 is the simplest, and many consumers qualify for a Chapter 7. It's just a straight liquidation of debt and non-exempt assets. Most of my consumer clients don't have non-exempt assets. It's a very simple form of bankruptcy. I'm going to talk more about it in a few minutes. There's also a Chapter 13, which is, I would say, the next most common. It's a reorganization of family debts. These are really the top two that consumer lawyers deal with. There is Chapter 11, which is a business reorganization. Some very high-end debtors can do that. But that's not appropriate. Hey, Jim. Thanks, Jim. All right. So you're not gonna see a lot of consumers in a Chapter 11. I've never done one. I would send it out to someone if it came my way. And then family farms and fishing operations. That's a separate form of bankruptcy. I was trying to think. I can't remember ever seeing one of these filed. I'm sure they get filed, and maybe I wasn't paying attention, but it's a fairly rare thing, at least in the courts that I practice in. The benefit to your client, one of the big benefits is the automatic stay. And I'm just, if you're not practicing in the bankruptcy area, it's very important to understand what the automatic stay does. It stops all collection activity. The minute that bankruptcy is filed and the judge issues the stay order, which generally happens automatically, all collection activity comes under the jurisdiction of the bankruptcy court. This means that all foreclosures, including foreclosure sales that haven't been completed, stop. The repossession stop. The creditor no longer has the right to repossess without leave of the court. Any debt collection lawsuits stop immediately. They go into the bankruptcy court. And the bankruptcy court enforces this through its contempt powers. Violation of the automatic stay is a serious matter to most bankruptcy judges. They do not have a lot of good humor about creditors who disrespect their orders. It is one of the most important benefits to your client or to the bankruptcy debtor. The court determines who gets paid through the trustees. And this is why the bankruptcy stay is important. It's not just important to our clients, it's important to the creditors, because when you have an overly aggressive creditor, they're going to go in and grab as much money as they can, but that leaves the other creditors not getting paid. So with enforcement of the automatic stay, it makes sure that people get paid, if anybody's getting paid in the case, on a pro rata share basis based upon the claims that they filed. So, so if a creditor wants to get paid after the automatic stay, they have to file a claim in the bankruptcy. There's a whole process whereby which you can contest claims, and there's a trustee who is appointed at this point to take possession of whatever bankruptcy assets there are to pay creditors' claims, and it's the trustee who distributes that money to the creditors based upon their claims, and generally it's a pro rata share basis. Okay, so in most cases with a consumer, we're looking at either a Chapter 7 or Chapter 13, and it's really important that people understand the differences in those. There's some subtle but hugely important differences in these two bankruptcies. The first one being, how long do they last? The Chapter 7 is a very, like I said, direct discharge of all dischargeable debt and a surrender of non-exempt assets. Okay. Again, most consumers don't have much if anything in the way of non-exempt assets. So these cases are generally over in about 6 months. Simple in and out. And it's a great and potent tool for people who are just up to their eyeballs in debt. The Chapter 13 lasts 3 to 5 years, so it's a much longer time period. There are some provisions in which you can take a 13 to a 7, and I guess you can also go the other way. I haven't ever gone from a 7 to a 13. My understanding is a trustee can force that in some circumstances, but it's not something we see much. But here's the difference. This is another thing that's really important. In a Chapter 7, once your client files, they have no right to dismiss that bankruptcy. So, and the thing that I found, what can come up and bite you in the behind on this, is if your client doesn't disclose an asset, and maybe you haven't done the due diligence, so that you're not clear on what their assets are, and that's where a bankruptcy lawyer has to really do a lot of due diligence. And it actually, I'll tell you, we had it come up in one of my cases many years ago, and I learned a very profound lesson. I was able to cure it and take care of it, but I had a client who was not aware that their mother had quit-claimed her house to them. Fortunately, the mother reserved a right to reside in the house until her death. But that, when the mother did that, that became part of the son's bankruptcy estate, and they didn't know anything about it. And at that point, that house that my client's interest was owned by the trustee. We basically had to buy it back from the trustee. If it had been at 13, I would have probably looked at dismissing or doing something else with it. But because we were in a Chapter 7, my client could not dismiss that. So there's no way to fix that other than what we did, which was, like, say, a buyback on it. The Chapter 13, your client always has the right to dismiss that at any time. They can bail on it. And as I said before, in some instances, you can even convert it to a Chapter 13, or I'm sorry, Chapter 7. You can convert and then get the direct discharge. The other difference between a Chapter 7 and a Chapter 13 is there is no plan in a Chapter 7. Right? Your client does not propose any plan of repayment. Whereas in a Chapter 13, that's the central feature of a Chapter 13, is this plan. And basically what happens is you plan a budget for your client, and you take the disposable income after reasonable living expenses, and you pay that money to the trustee who distributes it to the creditors. What's really good about this is that it gives you the ability to cure an arrearage in a mortgage or in car payments. The other thing that can happen in Chapter 13 is you can also strip out some negative equity with second mortgages. There's a lot of rules on that, and with car payments, but you can sometimes do things called cram downs, and your client who's really upside down in a car can sometimes really benefit from a Chapter 13. But in Chapter 7, there's no ability to cure the arrearage. And the other thing I will tell any of you that are doing mortgage foreclosure litigation is that I have really found that the bankruptcy court's mortgage modification program is the most effective one I've seen. The bankruptcy judges really keep an eye on it and don't let the creditors get away with a lot of nonsense, which has been a real problem for me in state courts. Chapter 7, not everybody can file a Chapter 7. It's subject to a test from they created in 2005, the means test. It's in theory, it's if your client is above the median income for their geographic location, they're not subject to they're not eligible for 7. But there's a lot of calculations that you can do that I've gotten people with income significantly above a Chapter 7 into Chapter 7 based upon their household incomes and things like that, and the fact that there's no disposable income. So it's not really that much of a bright line test, but it's something to be aware of. If you've got a very high income client, they may be forced into a Chapter 13. Which honestly for a lot of people makes bankruptcy a much less attractive option for them, and it's understandable. There's no means test applied in a Chapter 13, at least not formally. With the plan, you have to show that your client's basically turning over their disposable income to the bankruptcy trustee, and that's really my presentation. Like I said, I'm just trying to give you guys the 10,000 foot view here. I hope that if you're not practicing bankruptcy, that I've given you some information that'll be helpful, help you understand the process a little bit more, and recognize when you want to send that over to the when you want to send the client to the bankruptcy court. And with that, I will end my screen share if I can find, and I'll open it up to take any questions. What is going on here? Hang on. I got too many screens going, too many different directions. Okay, so any questions about bankruptcy?
David, there's a question. There are a couple questions in the Q&A box, although there's 2 that are landlord-tenant related, but the last one, there is one there. I don't know if you're able to see it. If not, I can just read it out.
Let's see. Bankruptcy question. Can email 101? Okay. Potential client has little income, owns a condo, lives in Florida less than 730. I think in this question, I think probably your client can use the question is client has little income, owns a condo, lived in Florida less than 730 days, acquired the condo in Florida soon after moving. Can she use homestead exemption to protect her home in a Chapter 7 or can she use home state's homestead exemption to protect her home in Chapter 7 or Florida homestead exemption in bankruptcy? I believe so. Look, it's if she comes from a home state that has a great one, you're certainly covered. But I think you'd be able to use the the homestead exemption, Florida's homestead exemption, to protect the condo in Florida. Especially if it's really well established that this is her domicile and she's been here a little while and it's not being used to shield assets. I think where you'd run into problems with that would be as if you had a client who took a bunch of exempt asset money and poured it into a Florida horse farm to try to shield that and then files bankruptcy immediately after. Then I think you're going to have problems. All right. Okay, so Latasha asks, how long does a bankruptcy stay work to delay a foreclosure? Is there a time limit before the foreclosure is released to move forward? Okay, so the bankruptcy stay, even in Chapter 7, the creditor has to request leave of court to move forward and basically to remove the stay to proceed in foreclosure. Understand that they can foreclose, but the bankruptcy court would still have jurisdiction over deficiency issues. So they can't, especially if you've got a Chapter 7 client who discharged a debt, did not reaffirm the mortgage, and then they move to foreclose. They can get the foreclosure, they can get their equitable relief, but they cannot get monetary relief. They can't get deficiency action. So Latasha, I'm hoping that answered your question. All right, and then Latasha has a question. What would a typical course of action for a tenant that effectively abuses a 7-day notice to withhold and essentially costs the landlord monies for repairs that are suspected? Okay, so Latasha said I answered it. I'm looking at this other question. What would be a typical course of action for a tenant? So is a tenant abusing the 7-day notice to withhold? And essentially costing the landlord money for that are suspected to be the result of tenant damage. Well, I think at that point that would be, I don't represent landlords, so I can't really tell you what the landlord's rights are. Well, I guess I can, but I think at that point the landlord would have the right to seek eviction, and then the tenant would raise that it was a legitimate rent withhold, and then the court would have to decide if the tenant was doing as the landlord suspected, deliberately damaging the property and things like that. That's a legitimate basis for an eviction. It's you can't have people pounding holes in your walls and stuff like that. So I think that they have to go forward with an eviction. All right. And then Latasha's got another question on the eviction moratorium. I'm gonna punt on that one and let Robert Churchill answer that at 4 o'clock. So, any other questions about bankruptcy? We're all gonna be back here at 4 o'clock, so we can answer whatever questions anybody has.
Hi, David. This is Cynthia. I can't ask a question for some reason, but I can put in chat. Anyway, I wanted to see if you had any experience with the student loan modification basically program, or if you have any intel on that, or just maybe over. I don't. So how
Okay.
that's going. You mentioned the modification of mortgages, but not the student loan program.
Right. Student loans are like a cancer in the U.S. economy. They are one of the worst things out there. And I can go on and on about how much I hate student loans and how much headache they've even cost me in my own life because they're administered so damn poorly. But there's a general rule in bankruptcy that student loans are not dischargeable except upon showing of undue hardship. And bankruptcy judges, for whatever reason, have these, in my opinion, ridiculous standards for what constitute undue hardship. If you ever got a chance you might ever make money in the future, they won't discharge your student loans. But they will. I have seen where they kind of really keep an eye out and make sure that people can get loan consolidations and the William D. Ford program with the income contingent repayment plans. Those things can sometimes help. Where we've been in private student loans, honestly, I've had clients that I've kept in perpetual Chapter 13s where they're paying the debts, the student loan payments, according to a Chapter 13 plan that gives them an affordable payment. And my hope is that after a while that the judges get tired of seeing these cases filed and recognize that your client's never going to be able to pay that debt off. And just to clear them off the docket, they'll start issuing discharges. I will say I have discharged a number of student loans in bankruptcy, private student loans. And what I've done in most of those, they've been related to trade schools and private education programs, is I've challenged the standing of the institution as a qualified institution, and they never fight, and I've been able to discharge them. So that's what I've used. I've actually gone after the fact that it's not a loan by a qualified educational institution, and but other than that, it's not a great situation, Cynthia. I wish I had better news for you. And I've never used a student loan mediation and modification program in a bankruptcy court.
I haven't used it either yet.
Yeah.
Mr. Abrams, on that point, I've been following the decision from the Southern District of New York and Rosenberg. I believe involved a situation where, for once, it seems, a court did actually find undue hardship. It seems like that's sort of, I don't know if that's the domino that pushes all the others over or if it's an outlier. I realize it's not been fully appealed yet, but the substance of that decision, as I understand it, is that the judge basically said, we've actually been getting it wrong, that the Brunner test and the various metrics, the three-part metric, has just not been interpreted correctly. And in that case, I actually think it was a law student who had gotten his degree. And if I recall the facts correctly, it was a situation where the judge said, I don't really care what his future earnings potential is. And maybe I'm misquoting the case, but I wondered if you had seen any of that trickle down into the Middle District of Florida or Florida at all.
I have not, and I'll be very candid with everyone. The last couple of years, I've not done a lot of bankruptcy law. It really slowed down for my practice a lot about 5 years ago, and so I keep a toe in it. And my bankruptcy cases have really been in the Northern District of Florida, and so I really don't. I can't tell you much about the judges here locally because I just don't have experience with them.
Okay,
but.
Go ahead.
But I'm encouraged to see that maybe the judges are coming around on this, because I will tell you, I have had young people in my office who literally left the country. Just that I'm leaving America. I had one guy who went to law school, had hundreds of thousands of dollars in loans, went to this private law school with private loans, and he flunks the bar one time, and then he can't pass character and fitness for the bar because he's defaulted on his student loans.
Round and round we go.
Yeah, and he's he's just hosed. And so he's like, I have dual citizenship, and I can't remember where it was, but he left. He packed up and he left the country. And I had another client do the same thing. They just and these are native-born Americans who just because of student loan debt feel they see no economic future here in the United States.
I suppose you've probably already answered part of my question if you're not doing anything or much in the Middle District, but I know that the Middle District has a trial program. I think it's first in the nation, the Student Loan Management Program.
Okay.
But it was my understanding that it acts to basically do what already exists, but the idea is essentially to allow debtors to come out of usually Chapter 13. But I don't think there's a prohibition on Chapter 7 petitioners utilizing it either. But I believe it basically takes the student loan modification options that already exist, like income-based repayment or income-driven repayment, and essentially acts as sort of like a clearinghouse. Do you see any of that in the Northern District at all? Or I know you said you're not really doing much with it, but is that something that has sort of come up?
I haven't seen that the program didn't exist in the Northern District, and I just don't have experience with the Middle District. I think it's a really important thing to have, and I'm glad to see the court doing that. I wish I had experience. If anybody does, feel free to chime in. Jared Lee just pointed out that Christy Arkovich in Tampa is very involved with these student loan bankruptcy issues. We do have on Thursdays, we have a consumer lawyer roundtable that we get together and we talk about either practice management or substantive issues of consumer law as a group of lawyers that, by the way, anyone's welcome to come to. And Christy is one of the people that is often comes to that group. Also, Joshua Cohen, who's out of someplace up north, I know that's his entire career has been helping people with student loan issues.
Do you have information on that I guess gathering? Is it a listserv or Zoom meeting or?
It's a weekly Zoom meeting that we have on Thursdays at 1 o'clock. If you shoot me an email, I'll make sure you get notified of it. So, and
have you done any of the new small business Chapter 11 reorganizations that qualify for the reduced? Well, I guess they have to be under what, $3,775,000 or something, and it removes a lot of the bars that normally exist as far as handing over the ability to make plans and things of that sort in a more traditional Chapter 11.
No, I am. I'm a coward when it comes to Chapter 11. I have stayed out of that. That swimming pool, as it were. Where when I was up in Tallahassee, which is really where I've done most of my bankruptcy cases, there were several lawyers that I would refer anything that needed a Chapter 11 over to. So I don't have any experience with Chapter 11s. Maybe I should have learned, because I've heard the fees are pretty high in those Chapter 11s. Yeah. But
David, there's a question in the chat from Michelle, and it says, under what circumstances would a stay be lifted?
Would a bankruptcy stay be listed? Yes. Okay. So the most common time that a bankruptcy stay is lifted has to do with a secured creditor. That's a mortgage company or in consumer cases, it tends to be a mortgage company or like a finance company for a car, where they've got a security interest, collateralized interest. And the stay is lifted for the purpose of the creditor basically foreclosing or repossessing. Again, it's very limited. They're not allowed. It's basically in rem relief only. It's not, well, for the car repossession, they have to get an order. It's in rem relief only. If they want to get paid by the consumer, they have to file a claim in the bankruptcy court after they've sold the collateral. And likewise, with a foreclosure, they want to get paid on any kind of deficiency, they have to come back to the bankruptcy court with a claim and pursue that. But I'll be honest with you, nobody does. And if they, a lot of times what I see more often happening is you'll do a Chapter 7, they'll surrender the house, and then they'll foreclose afterwards. And generally what I'll do is I'll put in a notice of appearance and not objection to foreclosure, but just making sure they don't get any kind of monetary judgment. I will tell you guys though something though, that if you have any clients who have mobile homes, mobile homes are often, you know, your client's been in for 10 years, they've been paying on this mobile home, and if it's attached to land, there's all this stuff about whether or not it's attached to land, but they got a mortgage on it because it's attached to the land rather than just a personal property interest. If you surrender that in a bankruptcy, because they often owe way more than this thing's worth, I have seen time and time again where the creditors just release their liens because they don't want to go foreclose on that mobile home because it's not worth anything to them. It's never a guarantee, but it's actually been kind of a problem for some of my clients who are trying to dump these mobile homes, and the creditors won't foreclose on them. They won't take them back. So do we have questions? All right. Martha, what do you think? We take a break till about 4 o'clock and we get everybody back and people can just fire questions at us?
That sounds good.
Okay. Thank you guys for listening to me, and I'm available if you have any questions on anything or, you know, whatever, or you just want to talk about consumer law, or you want to come to our Thursday afternoon talks. Everybody's welcome. So.
Thank you.
So what I figured we'd do to close this thing out is just let you guys fire questions at the panelists, and anything that you want. You got a lot of depth of experience here with these lawyers in terms of any consumer law matter, stuff that we didn't even talk about. If you've got a consumer law thing you're struggling with, you know, please feel free to ask away. How often do you get to pick a lawyer's brain for free? I do want to take a moment to, in case I neglected anybody, to thank all the presenters today for everything. You guys did a great job, and I really appreciate it. And I think we've given out some really good information. So fire away with your questions, guys. Or something, if you guys don't fire away, if there's something any of the presenters feel like they want to add or discuss that we didn't cover during our presentations, please feel free to speak up.
David, we had some questions in the chat, I'm sorry, in the Q&A session, and one from the chat, but I think those were landlord-tenant related, and I don't see Robert Churchill on, so we may have to defer those unless anybody else feels comfortable taking those on. So I just wanted to point those out to folks.
Okay, well, we can handle those as best we can until Robert gets back, and there may be something we need to bring him in on. But
do you know what I learned since we met, since I last talked? So I always like to have good relations with lawyers I have cases against. Not 100% that way. Some lawyers I just can't stand, and a lot of us share our same feelings about these people. So Sally Mae and the mortgage servicers have been meeting with law firms throughout the state, talking about ramping up foreclosures. And the lawyer told me that, you know, he just had gotten off the phone with one of the larger mortgage servicers, and they're going over what the procedures are going to be to increase foreclosure litigation coming in September. And the prediction is that, and the lawyers has seen this before, and he said, you know, this is what happened before in 2008. So I guess the other side of the coin is that, you know, there's probably these types of discussions with other lawyers on the other side as well. And I have a question. What do the y'all think we should be focusing on that we haven't covered?
Bob, are you asking the panelists or are you asking
Everybody? Anybody, I don't care.
We really have not touched on any mortgage-related issues at all.
We probably should have had either Lynn Drysdale or one of the attorneys that have been. Didn't we have? So we didn't have Jeff Herm on the panel. I actually confused this with something I did on Monday or Tuesday. Yeah, I think we should have had that, but that's something you could spend an entire day on. So we are members, David, Robert, Jared, Cynthia, James. I'm looking at the names here. I may miss somebody. We're all members of the National Association of Consumer Advocates. I served on the board for 6 years, and I was the Florida State Chair for probably 15 until someone wisely asked me to step down. That organization is based out of Washington, D.C. It's the, for lack of better definition, it's a Consumer Lawyers Bar Association nationally. There's a NACA Florida branch, which is the Florida lawyers, which we are all participants of. The membership for NACA is restricted to lawyers that don't represent the interest of businesses that have controversies or litigation or disputes with consumers. So if you represent a bank in a dispute against a consumer, you're disqualified. What's that? Or you represent, Cynthia, you gotta go off mute. Or if you represent a car dealer.
It's my dog. Sorry, I'm meeting.
And there's Robert Churchill's also a member of NACA. Those of you who are members of NACA, including legal services members, you should consider joining. Legal service members can join NACA as part of your office, so you don't have to actually get your own membership, and there's discounts as well. And that's my pitch for NACA.
Okay.
I appreciate you mentioning NACA, Bob, and I think that
well, you're the state chair. What the heck, man? You do it. I'm sorry.
I know. No, I appreciate you mentioning that because I intended to during this time period. The other thing I will mention is for anyone that is engaged in any level of consumer law litigation, the National Consumer Law Center, which is a organization that often partners with NACA, puts together a full set of consumer law manuals. And if you're going to, particularly for the Fair Credit Reporting Act, if you don't have that manual, you should not be filing FCRA cases. It is a tremendous resource for practicing consumer law. The FCRA book might as well be the Bible for FCRA litigation.
It's very hard to find this information anyplace else. Otherwise you're going to be digging through case law for the rest of your life.
And it does a great job systematizing. It does a great job keeping up with the developments. You can get an online subscription and those updates come through. Well worth the investment.
Okay. I'll tell you a question I would ask all the panelists if you want to just make a 2-minute pitch. I know that we have a lot of legal services lawyers here and that they're going to be inundated very quickly, is what the expectation is. A lot of consumer related claims. And so part of the resource that they need to have are good referral sources for consumer lawyers. And maybe if you guys want to go around very quickly and give the 1-minute elevator pitch on what kind of cases you guys would be most interested in looking at, so that they know who to refer and what to refer to, what kind of cases and who to refer them to that you're looking for, that are of interest to your particular practice. And I guess, Robert, Churchill, I'll start with you. I think I kind of know what you're into, but tell us what types of cases do you like to be referred out to?
Thank you, David. Yeah, what I spend most of my time and energy doing, and what my office does, is we do landlord-tenant law, and we all, as I talked about today, but we also do consumer debt defense, what Cynthia O'Donnell was talking about in terms of defending debt buyer lawsuits, and also auto repo deficiency cases, things like that, and a very little bit of consumer bankruptcy. We work mostly Chapter 7s here in North Florida and in Central Florida. So consumer debt defense and landlord tenant.
How about Cynthia O'Donnell?
Yeah, I'm in Mount Dora, Florida, which is, I guess, halfway between Ocala and Orlando. So kind of rural areas, and I do a lot of debt defense. I do consumer bankruptcies. I only do Chapter 7s. Chapter 13s I'll just send out. I don't want to do it. I do some FDCPA work, and then working on expanding a little more, but always consumer debt. That's basically all I work on.
Okay, very good. How about Jared Lee?
More and more, we are focusing on the Fair Credit Reporting Act as our primary area of practice. Always try to help people in other areas as we can, but we do a lot of FCRA litigation, a lot of situations that involve identity theft, mixed merge files, inaccuracies, objective inaccuracies on the credit report. Do some collection harassment cases under the FDCPA, FCCPA as well, but more and more exclusively FCRA stuff.
Okay. How about Bob Murphy?
What do I do?
What kind of cases would you, for the legal services lawyers who are looking to, to get out from underneath what is expected to be a tidal wave of cases, what kind of cases are you interested in looking at?
I do pretty much anything and everything. I mean, I get bored really easily. Obviously, I do auto-related cases. My office has litigated everything from national class actions against auto manufacturers to, little bitty things. I don't discriminate, and I'm happy what I do. Right now, I'm focusing on trying to challenge some of the really unsavory practices created by fintech corporations. Fintech, for those who don't know what that is companies that are offering platforms, typically, obviously electronically based, but a lot of it's on an app, where they offer loan products ranging from payday loans to auto loans to boat loans to home improvement loans. And the problem with this fintech industry is that none of them have a license to do any sort of lending in Florida, and they're operating on the fringe of the regulators. And the Credit Service Organizations Act, which Florida, along with other states, have adopted, requires transparency in the fees. And transparency means just that. They have to disclose what their fees are. The first couple of cases we did, we were challenging arrangers of loans involving auto loans. And these are meaningful cases because the consumers are oftentimes paying as much for auto loan refinance. In the cases we finished in Maryland, they were paying about $1,200 to get a loan refinanced through this loan arranger. I'm finishing a boat loan arranger case now. And when you get that type of recovery, we're usually getting 100% recovery in these cases. And that's one of the things I ask people to look for. If I don't know if I can't do it, I know people that can do these cases. That's because we know pretty much everybody in the state. and we meet new people all the time. I think I met Cynthia last year at this type of function through Mid-Florida Legal and others at the training for legal services. I think you were on one of the panels, and I've known Jarrett since Jesus walked the earth, and David, I've known you since Moses walked the earth. So
all right, Jim Turner, what kind of cases can legal services lawyers look to you to have an interest in? Thank you, Bob.
Am I unmuted? Am I unmuted? Am I okay?
You are unmuted, but there's no you here. We just have your name. We're missing your shining face. Hello?
That's all right. I can't get it.
Yeah.
See camera. Start my video. Okay.
There you go.
Okay. You know, I find that if I get credit card lawsuits, people who are having trouble with credit cards, usually they got other problems. And so I have mechanized my practice that I can do credit card lawsuits very efficiently and very inexpensively for the consumer. So I would say if you were going to send me anything, send me a credit card lawsuit defense case, because I think that from that, I get more from that than I get from bankruptcy. So.
All right, very good. And I'm David Abrams. I'm here in Orlando, but I'll pretty much go anywhere in the state for a good landlord-tenant class action or FDCPA class action, things like that. I very much enjoy doing class litigation and partnering with other lawyers to do that. And so if you need someone with some class experience, I'm more than happy to work with you. Heck, I'll work with you on an individual case, or or if you got something that you think is interesting. I'm always open and ready to listen. I very much enjoy working with legal services lawyers. By the way, we should recognize Robert Churchill was the pro bono leader for the Second Judicial Circuit this past year. Got the award for helping legal services folks.
Thank you. I forgot to mention it. I meant to highlight that somehow, but somehow it slipped through the cracks on me. Thank you, David.
Yes. So.
And equally, David, for the Florida Bar's Consumer Lawyer of the Year.
That's what I'm told. Yes, that was a nice call. Yes.
Congratulations on that. Well deserved.
Thank you so much. So, do we have any questions from anybody? If we don't, we can call it a day and go enjoy our weekend. Unless the panelists have something else, but I think we're pretty much.
We have some questions in the Q&A box.
In the Q&A box, okay.
Yep. And I believe that there was one in the chat that one of our attendees couldn't post earlier, so I posted it for her. I'm just scrolling through. And that question was, so landlords are not, it's a landlord question, a landlord tenant question. So landlords are not required to return the security deposit to a month-to-month tenant only if they have a lease and have provided written notice within 7 days via certified mail of vacating the premises. And that came from Michelle. So Michelle, I don't know if you're still on and if you just wanted to clarify that if needed.
Yeah, I'm still here. Hi. My question was, I think it was probably not well written, but I was trying to type it very quickly and take notes. But the question I had was earlier, Mr. Churchill, you stated that, or I thought you stated, and I just wanted to clarify, that there's no affirmative notice requirement for the return of the security deposit for individuals who have a month-to-month tenancy as there is imposed upon landlords with tenants who've had a year lease. Did I hear that correctly?
Yeah, what I would add to that is there's no automatic requirement. So you can, the automatic requirement on landlords for doing a security deposit notice is for tenants who vacate on time, like right when they should at the end of a lease, or the tenant can, or if the tenant does a certified mail notice at least 10, I use 10 days, but I think it's a week prior to vacating about where their forwarding address will be. So there's basically a lower threshold. I want to make sure I'm answering your question. There's a lower threshold that a landlord has to meet to make a claim on a security deposit if you're month to month, or if you stayed over or left early, or if you did anything other than leave right on time, unless you do the certified mail notice that puts the heightened burden back on the landlord to do the notices. So a landlord still has, under the statute, the landlord still has an obligation to basically to make an assessment and to spend the security deposit appropriately. The problem is that without the notice requirement, that just becomes a big factual he said, she said dispute where they're going to say everything was destroyed and no, we don't have to show you anything, which is in fact correct. I mean, the practicalities of enforcing it without the notice are insurmountable as a practical matter.
Okay, that makes sense. Thank you.
Mm-hmm.
Robert, there were a couple of other questions in the Q&A box. One was regarding the eviction moratorium, regarding and I'll just read this out. It is my understanding that a 3-day notice is still permissible, but just the enforcement is not. Is that the case, or does the moratorium also exempt landlords from taking any action to enforce rent obligation?
The moratorium is the moratorium. Well, it depends. The moratorium and the CARES Act, or one or both of them, prohibit landlords from asking for rent in any form. But the rent obligation continues, which means when the moratorium ends and the CARE Act and the CARE Act timeline ends at the end of this month, there's going to be a lot of money owed by a lot of people who, if they've not been paying, suddenly, and then everything ramps up. So, which is why there's going to be a coming flood of landlord-tenant issues. But so I have at request, I've sent the materials that I referred to in reference to the CARES Act stuff from the prior CLE that I did, probably to 10 different people. If you're not one of those people who's asked the question, then just shoot me an email and I will send you this stuff, because that's all in the PowerPoint that I've emailed out.
Robert, I have a follow-up if I can on that. So I wondered, because I see that there are evictions being filed, landlord, like based on payment. Not, some are saying no payment requested, so they're trying to evict for whatever breach of whatever, which is authorized under the CARES Act, as I understand. But if they're issuing a notice to vacate, or the 3-day notice, whatever it is, and then that's a precondition to filing a lawsuit to evict, is that just not valid? And when this is lifted is why I'm worried about it. Would it be possible to just move to dismiss, or how do we handle all of these cases that have been being filed for months now?
That's what I would do. Yeah, if there's an effective moratorium on your asking for rent in July, and you're premising an eviction-based lawsuit filed in even if the moratorium is lifted, if they file it in August, but they're trying to premise the claim on a 3-day notice done in July during the moratorium, I'd be moving to dismiss that case.
So you would say it's an invalid notice?
Right.
Because it was issued during the moratorium. In the moratorium, I mean, it could be extended. It was extended June 30th,
twice,
or July
yeah.
30th this time. Yeah, we'll see. Okay, thanks for letting me know that, because I was concerned. I see these eviction actions and don't know what the plan is. And they're not getting dismissed, as I understand. They're just kind of hanging out. My dogs might bark again. I mean,
Yeah,
they're
I
just
think
on the
what the
docket.
courts have done is a lot of courts have just said, well, we're going to process these things through, but we're not going to issue a writ of
Right.
possession. And
But
that,
people are moving out based on those notices. I mean, I would assume if I got a notice, like, get out, then I might be moving.
right.
I might be calling legal aid.
Yeah, so, which that maybe, I expect that is actionable in and of itself. You could find a claim for doing a legally invalid notice that basically puts somebody in a position where is misleading, as Mr. Turner would tell us. The suggestion that they have to get out or pay rent, and as much as a rent demand is legally invalid and probably actionable.
I wondered that too, so thanks. So that might be an FDCPA violation if they're if they're actually relying on those notices and moving out.
Correct.
It looks like there's a follow-up bankruptcy question about the exemption. Is that correct? It says anonymous attendee. Is that the one that you answered earlier, or are we done with that one? I think it's new though, because it's 418.
Yeah, it's a question about the domicile issue that I raised and looking at it, and based on previous senators, well, it may or may not apply. Would not be a better answer that you add that to your list of time when you. Yeah, I mean, what I really wanted to do in the slide and in the presentation is just make lawyers aware that that the amount of time your client's been domiciled in Florida can have an impact on the exemptions that they can claim. The intricacies of that, I think, can get kind of complex at times. So, would it be an answer that at times you would want to? Yeah, I would agree. Yeah, it's something you want to consider when you're looking at filing. You want to research that issue and the specifics of your client's situation and what exemptions they can apply, especially homestead stuff. So I absolutely think that it's something that you should be looking at.
I filed a few of these recently, well, over the last couple of years, and I'm about to file another one. It depends on the state they're coming from. Is when they don't qualify for Florida exemptions, then you look to the state they're coming from. And then you get to look to see if under their exemption laws, so you get to be an expert on Nevada and Arizona and wherever law they're coming from. I can tell you that Arizona and Virginia do not allow people to qualify for homestead exemption if they're not domiciled in those states. So when that happens, if it's one of those states, and also if it's any other state that you want to research, but those two I know, then you want to file federal exemptions. And depending on the equity in the condo, in this circumstance, the federal exemptions might be better. That actually, I mean, Florida has great homestead exemption, but a lot of other exemptions, the federal is better. So if there's not a lot of equity in this condo, then you get a huge wild card exception in federal. So if you can, I mean, not like Florida, and you don't get wild card in Florida. Anyway, it gets really weedsy, but get into the exemptions for that state, and that's what decides your timing. If Florida's better, then you wait. If Florida's not better and federal's better, then it's actually always benefited my clients that I filed before they get domiciled in Florida, because the federal exemptions are usually better for really poor people who have a homestead.
Good answer, Cynthia. Very good.
I see we also have a question in the question answer box regarding whether there are FDCPA, FCCPA claims against landlords filing evictions during moratoriums. And I know we
saw
have a
that.
number
I
of people that
answered
can
that.
speak to that.
I answered that by typing, but I'll answer it again because it's a good question. Certainly, if the landlord is trying to collect, if the landlord files an eviction during the moratorium, that could be an FCCPA violation. What I'm concerned about is the definition of a communication. Certainly, a written letter saying I'm going to evict you unless you pay the rent during the moratorium, that would be a that would be a communication. But, you know, the eviction, I say that with reservation, so I'd like to study that.
Jim,
You
what would
have
your
any
thoughts
thoughts,
be on
Jared?
the interaction of the litigation privilege with the FCCPA claim there?
The litigation privilege, that's a good point. That's certainly a good point. I'd have to think about it. I don't have an answer that I can give you off the top of my head.
Is a notice that's sent prior to, as a precondition to litigation?
I don't think the notice is protected, but I won't say that I've researched that issue recently.
I might be researching that today because I'm sure that that's a problem. And that's the main communication. They're posting that to the door, aren't they? Normally mailing it at least.
Well,
Sure.
I have a question for you guys. When the notice comes from a property manager, of course we have an FCCPA claim against the landlord and the property manager because they're collecting a debt. You know, the Florida statute says no person shall, but the FDCPA only applies to debt collectors. Are the property managers to whom the debt is not technically owed, are they subject to FDCPA liability because their job is to collect rent?
Rarely. I run into this with HOA issues all the time. I hate HOAs, by the way. I'm sorry if any of the attendees are property management attorneys, but they always think they're right and they're communicating all the time. When you see the property management company, and they have litigated this extensively with regards to FCCPA, that they're not, usually FCCPA and FDCPA as well, that is definitely not their regular course of practice to be collecting debts. They're collecting things that are current. So at the point where so it's not the regular practice. You might still get it on the, what is the other prong of the FDCPA? All people who know the FDCPA better, for debt collector.
After default.
Right, so it's after default, then that's it. But a lot of things are gonna be, they're gonna fight that they're debt collectors.
Yeah, I could see that being a fight. I just wondered if anybody had any success with that.
My opinion is they're not debt collectors.
Okay.
The property manager is not a debt collector.
All right. Yeah, because I mean, technically, they're the owner's agent. Well, I don't. Yeah, probably. Okay.
I haven't seen it litigated and definitely haven't litigated it, but think that frequently it would be. I think it would be comparable to like a billing company. You know, before a bill goes into default, that generally hasn't been found to be a debt collector.
All right. Do we have any?
David, I have to run. I got to pick up my dog at the vet.
That's okay.
Have a good weekend, everyone. Thanks for participating.
We're at the end of time anyhow, so thank you guys for everything today. So, any last statements before we all head off to our weekend, guys?
Thank you, David.
Yeah, thank you, David and Martha, for everything you guys did to put this together.
Thank you so much for doing it, guys. You guys are the best.
Thank you for that too.
All right.
Have a good one.
Great.
Bye. Happy
Thanks for
weekend.
coming, everyone.
Take care.
Thank
Bye,
you,
guys.
everybody.